Section 1 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Part 1 of the Law of Nations. Lecture 1 of the Foundation and History of the Law of Nations. When the United States ceased to be a part of the British Empire and assumed the character of an independent nation, they became subject to that system of rules which reason, morality, and custom had established among the civilized nations of Europe as their public law. During the War of the American Revolution, Congress claimed cognizance of all matters arising upon the law of nations, and they professed obedience to that law, quote, according to the general usages of Europe. By this law we are to understand that code of public instruction which defines the rights and prescribes the duties of nations in their intercourse with each other. The faithful observance of this law is essential to national character and to the happiness of mankind. According to the observation of Montesquieu, it is founded upon the principle that different nations ought to do each other as much good in peace and as little harm in war as possible without injury to their true interests. But as the precepts of this code are not defined in every case with perfect precision, and as nations have no common civil tribunal to resort to for the interpretation and execution of this law, it is often very difficult to ascertain, to the satisfaction of the parties concerned, its precise injunctions and extent, and a still greater difficulty is the want of adequate pacific means to secure obedience to its dictates. Natural and positive law of nations. There has been a difference of opinion among writers concerning the foundation of the law of nations. It has been considered by some as a mere system of positive institutions, founded upon consent and usage, while others have insisted that it was essentially the same as the law of nature, applied to the conduct of nations in the character of moral persons, susceptible of obligations and laws. We are not to adopt either of these theories as exclusively true. The most useful and practical part of the law of nations is, no doubt, instituted or positive law, founded on usage, consent, and agreement. But it would be improper to separate this law entirely from natural jurisprudence, and not to consider it as deriving much of its force and dignity from the same principles of right reason, the same views of the nature and constitution of man, and the same sanction of divine revelation as those from which the science of morality is deduced. There is a natural and a positive law of nations. By the former, every state in its relations with other states is bound to conduct itself with justice, good faith, and benevolence, and this application of the law of nature has been called by Vattel the necessary law of nations, because nations are bound by the law of nature to observe it. And it is termed by others the internal law of nations, because it is obligatory upon them in point of conscience. Moral obligation of states. We ought not, therefore, to separate the science of public law from that of ethics, nor encourage the dangerous suggestion that governments are not so strictly bound by the obligations of truth, justice, and humanity in relation to other powers, as they are in the management of their own local concerns. States, or bodies politic, are to be considered as moral persons, having a public will, capable and free to do right and wrong, inasmuch as they are collections of individuals, each of whom carries with him into the service of the community the same binding law of morality and religion which ought to control his conduct in private life. The law of nations is a complex system, composed of various ingredients. It consists of general principles of right and justice, equally suitable to the government of individuals in a state of natural equality and to the relations and conduct of nations, of a collection of usages and customs, the growth of civilization and commerce, and of a code of conventional or positive law. In the absence of these latter regulations, the intercourse and conduct of nations are to be governed by principles fairly to be deduced from the rights and duties of nations, and the nature of moral obligation. And we have the authority of the lawyers of antiquity, and of some of the first masters in the modern school of public law, for placing the moral obligation of nations and of individuals on similar grounds, and for considering individual and national morality as parts of one and the same science. The law of nations, so far as it is founded on the principles of natural law, is equally binding in every age, and upon all mankind. But the Christian nations of Europe, and their descendants on this side of the Atlantic, by the vast superiority of their attainments in arts and science and commerce, as well as in policy and government, and above all by the brighter light, the more certain truths, and the more definite sanction which Christianity has communicated to the ethical jurisprudence of the ancients, have established a law of nations peculiar to themselves. They form together a community of nations, united by religion, manners, morals, humanity, and science, and united also by the mutual advantages of commercial intercourse, by the habit of forming alliances and treaties with each other, of interchanging ambassadors, and of studying and recognizing the same writers and systems of public law. After devoting the present lecture to a cursory view of the history of the law of nations, I shall enter upon the examination of the European and American code of international law, and endeavor to collect, with accuracy, its leading principles, and to discuss its practical details. Law of Nations in Ancient Greece. The law of nations, as understood by the European world and by us, is the offspring of modern times. The most refined states among the ancients seem to have had no conception of the moral obligations of justice and humanity between nations, and there was no such thing in existence as the science of international law. They regarded strangers and enemies as nearly synonymous, and considered foreign persons and property as lawful prize. Their laws of war and peace were barbarous and deplorable. So little were mankind accustomed to regard the rights of persons or property, or to perceive the value and beauty of public order, that in the most enlightened ages of the Grecian republics piracy was regarded as an honorable employment. There were powerful Grecian states that avowed the practice of piracy, and the fleets of Athens, the best disciplined and most respectable naval force in all antiquity, were exceedingly addicted to piratical excursions. It was the received opinion that Greeks, even as between their own cities and states, were bound to no duties, nor by any moral law, without compact, and that prisoners taken in war had no rights, and might lawfully be put to death or sold into perpetual slavery with their wives and children. There were, however, many feeble efforts, and some successful examples to be met with in Grecian history in favor of national justice. The object of the Amphictyonic Council was to institute a law of nations among the Greeks, and settle contests between Grecian states by a pacific adjustment. It was also a law of nations among them, and one which was very religiously observed, to allow to the vanquished the privilege of burying their own dead, and to grant the requisite truce for that purpose. Some of the states had public ministers resident at the courts of others, and there were some distinguished instances of great humanity shown to prisoners of war. During a cessation of arms in the course of the Peloponnesian War, Athens and Sparta agreed to an exchange or mutual surrender of prisoners. The sound judgment and profound reflections of Aristotle naturally raised his sense of right above the atrocious maxims and practices of his age, and he perceived the injustice of that doctrine of Grecian policy, that by the laws of war the vanquished became the absolute property of the victor. Wise men, he observed, entertained different opinions upon that subject. Some considered superiority as a proof of virtue because it is its natural effect, and they asserted it to be just that the victors should be masters of the vanquished, whilst others denied the force of the argument, and maintained that nothing could be truly just which was inconsistent with humanity. He then proceeded to weaken by argument the false foundations on which the law of slavery, by means of capture in war, was established, and though he does not write on the subject very distinctly or forcibly, it seems to be quite apparent that his convictions were against the law. In ancient Rome. The Romans exhibited much stronger proofs than the Greeks of the influence of regular law, and there was a marked difference between those nations in their intercourse with foreign powers. It was a principle of the Roman government that none but a sworn soldier could lawfully fight the enemy, and in many instances the Romans showed that they excelled the Greeks, by the observance of better principles in their relations with other nations. The institution of a college of heralds, or priests, charged with the official law relating to declarations of war and treaties of peace, was evidence of a people considerably advanced in the cultivation of the law of nations as a science. And yet, with what little attention they were accustomed to listen to the voice of justice and humanity, appears but too plainly in their haughty triumphs, their cunning interpretation of treaties, their continual violation of justice, their cruel rules of war, and the whole series of their wonderful successes in the steady progress of the conquest of the world. The perusal of Livy's magnificent history of the rise and progress of the Roman power excites our constant admiration of the vigor, the skill, the valor, and the fortitude of the Roman people. Yet, notwithstanding the splendor of the story and the attractive simplicity of the writer, no reader of taste and principle can well avoid feeling a thorough detestation of the fierce spirit of conquest which it displays, and of the barbarous international law and customs of the ancients. A purer system of public morals was cultivated and insensibly gained ground in the Roman state. The cruelties of Marius in the Jugurthan War, when he put part of the inhabitants of a Numidian town to the sword and sold the rest for slaves, were declared by Sallust to be a proceeding contra jus belli. At the zenith of the Roman power, the enlarged and philosophical mind of Cicero was struck with extreme disgust at the excesses in which his countrymen indulged their military spirit. He justly discerned that mankind were not intended, by the law and constitution of their nature as rational and social beings, to live in eternal enmity with each other, and he recommends in one of the most beautiful and perfect ethical codes to be met with among the remains of the ancients, the virtues of humanity, liberality, and justice towards other people, as being founded in the universal law of nature. Their ancestors, he observed, applied the term enemy to that man whom they regarded merely as a foreigner, and to deny to strangers the use and protection of the city would be inhuman. To overturn justice by plundering others tended to destroy civil society as well as violate the law of nature and the institutions of heaven. And by some of the most happy illustrations and pathetic examples, Cicero vindicated the truth and inculcated the value of the precept that nothing was truly useful which was not honest. In the latter ages of the Roman Empire, when their municipal law became highly cultivated and adorned by philosophy and science, the law of nations was recognized as part of the natural reason of mankind. Quod vero naturalis ratio inter omnes homines constituit, id apud omnes gentes peroque custoditur, vocetur que jus gentium, quasi quo jure omnes gentes utantur. The Roman law was destined to obtain the honorable distinction of becoming a national guide to future ages, and to be appealed to by modern tribunals and writers in cases in which usage and positive law are silent, as one authoritative evidence of the decisions of the law of nations. It must be admitted, however, that the sages from whose works the Pandects were compiled speak very indistinctly and imperfectly on the subject of national law. They must be read with much discrimination, as Grotius observed, for they often call that the law of nations which prevailed, and perhaps by casual consent, among some nations only, and many things which belonged to the law of nations they treated indiscriminately with matters of mere municipal law. The Roman jurisprudence, in its most cultivated state, was a very imperfect transcript of the precepts of natural justice on the subject of national duty. It retained strong traces of ancient rudeness, from the want of the Christian system of morals and the civilizing restraints of commerce. We find the barbarous doctrine still asserted that prisoners of war become slaves jure gentium, and even in respect to foreign nations with whom the Romans were at peace, but had no particular alliance, it is laid down in the Digest that whoever passed from one country to the other became immediately a slave. Nam si cum gente
aliqua neque amicitiam, neque hospitium, neque foedus amicitiae causa factum habemus, hi hostes quidem non sunt, quod autem ex nostro ad eos pervenit, illorum fit, et liber homo noster ab eis captus servus fit, eorum. Idemque est si ab illis ad nos aliquid perveniat. It is impossible to conceive of a rule of national law more directly calculated to destroy all commercial intercourse and to maintain eternal enmity between nations. The eruption of the northern tribes of Scythia and Germany overturned all that was gained by the Roman law, annihilated every restraint and all sense of national obligation, and civil society relapsed into the violence and confusion of the barbarous ages. Law of Nations in the Middle Ages. Mankind seemed to be doomed to live once more in constant distrust or hostility, and to regard a stranger and an enemy as almost the same. Piracy, rapine, and ferocious warfare deformed the annals of Europe. The manners of nations were barbarous, and their maxims of war cruel. Slavery was considered as a lawful consequence of captivity. Mr. Barrington has indeed cited the laws of the Visigoths, Saxons, Sicilians, and Bavarians as restraining by the severest penalties the plunder of shipwrecked goods and the abuse of shipwrecked seamen, and as extending the rights of hospitality to strangers. But notwithstanding a few efforts of this kind to introduce order and justice, and though municipal law had undergone great improvement, the law of nations remained in the rudest and most uncultivated state down to the period of the 16th century. In many instances, shipwrecked strangers were made prisoners and sold as slaves, without exciting any complaint or offending any public sense of justice. Numerous cases occurred of acts of the greatest perfidy and cruelty towards strangers and enemies. Prisoners were put to death for their gallantry and brave defense in war. There was no reliance upon the word and honor of men in power. Reprisals and private war were in constant activity. Instances were frequent of the violation of embassies, of the murder of hostages, the imprisonment of guests, and the killing of heralds. The victor in war had his option in dealing with his prisoners, either to put them to death or reduce them to slavery, or exact an exorbitant ransom for their deliverance. So late as the time of Cardinal Richelieu, it was held to be the right of all nations to arrest strangers who came into the country without a safe conduct. The Emperor Charlemagne made distinguished efforts to improve the condition of Europe by the introduction of order and the propagation of Christianity, and we have cheering examples during the darkness of the Middle Ages of some recognition of public law by means of alliances, and the submission of disputes to the arbitrament of a neutral power. Mr. Ward enumerates 5 institutions existing about the period of the 11th century, which made a deep impression upon Europe, and contributed in a very essential degree to improve the law of nations. These institutions were the feudal system, the concurrence of Europe in one form of religious worship and government, the establishment of chivalry, the negotiations and treaties forming the conventional law of Europe, and the settlement of a scale of political rank and precedency. Influence of Christianity. Of all these causes of reformation, the most weight is to be attributed to the intimate alliance of the great powers as one Christian community. The influence of Christianity was very efficient towards the introduction of a better and more enlightened sense of right and justice among the governments of Europe. It taught the duty of benevolence to strangers, of humanity to the vanquished, of the obligation of good faith, and of the sin of murder, revenge, and rapacity. The history of Europe, during the early periods of modern history, abounds with interesting and strong cases to show the authority of the Church over turbulent princes and fierce warriors, and the effect of that authority in ameliorating manners, checking violence, and introducing a system of morals which inculcated peace, moderation, and justice. The Church had its councils, or convocations of the clergy, which formed the nations professing Christianity into a connection resembling a federal alliance. And those councils sometimes settled the titles and claims of princes, and regulated the temporal affairs of the Christian powers. The confederacy of the Christian nations was bound together by a sense of common duty and interest in respect to the rest of mankind. It became a general principle of belief and action that it was not only a right, but a duty, to reduce to obedience, for the sake of conversion, every people who professed a religious faith different from their own. To make war upon infidels was, for many ages, a conspicuous part of European public law, and this gross perversion of the doctrines and spirit of Christianity had at least one propitious effect upon the Christian powers, inasmuch as it led to the cultivation of peace and union between them, and to a more free and civilized intercourse. The notion that it was lawful to invade and subdue Mohammedan and pagan countries continued very long to sway the minds of men, and it was not till after the age of Grotius and Bacon that this error was entirely eradicated. Lord Coke held that an alliance for mutual defense was unlawful between Christians and Turks, and Grotius was very cautious as to the admission of the lawfulness of alliances with infidels, and he had no doubt that all Christian nations were bound to assist one another against the attacks of infidels. Even Lord Bacon thought it a matter of so much doubt as to propound it seriously as a question, whether a war with infidels was not first in order of dignity, and to be preferred to all other just temporal quarrels, and whether a war with infidels might not be undertaken merely for the propagation of the Christian faith without other cause of hostility. End of section 1. Section 2 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Part 1 of the Law of Nations. Lecture 1. Of the Foundations and History of the Law of Nations. Of Chivalry. The influence of chivalry was beneficial upon the laws of war. It introduced declaration of war by herald, and to attack an enemy by surprise was deemed cowardly and dishonorable. It dictated humane treatment to the vanquished, courtesy to enemies, and the virtues of fidelity, honor, and magnanimity in every species of warfare. Of the civil law. The introduction and study of the civil law must also have contributed largely to more correct and liberal views of the rights and duties of nations. It was impossible that such a refined and wise system of municipal and ethical jurisprudence as the Roman law could have been taught in universities and schools and illustrated by a succession of eminent civilians who were worthy of being associated with the Roman sages, without at the same time producing a great effect upon the public mind. This grand monument of the embodied wisdom of the ancients, when once known and examined, must have reflected a broad stream of light upon the feudal institutions and the public councils of the European nations. We accordingly find that the rules of the civil law were applied to the government of national rights, and they have contributed very materially to the erection of the modern international law of Europe. From the 13th to the 16th century, all controversies between nations were adjudged by the rules of the civil law. Of treaties. Treaties, conventions, and commercial associations had a still more direct and visible influence in the formation of the great modern code of public law. They gave a new character to the law of nations and rendered it more and more of a positive or instituted code. Commercial ordinances and conventions contributed greatly to improve and refine public law and the intercourse of nations by protecting the persons and property of merchants in cases of shipwreck and against piracy, and against seizure and arrest upon the breaking out of war. Auxiliary treaties were tolerated, by which one nation was allowed to be an enemy to a certain extent only. Thus, if, in time of peace, a defensive treaty had been made between one of the parties to a subsequent war and a third power, by which a certain number of troops were to be furnished in case of war, a compliance with this engagement implicated the auxiliary as a party to the war only so far as her contingent was concerned. The nations of Europe had advanced to this extent in diplomatic science as early as the beginning of the 13th century, and such a refinement was totally unknown to the ancients. Treaties of subsidy showed also the progress of the law of nations. The troops of one nation, to a definite extent, could be hired for the service of one of the belligerents, without affording ground for hostility with the community which supplied the specific aid. The rights of commerce began to be regarded as under the protection of the law of nations, and Queen Elizabeth complained of the Spaniards that they had prohibited commerce in the Indian seas contrary to that law. Law concerning shipwrecks. The efforts that were made upon the revival of commerce to suppress piracy and protect shipwrecked property show a returning sense of the value and of the obligations of national justice. The case of shipwrecks may be cited and dwelt upon for a moment as a particular and strong instance of the feeble beginnings, the slow and interrupted progress, and final and triumphant success of the principles of public right. Vallon imputes the barbarous custom of plundering shipwrecked property not merely to the ordinary cupidity for gain, but to a more particular and peculiar cause. The earliest navigators were almost all pirates, and the inhabitants of the coasts were constantly armed against their depredations, and whenever they had the misfortune to be shipwrecked, they were pursued with a vindictive spirit, and deemed just objects of punishment. The practice of plundering shipwrecks has been traced to the Rhodians, and from them it passed to the Romans, and the efforts to restrain it were very feeble and gradual and mixed with much positive injustice. The goods cast ashore first belonged to the fortunate occupant, and then they were considered as belonging to the state. This change from private to public appropriation of the property rendered a returning sense of right and duty more natural and easy. The emperors Hadrian and Antoninus had the honor of having first renounced the claim to shipwrecked property in favor of the rightful owner. But the inhuman customs on this subject were too deeply rooted to be eradicated by the wisdom and vigilance of the Roman lawgivers. The laws in favor of the unfortunate were disregarded by succeeding emperors, and when the empire itself was overturned by the northern barbarians, the laws of humanity were swept away in the tempest, and the continual depredations of the Saxons and Normans induced the inhabitants of the western coast of Europe to treat all navigators, who were thrown by the perils of the sea upon their shores, as pirates, and to punish them as such, without inquiry or discrimination. The Emperor Andronicus Comnenus, who reigned at Constantinople in 1183, made great efforts to repress this inhuman practice. His edict was worthy of the highest praise, but it ceased to be put in execution after his death. Pillage had become an inveterate moral pestilence. It required something more effectual than papal bulls and the excommunication of the Church to stop the evil. The revival of commerce, and with it a sense of the value of order, commercial ordinances, particular conventions and treaties between sovereigns, contributed gradually to suppress this criminal practice by rendering the regulations on that subject a branch of the public law of nations. Vallon says it was reserved to the ordinances of Louis XIV to put the finishing stroke toward the execution of this species of piracy by declaring that shipwrecked persons and property were placed under the special protection and safeguard of the crown, and the punishment of death without hope of pardon was pronounced against the guilty. Treatment of prisoners. The progress of moderation and humanity in the treatment of prisoners is to be imputed to the influence of Christianity and of conventional law, establishing a general and indiscriminate exchange of prisoners rank for rank, and giving protection to cartel ships for that purpose. It is a practice of no very ancient introduction among the states of Europe, and it was not of very familiar use in the age of Grotius, and it succeeded the elder practice of ransom. From the extracts which Dr. Robinson gives from Bellis, who was a judge or assessor in the armies of Charles V and Philip II, he concludes that no practice so general and so favorable to the conduct of prisoners as a public exchange in time of war was known in the 16th century. The private interest of the captor in his prisoner, and his right to claim ransom money, continued through that period, and the practice of ransom, founded on the right of property claimed by the captor, succeeded to the Greek and Roman practice of killing prisoners or selling them as slaves. Admission of ambassadors. The custom of admitting resident ministers at each sovereign's court was another important improvement in the security and facility of national intercourse, and this led to the settlement of a great question, which was very frequently discussed in the 15th and 16th centuries, concerning the inviolability of ambassadors. It became at last to be a definitive principle of public law that ambassadors were exempted from all local jurisdiction, civil and criminal, though Lord Coke considered the law in his day to be that if an ambassador committed any crime which was not merely malum prohibitum, he lost his privilege and dignity as an ambassador and might be punished as any other private alien, and that he was even bound to answer civilly for his contracts that were good jure gentium. Grotius. Thus stood the law of nations at the age of Grotius. It had been rescued to a very considerable extent from the cruel usages and practices of the barbarians. It had been restored to some degree of science and civility by the influence of Christianity and the study of the Roman law, and the spirit of commerce. It had grown in value and efficacy from the intimate connection and constant intercourse of the modern nations of Europe, who were derived from a common origin and were governed by similar institutions, manners, laws, and religion. But it was still in a state of extreme disorder, and its principles were little known and less observed. It consisted of a series of undigested precedents without order or authority. Grotius has therefore been justly considered as the father of the law of nations. He arose like a splendid luminary, dispelling darkness and confusion, and imparting light and security to the intercourse of nations. It has been said by Barbariac that Lord Bacon's works first suggested to Grotius the idea of reducing the law of nations to the certainty and precision of a regular science. Grotius has himself fully explained the reasons which led him to undertake his necessary and most useful and immortal work. He found the sentiment universally prevalent, not only among the vulgar, but among men of reputed wisdom and learning, that war was a stranger to all justice, and that no commonwealth could be governed without injustice. The saying of Euphemus in Thucydides he perceived to be in almost everyone's mouth, that nothing which was useful was unjust. Many persons who were friends to justice in private life made no account of it in a whole nation, and did not consider it as applicable to rulers. He perceived a horrible licentiousness and cruelty in war throughout the Christian world, of which barbarians might be ashamed. When men took up arms, there was no longer any reverence for law, either human or divine, and it seemed as if some malignant fury was sent forth into the world with a general license for the commission of all manner of wickedness and crime. The object of Grotius was to correct these false theories and pernicious maxims by showing a community of sentiment among the wise and learned of all nations and ages in favor of the natural law of morality. He likewise undertook to show that justice was of perpetual obligation and essential to the well-being of every society, and that the great commonwealth of nations stood in need of law and the observance of faith and the practice of justice. His object was to digest in one systematic code the principles of public right, and to supply authorities for almost every case in the conduct of nations. And he had the honor of reducing the law of nations to a system, and of producing a work which has been resorted to as the standard of authority in every succeeding age. The more it is studied, the more will our admiration be excited at the consummate execution of the plan, and the genius and erudition of the author. There was no system of the kind extant that had been produced by the ancient philosophers of Greece or by the primitive Christians. The work of Aristotle on the rights of war, and the writings of the Romans on their official law had not survived the wreck of ancient literature, and the treaties of some learned moderns on public law were most imperfect and exceedingly defective in illustrations from history, and in omitting to place their decisions upon the true foundations of equity and justice. Grotius therefore went purposely into the details of history and the usages of nations, and he resorted to the works of philosophers, historians, orators, poets, civilians, and divines, for the materials out of which the science of public morality should be formed, proceeding on the principle that when many men, at different times and places, unanimously affirmed the same thing for truth, it ought to be ascribed to some universal cause. His unsparing citation of authorities, in support of what the present age may consider very plain and undisputed truths, has been censured by many persons as detracting from the value of the work. On the other hand, the support that he gave to those truths by the concurrent testimony of all nations and ages has been justly supposed to contribute to that reverence for the principles of international justice which has since distinguished the European nations. Pufendorf, Martens, Binkerschirk, Vatel. Among the disciples of Grotius, Pufendorf has always held the first rank. His work went more at large into the principles of natural law, and combined the science of ethics with what may be more strictly called the law of nations. It is copious in detail, but of very little practical value in teaching us what the law of nations is at this day. It is rather a treatise on moral philosophy than on international law, and the same thing may be said of the works of Wolfius, Burlick-Macquis, and Rutherford. The Summary of the Law of Nations by Professor Martens is a treatise of greater practical utility, but it is only a very partial view of the system, being confined to the customary and conventional law of the modern nations of Europe. Binkerscherk's treatise on the law of war has always been received as of great authority on that particular branch of the science of the law of nations, and the subject is ably and copiously discussed. The work is replete with practical illustration, though too exclusive in its references to the ordinances of his own country to render his authority very unquestionable. The most popular and the most elegant writer on the law of nations is Vattel, whose method has been greatly admired. He has been cited for the last half-century more freely than any one of the public jurists, but he is very deficient in philosophical precision. His topics are loosely and often tediously and diffusively discussed, and he is not sufficiently supported by the authority of precedents, which constitute the foundation of the positive law of nations. There is no work which combines in just proportions and with entire satisfaction an accurate and comprehensive view of the necessary and of the instituted law of nations, and in which principles are sufficiently supported by argument, authority, and examples. Since the age of Grotius, the code of war has been vastly enlarged and improved, and its rights better defined, and its severities greatly mitigated. The rights of maritime capture, the principles of the law of prize, and the duties and privileges of neutrals have grown into very important titles in the system of national law. Modern improvements in the law of nations. We now appeal to more accurate, more authentic, more precise, and more commanding evidence of the rules of public law, by a reference to the decisions of those tribunals to whom, in every country, the administration of that branch of jurisprudence is specially entrusted. We likewise appeal to the official documents and ordinances of particular states, which have professed to reduce into a systematic code, for the direction of their own tribunals, and for the information of foreign powers, the law of nations on those points which relate particularly to the rights of commerce and the duties of neutrality. But in the absence of higher and more authoritative sanctions, the ordinances of foreign states, the opinions of eminent statesmen, and the writings of distinguished jurists are regarded as of great consideration on questions not settled by conventional law. In cases where the principal jurists agree, the presumption will be very great in favor of the solidity of their maxims, and no civilized nation that does not arrogantly set all ordinary law and justice at defiance will venture to disregard the uniform sense of the established writers on international law. England and the United States have been equally disposed to acknowledge the authority of the works of jurists writing professedly on public law, and the binding force of the general usage and practice of nations, and the still greater respect due to judicial decisions recognizing and enforcing the law of nations. In all our foreign negotiations and domestic discussions of questions of national law, we have paid the most implicit respect to the practice of Europe and the opinions of her most distinguished civilians. In England, the report made in 1753 to the King, in answer to the Prussian memorial, is very satisfactory evidence of the obedience shown to the great standing authorities on the law of nations, to which I have alluded, and in a case which came before Lord Mansfield in 1764, in the K.B., he referred to a decision of Lord Talbot, who had declared that the law of nations was to be collected from the practice of different nations and the authority of writers, and who had argued from such authorities as Grotius, Barbariac, Binkerscherk, Wickford, etc., in a case where British authority was silent. The most celebrated collections and codes of maritime law, such as the Consolato del Mare, the laws of Oleron, the laws of the Hanseatic League, and above all the marine ordinances of Louis XIV, are also referred to as containing the most authentic evidence of the immemorial and customary law of Europe. Importance of the study. The dignity and importance of this branch of jurisprudence cannot fail to recommend it to the deep attention of the student, and a thorough knowledge of its principles is necessary to lawyers and statesmen, and highly ornamental to every scholar who wishes to be adorned with the accomplishments of various learning. Many questions arise in the course of commercial transactions which require for their solution an accurate acquaintance with the conventional law of Europe and the general doctrines of the prize tribunals. Though we may remain in peace, there is always war raging in some part of the globe, and we have at the present moment neutral rights to exact and neutral duties to perform in the course of our Mediterranean trade and in the trade to the Brazils and along the shores of the Pacific. A comprehensive and scientific knowledge of international law is highly necessary, not only to lawyers practicing in our commercial ports, but to every gentleman who is animated by liberal views and a generous ambition to assume stations of high public trust. It would be exceedingly to the discredit of any person who should be called to take a share in the councils of the nation if he should be found deficient in the great leading principles of this law. And I think I cannot be mistaken in considering the elementary learning of the law of nations as not only an essential part of the education of an American lawyer, but as proper to be academically taught. My object, therefore, in some succeeding lectures, will be to discuss all the leading points arising upon the rights and duties of nations in the several relations of peace, of war, and of neutrality. End of Section 2. Section 3 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 2. Of the Rights and Duties of Nations in a State of Peace. A view of the rights and duties of nations in peace will lead us to examine the grounds of national independence, the extent of territorial jurisdiction, the rights of embassy, and of commercial intercourse. Equality and independence of nations. Nations are equal in respect to each other and entitled to claim equal consideration for their rights, whatever may be their relative dimensions or strength, or however greatly they may differ in government, religion, or manners. This perfect equality and entire independence of all distinct states is a fundamental principle of public law. It is a necessary consequence of this equality that each nation has a right to govern itself as it may think proper, and no one nation is entitled to dictate a form of government or religion or a course of internal policy to another. No state is entitled to take cognizance or notice of the domestic administration of another state, or of what passes within it as between the government and its own subjects. The Spaniards, as Vattel observes, violated all rules of right when they set up a tribunal of their own to judge the Inca of Peru according to their laws. If he had broken the law of nations in respect to them, they would have had a right to punish him. But when they undertook to judge of the merits of his own interior administration and to try to punish him for acts committed in the course of it, they were guilty of the grossest injustice. No nation had a contention within itself, but the ancient Romans, with their usual insolence, immediately interfered and with profound duplicity pretended to take part with the oppressed for the sake of justice, though in reality for the purpose of dominion. It was by a violation of the right of national independence that they artfully dissolved the Achaean League and decreed that each member of the confederacy should be governed by its own laws, independent of the general authority. But so surprisingly loose and inaccurate were the theories of the ancients on the subject of national independence that the Greeks seem never to have questioned the right of one state to interfere in the internal concerns of another. We have several instances within time of memory of unwarrantable and flagrant violations of the independence of nations. The interference of Russia, Prussia, and Austria in the internal government of Poland, and first dismembering it of large portions of its territory, and then finally overturning its constitution and destroying its existence as an independent power, was an aggravated abuse of national right. There were several cases which preceded, or which arose during, the violence of the French Revolution, which were unjustifiable invasions of the rights of independent nations to prescribe their own forms of government and to deal in their discretion with their own domestic concerns. Among other instances, We may refer to the invasion of Holland by the Prussian arms in 1787, and of France by the Prussian arms in 1792, and of wars fomented or declared against all monarchical forms of government by the French rulers during the early and more intemperate stages of their revolution. We may cite also the invasion of Naples by Austria in 1821, and the invasion of Spain by France in 1823 under the pretext of putting down a dangerous spirit of internal revolution and reform, as instances of the same violation of the absolute equality and independence of nations. Rule of interference. Every nation has an undoubted right to provide for its own safety, and to take due precaution against distant as well as impending danger. A rational fear is said to be a justifiable cause of war. Posse vicinum imperidiri, ne in suo solo, sine alia causa suaque evidenti utilitate, munimentum nobis propinquum extraat, aut aliud quid faciat, unde justa formido periculi aureatur. The danger must be great, distinct, and imminent, and not rest on vague and uncertain suspicion. The British government officially declared to the Allied powers in 1821 that no government was more prepared than their own, quote, to uphold the right of any state or states to interfere where their own security or essential interest were seriously endangered by the internal transactions of another state, that the assumption of the right was only to be justified by the strongest necessity, and to be limited and regulated thereby, that it could not receive a general and indiscriminate application to all revolutionary movements, without reference to their immediate bearing upon some particular state or states, that its exercise was an exception to general principles of the greatest value and importance, and as one that only properly grows out of the circumstances of the special case, and exceptions of this description could never, without the utmost danger, be so far reduced to rule as to be incorporated into the ordinary diplomacy of states, or into the institutes of the law of nations. The limitation to the right of interference with the internal concerns of other states was defined in this instance with uncommon precision, and no form of civil government which a nation may think proper to prescribe for itself can be admitted to create a case of necessity justifying an interference by force. For a nation, under any form of civil policy which it may choose to adopt, is competent to preserve its faith and to maintain the relations of peace and amity with other powers. Assistance in cases of revolt. It is sometimes a very grave question when and how far one nation has a right to assist the subjects of another who have revolted and implored that assistance. It is said that assistance may be afforded consistently with the law of nations in extreme cases, as when rulers have violated the principles of the social compact and given just cause to their subjects to consider themselves discharged from their allegiance. Vattel mentions the case of the Prince of Orange as a justifiable interference, because the tyranny of James II had compelled the English nation to rise in their defense and call for his assistance. The right of interposition must depend upon the special circumstances of the case. It is not susceptible of precise limitations, and is extremely delicate in the application. It must be submitted to the guidance of eminent discretion and controlled by principles of justice and sound policy. It would clearly be a violation of the law of nations to invite subjects to revolt who were under actual obedience, however just their complaints, or to endeavor to produce discontents, violence, and rebellion in neighboring states, and under color of a generous assistance to consummate projects of ambition and dominion. The most unexceptionable precedents are those in which the interference did not take place until the new states had actually been established and sufficient means and spirit had been displayed to excite a confidence in their stability. The assistance that England gave to the United Netherlands when they were struggling against Spain, and the assistance that France gave to this country during the War of our Revolution, were justifiable acts founded in wisdom and policy. And it is not to be doubted that the government of the United States had a perfect right, in the year 1822, to consider, as it then did, the Spanish provinces in South America as legitimate powers, which had attained sufficient solidity and strength to be entitled to the rights and privileges belonging to independent states. Prior to the recognition of the independence of any of the Spanish colonies in America, and during the existence of the Civil War between Spain and her colonies, it was the declared policy of the government of the United States to remain neutral and to allow to each of the belligerent parties the same rights of asylum and hospitality, and to consider them in respect to the neutral relation and duties of the United States as equally entitled to the sovereign rights of war as against each other. This was also the judicial doctrine of the Supreme Court, derived from the policy of the government, and seems to have been regarded as a principle of international law. Nations are at liberty to use their own resources in such manner, and to apply them to such purposes as they may deem best, provided they do not violate the perfect rights of other nations, nor endanger their safety, nor infringe the indispensable duties of humanity. Treaties not affected by change of government. They may contract alliances with particular nations, and grant or withhold particular privileges in their discretion. By positive engagements of this kind, a new class of rights and duties is created which forms the conventional law of nations, and constitutes the most diffusive and generally the most important branch of public jurisprudence. And it is well to be understood, at a period when alterations in the constitutions of governments and revolutions in states are familiar, that it is a clear position of the law of nations that treaties are not affected, nor positive obligations of any kind with other powers or with creditors weakened by any such mutations. A state neither loses any of its rights, nor is discharged from any of its duties by a change in the form of its civil government. The body politic is still the same, though it may have a different organ of communication. So, if a state should be divided in respect to territory, its rights and obligations are not impaired, and if they have not been apportioned by special agreement, those rights are to be enjoyed, and those obligations fulfilled, by all the parts in common. Jurisdiction over adjoining seas. The extent of jurisdiction over the adjoining seas is often a question of difficulty and of dubious right, as far as a nation can conveniently occupy, and that occupancy is acquired by prior possession or treaty. The jurisdiction is exclusive. Navigable rivers which flow through a territory, and the sea coast adjoining it, and the navigable waters included in bays and between headlands and arms of the sea, belong to the sovereign of the adjoining territory, as being necessary to the safety of the nation and to the undisturbed use of the neighboring shores. The open sea is not capable of being possessed as private property. The free use of the ocean for navigation and fishing is common to all mankind, and the public jurists generally and explicitly deny that the main ocean can ever be appropriated. The subjects of all nations meet there, in time of peace, on a footing of entire equality and independence. No nation has any right of jurisdiction at sea, except it be over the persons of its own subjects, in its own public and private vessels, and so far territorial jurisdiction may be considered as preserved, for the vessels of a nation are, in many respects, considered as portions of its territory, and persons on board are protected and governed by the law of the country to which the vessel belongs. They may be punished for offences against the municipal laws of the state committed on board its public and private vessels at sea, and on board of its public vessels in foreign ports. This jurisdiction is confined to the ship, and no one ship has a right to prohibit the approach of another at sea, or to draw round her a line of territorial jurisdiction within which no other is at liberty to intrude. Every vessel, in time of peace, has a right to consult its own safety and convenience, and to pursue its own course and business, without being disturbed, when it does not violate the rights of others. As to narrow seas, and waters approaching the land, there have been many and sharp controversies among the European nations concerning the claim for exclusive dominion. The questions arising on this claim are not very clearly defined and settled, and extravagant pretensions are occasionally put forward. The subject abounds in curious and interesting discussions, and, fortunately for the peace of mankind, they are at the present day matters rather of speculative curiosity than of use. Grotius published his Mare Liberum against the Portuguese claim to an exclusive trade to the Indies through the South Atlantic and Indian Oceans, and he shows that the sea was not capable of private dominion. He vindicates the free navigation of the ocean and the right of commerce between nations, and justly exposes the folly and absurdity of the Portuguese claim. Selden's Mare Clausum was intended to be an answer to the doctrine of Grotius, and he undertook to prove, by the laws, usages, and opinions of all nations, ancient and modern, that the sea was, in point of fact, capable of private dominion, and he poured a flood of learning over the subject. He fell far short of his great rival in the force and beauty of his argument, but he entirely surpassed him in the extent and variety of his citations and researches. Having established the fact that most nations had conceded that the sea was capable of private dominion, he showed by numerous documents and records that the English nation had always asserted and enjoyed a supremacy over the surrounding or narrow seas, and that this claim had been recognized by all the neighboring nations. Sir Matthew Hale considered the title of the king to the narrow seas adjoining the coasts of England to have been abundantly proved by the Treatise of Selden, and Butler speaks of it as a work of profound erudition. Binkerscherk has also written a treatise on the same contested subject, in which he concedes to Selden much of his argument, and admits that the sea was susceptible of dominion, though he denies the title of the English on the ground of a want of uninterrupted possession. He said there was no instance at that time in which the sea was subject to any particular sovereign where the surrounding territory did not belong to him. The claim of dominion to close or narrow seas is still the theme of discussion and controversy. Pufendorf admits that in a narrow sea the dominion of it, and the right of fishing therein, may belong to the sovereigns of the adjoining shores. Vattel also lays down the position that the various uses to which the sea contiguous to the coast may be applied render it justly the subject of property. People fish there, and draw from it shells, pearls, amber, etc., and who can doubt, he observes, but that the pearl fisheries of Bahram and Ceylon may be lawfully enjoyed as property. Chitty, in his work on commercial law, has entered into an elaborate vindication of the British title to the 4 seas surrounding the British Islands and known by the name of the British Seas, and, consequently, to the exclusive right of fishing and of controlling the navigation of foreigners therein. On the other hand, Sir William Scott, in the case of the Twee Gebroeders, did not treat the claim of territory to contiguous portions of the sea with much indulgence. He said the general inclination of the law was against it, for in the sea, out of the reach of cannon shot, universal use was presumed, in like manner as a common use in rivers flowing through conterminous states was presumed, and yet in both cases there might, by legal possibility, exist a peculiar property, excluding the universal, or the common use. The claim of Russia to sovereignty over the Pacific Ocean north of the 51st degree of latitude as a close sea was considered by our government in 1822 to be against the rights of other nations. It is difficult to draw any precise or determinate conclusion amidst the variety of opinions as to the distance to which a state may lawfully extend its exclusive dominion over the sea adjoining its territories, and beyond those portions of the sea which are embraced by harbors, gulfs, bays, and estuaries, and over which its jurisdiction unquestionably extends. All that can reasonably be asserted is, that the dominion of the sovereign of the shore over the contiguous sea extends as far as is requisite for his safety and for some lawful end. A more extended dominion must rest entirely upon force and maritime supremacy. According to the current of modern authority, the general territorial jurisdiction extends into the sea as far as cannon shot will reach, and no farther, and this is generally calculated to be a marine league, and the Congress of the United States have recognized this limitation by authorizing the district courts to take cognizance of all captures made within a marine league of the American shores. The executive authority of this country in 1793 considered the whole of Delaware Bay to be within our territorial jurisdiction, and it rested its claim upon those authorities which admit that gulfs, channels, and arms of the sea belong to the people with whose lands they are encompassed. It was intimated that the law of nations would justify the United States in attaching to their coasts an extent into the sea beyond the reach of cannon shot. Considering the great extent of the line of the American coasts, we have a right to claim for fiscal and defensive regulations a liberal extension of maritime jurisdiction, and it would not be unreasonable, as I apprehend, to assume for domestic purposes connected with our safety and welfare the control of the waters on our coasts, though included within lines stretching from quite distant headlands, as, for instance, from Cape Ann to Cape Cod, and from Nantucket to Montauk Point, and from that point to the Capes of the Delaware, and from the South Cape of Florida to the Mississippi. It is certain that our government would be disposed to view with some uneasiness and sensibility, in the case of war between other maritime powers, the use of the waters of our coast far beyond the reach of cannon shot as cruising ground for belligerent purposes. In 1793 our government thought they were entitled, in reason, to as broad a margin of protected navigation as any nation whatever, though at that time they did not positively insist beyond the distance of a marine league from the seashores. And in 1806 our government thought it would not be unreasonable, considering the extent of the United States, the shoalness of their coast, and the natural indication furnished by the well-defined path of the Gulf Stream, to expect an immunity from belligerent warfare for the space between that limit and the American shore. It ought, at least, to be insisted that the extent of the neutral immunity should correspond with the claims maintained by Great Britain around her own territory, and that no belligerent right should be exercised within, quote, the chambers formed by headlands or anywhere at sea within the distance of 4 leagues, or from a right line from one headland to another, close quote. In the case of the Little Belt, which was cruising many miles from the shore between Cape Henry and Cape Hatteras, our government laid stress on the circumstance that she was, quote, hovering on our coasts, close quote, and it was contended on the part of the United States that they had a right to know the national character of armed ships in such a situation, and that it was a right immediately connected with our tranquillity and peace. It was further observed that all nations exercised the right, and none with more rigor, or at a greater distance from the coast than Great Britain, and none on more justifiable grounds than the United States. There can be but little doubt that as the United States advance in commerce and naval strength, our government will be disposed more and more to feel and acknowledge the justice and policy of the British claim to supremacy over the narrow seas adjacent to the British Isles, because we shall stand in need of similar accommodation and means of security. It was declared in the case of Le Louis that maritime states claim, upon a principle just in itself and temperately applied, a right of visitation and inquiry within those parts of the ocean adjoining to their shores. They were to be considered as parts of the territory for various domestic purposes, and the right was admitted by the courtesy of nations. The English hovering laws were founded upon that right. The statute 9 George II, Chapter 35, prohibited foreign goods to be transshipped within 4 leagues of the coast without payment of duties, and the Act of Congress of March 2, 1799, Chapter 128, Sections 25, 26, 27, and 99, contained the same prohibition, and the exercise of jurisdiction to that distance for the safety and protection of the revenue laws was declared by the Supreme Court in Church v. Hubbard to be conformable to the laws and usages of nations. Rights of Commerce. As the end of the law of nations is the happiness and perfection of the general society of mankind, it enjoins upon every nation the punctual observance of benevolence and goodwill, as well as of justice towards its neighbors. This is equally the policy and the duty of nations. They ought to cultivate a free intercourse for commercial purposes in order to supply each other's wants and promote each other's prosperity. The variety of climates and productions on the surface of the globe, and the facility of communication by means of rivers, lakes, and the ocean, invite to a liberal commerce, as agreeable to the law of nature and extremely conducive to national amity, industry, and happiness. The numerous wants of civilized life can only be supplied by mutual exchange between nations of the peculiar productions of each. And who that is familiar with the English classics has not dwelt with delight on the description of the extent and blessings of English commerce, which Addison has given with such graceful simplicity and such enchanting elegance in one of the Spectator's visits to the Royal Exchange? But as every nation has the right, and is disposed to exercise it, of judging for itself in respect to the policy and extent of its commercial arrangements, the general freedom of trade, however reasonably and strongly it may be inculcated in the modern school of political economy, is but an imperfect right, and necessarily subject to such regulations and restrictions as each nation may think proper to prescribe for itself. every nation may monopolize as much as it pleases of its own internal and colonial trade, or grant to other nations with whom it deals such distinctions and particular privileges as it may deem conducive to its interest. The celebrated English Navigation Act of Charles II contained nothing, said Martins, contrary to the law of nations, notwithstanding it was very embarrassing to other countries. When the United States put an entire stop to their commerce with the world in December 1807 by laying a general embargo on their trade, without distinction as to nation, or limit as to time, no other power complained of it, and the foreign government most affected by it, and against whose interests it was more immediately directed, declared to our government that as a municipal regulation foreign states had no concern with it, and that the British government did not conceive that they had the right or the pretension to make any complaint of it, and that they had made none. No nation has a right in time of peace to interfere with or interrupt any commerce which is lawful by the law of nations, and carried on between other independent powers, or between different members of the same state. The claim of the Portuguese, in the height of their maritime power in India, to exclude all European people from commerce with Asia, was contrary to national law and a just cause of war. Vattel called it a pretension no less iniquitous than chimerical. The attempt of Russia to appropriate to herself an exclusive trade in the North Pacific met with a prompt resistance on the part of this country, and the government of the United States claimed for its citizens the right to carry on trade with the aboriginal natives on the northwest coast of America, without the territorial jurisdiction of other nations, even in arms and ammunitions of war. Commercial treaties. Treaties of commerce, defining and establishing the rights and extent of commercial intercourse, have been found to be of great utility, and they occupy a very important title in the code of international law. They were considered, even 2 centuries ago, to be so conducive to the public welfare as to overcome the bigotry of the times, and Lord Coke admitted them to be one of the 4 kinds of national compacts that might lawfully be made with infidels. They have multiplied exceedingly within the last century, for it has been found by experience that the general liberty of trade, resting solely on principles of common right, benevolence, and sound policy, was too vague and precarious to be consistent with the safety of the extended intercourse and complicated interests of great commercial states. Every nation may enter into such commercial treaties and grant such special privileges as they think proper, and no nation, to whom the like privileges are not conceded, has a right to take offense, provided those treaties do not affect their perfect rights. A state may enter into a treaty by which it grants exclusive privileges to one nation and deprives itself of the liberty to grant similar privileges to any other. Thus Portugal in 1703, by her treaty with England, gave her the monopoly of her wine trade, and the Dutch, formerly, by a treaty with Ceylon, engrossed the cinnamon trade, and, latterly, they have monopolized the trade of Japan. These are matters of strict legal right, but it is, nevertheless, in a moral sense, the duty of every nation to deal kindly, liberally, and impartially toward all mankind, and not to bind itself by treaty with one nation in contravention of those general duties which the law of nature dictates to be due to the rest of the world. Passage over foreign territory. Every nation is morally bound, in time of peace, to grant a passage, for lawful purposes, over their lands, rivers, and seas, to the people of other states, whenever it can be permitted without inconvenience, and burthensome conditions ought not to be annexed to the transit of persons and property. If, however, any government deems the introduction of foreigners or their merchandise injurious to those interests of their own people which they are bound to protect and promote, they are at liberty to withhold the indulgence. The entry of foreigners and their effects is not an absolute right, but only one of imperfect obligation, and is subject to the discretion of the government which tolerates it. The state may even levy a tax or toll upon the persons and property of strangers in transitu, provided the same be a reasonable charge, by way of recompense for the expense which the accommodation creates. These things are now generally settled in commercial treaties, by which it is usually stipulated that there shall be free navigation and commerce between the nations, and a free entry to persons and property, subject to the ordinary revenue and police laws of the country and the special terms and conditions prescribed by treaty. End of Section 3. Section 4 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 2, of the Rights and Duties of Nations in a State of Peace. Use of navigable rivers. A nation possessing only the upper parts of a navigable river is entitled to descend to the sea without being embarrassed by useless and oppressive duties or regulations. It is doubtless a right of imperfect obligation, but one that cannot justly be withheld without good cause. When Spain, in the year 1792, owned the mouth and both banks of the lower Mississippi, and the United States the left bank of the upper portion of the same, it was strongly contended on the part of the United States that by the law of nature and nations we were entitled to the navigation of that river to the sea, subject only to such modifications as Spain might reasonably deem necessary for her safety and fiscal accommodation. It was further contended that the right to the end carried with it as an incident the right of the means requisite to attain the end, such, for instance, as the right to moor vessels to the shore and to land in cases of necessity. The same clear right of the United States to the free navigation of the Mississippi through the territories of Spain to the ocean was asserted by the Congress under the Confederation. The claim in that case, with the qualifications annexed to it, was well grounded on the principles and authorities of the law of nations. The like claim, and founded on the same principles of natural law, and on the authority of jurists and the conventional law of nations, has been made on behalf of the people of the United States to navigate the St. Lawrence to and from the sea, and it has been discussed at large between the American and British governments. Surrender of criminals. When foreigners are admitted into a state upon free and liberal terms, the public faith becomes pledged for their protection. The courts of justice ought to be freely open to them as a resort for the redress of their grievances. But strangers are equally bound with natives to obedience and to the laws of the country during the time they sojourn in it, and they are equally amenable for infractions of the law. It has sometimes been made a question how far one government was bound by the law of nations, and independent of treaty, to surrender upon demand fugitives from justice, who, having committed crimes in one country, flee to another for shelter. It is declared by some of the most distinguished public jurists that every state is bound to deny an asylum to criminals, and upon application and due examination of the case, to surrender the fugitive to the foreign state where the crime was committed. The language of those authorities is clear and explicit, and the law and usage of nations as declared by them rest on the plainest principles of justice. It is the duty of the government to surrender up fugitives upon demand, after the civil magistrate shall have ascertained the existence of reasonable grounds for the charge, and sufficient to put the accused upon his trial. The guilty party cannot be tried and punished by any other jurisdiction than the one whose laws have been violated, and, therefore, the duty of surrendering him applies as well to the case of the subjects of the state surrendering, as to the case of subjects of the power demanding the fugitive. The only difficulty in the absence of positive agreement consists in drawing the line between the class of offenses to which the usage of nations does, and to which it does not, apply, inasmuch as it is understood in practice to apply only to crimes of great atrocity or deeply affecting the public safety. The act of the Legislature of New York of the 5th of April, 1822, Chapter 148, gave facility to the surrender of fugitives by authorizing the governor, in his discretion, on requisition from a foreign government, to surrender up fugitives charged with murder, forgery, larceny, or other crimes, which by the laws of this state were punishable with death or imprisonment in the state prison, provided the evidence of criminality was sufficient by our laws to detain the party for trial on a like charge. Such a legislative provision was requisite, for the judicial power can do no more than cause the fugitive to be arrested and detained, until sufficient means and opportunity have been afforded for the discharge of this duty to the proper organ of communication with the power that makes the demand. The European nations in early periods of modern history made provision by treaty for the mutual surrender of criminals seeking refuge from justice. Treaties of this kind were made between England and Scotland in 1174, and England and France in 1308, and France and Savoy in 1378, and the last treaty made special provision for the surrender of criminals, though they should happen to be subjects of the state to which they had fled. Mr. Ward considers these treaties as evidence of the advancement of society in regularity and order. Ambassadors. Ambassadors form an exception to the general case of foreigners resident in the country, and they are exempted absolutely from all allegiance and from all responsibility to the laws of the country to which they are deputed. As they are representatives of their sovereigns and requisite for negotiations and friendly intercourse, their persons, by the consent of all nations, have been deemed inviolable, and the instances are rare in which popular passions or perfidious policy have violated this immunity. Some very honorable examples of respect for the rights of ambassadors, even when their privileges would seem injustice to have been forfeited on account of the gross abuse of them, are to be met with in the ancient Roman annals, notwithstanding the extreme arrogance of their pretensions and the intemperance of their military spirit. If, however, ambassadors should be so regardless of their duty and of the object of their privilege as to insult or openly attack the laws or government of the nation to whom they are sent, their functions may be suspended by a refusal to treat with them, or application can be made to their own sovereign for their recall, or they may be dismissed and required to depart within a reasonable time. We have had instances within our times of all these modes of dealing with ministers who have given offense, and it is not to be denied that every government has a perfect right to judge for itself whether the language or conduct of a foreign minister be admissible. The writers on public law go still further and allow force to be applied to confine or send away an ambassador when the safety of the state, which is superior to all other considerations, absolutely requires it, arising either from the violence of his conduct or the influence and danger of his machinations. This is all that can be done, for ambassadors cannot, in any case, be made amenable to the civil or criminal jurisdiction of the country, and this has been the settled rule of public law ever since the attempt made in the reign of Elizabeth to subject the Scotch ambassador to criminal jurisdiction, and the learned discussions which that case excited. By fiction of law, an ambassador is considered as if he were out of the territory of the foreign power, and it is an implied agreement among nations that the ambassador, while he resides within the foreign state, shall be considered as a member of his own country, and the government he represents has exclusive cognizance of his conduct and control of his person. An ambassador is also deemed under the protection of the law of nations in his passage through the territories of a third and friendly power, while upon his public mission in going to and returning from the government to which he is deputed. To arrest him under such circumstances would be a breach of his privilege as a public minister. The attendants of the ambassador attached to his person and the effects in his use and the house in which he resides are under his protection and privilege, and equally exempt from the foreign jurisdiction, though there are strong instances in which their inviolability has been denied and invaded. The distinction between ambassadors, ministers plenipotentiary, envoys extraordinary, and resident ministers relates to diplomatic precedence and etiquette, and not to their essential powers and privileges. A government may, in its discretion, lawfully refuse to receive an ambassador, and without affording any just cause for war, though the act would probably excite unfriendly dispositions unless accompanied with conciliatory explanations. The refusal may be upon the ground of the ambassador's bad character or former offensive conduct, or because the special subject of the embassy is not proper or not convenient for discussion. A state may also be divided and distracted by civil wars so as to render it inexpedient to acknowledge the supremacy of either party. Binkerscherk says that this right of sending ambassadors belongs to the ruling party, in whom stet rei agendae potestas. This is placing the right where all foreign governments place it, in the government de facto, which is in the actual exercise of power. But the government to whom the ambassador is sent may exercise its discretion in receiving or refusing to receive him. It sometimes becomes a grave question in national discussions how far the sovereign is bound by the act of his minister.
This will depend upon the nature and terms of his authority. It is now the usual course for every government to reserve to itself the right to ratify or dissent from the treaty agreed to by its ambassador. A general letter of credence is the ordinary letter of attorney, or credential of the minister, and it is not understood to confer a power upon the minister to bind his sovereign conclusively. To do so important an act would require at least a distinct and special power containing an express authority to bind the principle definitively, without the right of review or the necessity of ratification on his part. This is not the ordinary or prudent course of business. Ministers always act under instructions which are confidential, and which, it is admitted, they are not bound to disclose, and it is a well-grounded custom, as Vattel observes, that any engagement which the minister shall enter into is of no force among sovereigns unless ratified by his principal. This is now the usage, although the treaty may have been signed by plenipotentiaries. Consuls. Consuls are commercial agents appointed to reside in the seaports of foreign countries, with a commission to watch over the commercial rights and privileges of the nation deputing them. The establishment of consuls is one of the most useful of modern commercial institutions. They were first appointed about the 12th century in the opulent states of Italy, such as Pisa, Lucca, Genoa, and Venice, and their origin has been ascribed to the necessity for extraordinary assistance in those branches of commerce formerly carried on with barbarous and uncivilized nations. The utility of such a mercantile officer has been perceived and felt by all trading nations, and the Mediterranean trade in particular stands highly in need of such accredited agents. Consuls have been multiplied and extended to every part of the world, where navigation and commerce can successfully penetrate, and their duties and privileges are now generally limited and defined in treaties of commerce or by the statute regulations of the country which they represent. In some places they have been invested with judicial powers over disputes between their own merchants in foreign ports, but in the commercial treaties made by Great Britain there is rarely any stipulation for clothing them with judicial authority, except in treaties with the Barbary powers, and in England it has been held that a consul is not strictly a judicial officer, and they have there no judicial power. It's been urged by some writers as a matter highly expedient to establish rules requiring merchants abroad to submit their disputes to the judicial authority of their own consuls, particularly with reference to shipping concerns. But no government can invest its consuls with judicial power over their own subjects in a foreign country without the consent of the government of the foreign country founded on treaty. And there is no instance, in any nation of Europe, of the admission of criminal jurisdiction in foreign consuls. The laws of the United States on the subject of consuls and vice-consuls specially authorize them to receive the protest of masters and others relating to American commerce, and they declare that consular certificates under seal shall receive faith and credit in the courts of the United States. It is likewise made their duty, where the laws of the country permit, to administer on the personal estates of American citizens, dying within their consulates, and leaving no legal representative, and to take charge of and secure the effects of stranded American vessels in the absence of the master, owner, or consignee, and they are bound to provide for destitute seamen within their consulates, and to send them at the public expense to the United States. And it is made the duty of masters of American vessels on arrival at a foreign port to deposit their registers, sea letters, and passports with the consul, vice-consul, or commercial agent, if any, at the port, though this injunction only applies when the vessel shall have come to an entry or transacted business at the port. These particular powers and duties are similar to those prescribed to British consuls, and to consuls under the Consular Convention between the United States and France in 1788, and they are in accordance with the usages of nations, and are not to be construed to the exclusion of others resulting from the nature of the consular appointment. The former Consular Convention between France and this country allowed consuls to exercise police over all vessels of their respective nations, quote, within the interior of the vessels, and to exercise a species of civil jurisdiction by determining disputes concerning wages and between the masters and crews of vessels belonging to their own country. The jurisdiction claimed under the Consular Convention with France was merely voluntary, and altogether exclusive of any coercive authority, and we have no treaty at present which concedes even such consular functions. The doctrine of our courts is that a foreign consul duly recognized by our government may assert and defend as a competent party the rights of property of the individuals of his nation in the courts of the United States, and may institute suits for that purpose without any special authority from the party for whose benefit he acts. But the court in that case said they could not go so far as to recognize a right in a vice-consul to receive actual restitution of the property or its proceeds without showing some specific power for the purpose from the party in interest. No nation is bound to receive a foreign consul unless it has agreed to do so by treaty, and the refusal is no violation of the peace and amity between the nations. Consuls are to be approved and admitted in the usual form, and if any consul be guilty of illegal or improper conduct, he is liable to have his exequatur, or written recognition of his character, revoked, and to be punished according to the laws of the country in which he is consul. Or he may be sent back to his own country at the discretion of the government which he has offended. The French consuls are forbidden to be concerned in commerce, and by the Act of Congress of February 28, 1803, American consuls residing on the Barbary coast are forbidden also. But British and American consuls are generally at liberty to be concerned in trade, and in such cases the character of consul does not give any protection to that of merchant, when these characters are united in the same person. Though the functions of consul would seem to require that he should not be a subject of the state in which he resides, yet the practice of the maritime powers is quite lax on this point, and it is usual and thought most convenient to appoint subjects of the foreign country to be consuls at its ports. A consul is not such a public minister as to be entitled to the privileges appertaining to that character, nor is he under the special protection of the law of nations. He is entitled to privileges to a certain extent, such as for safe conduct, but he is not entitled to the jus gentium. Vattel thinks that his functions require that he should be independent of the ordinary criminal jurisdiction of the country, and that he ought not to be molested, unless he violates the law of nations by some enormous crime, and that if guilty of any crime he ought to be sent home to be punished. But no such immunities have been conferred on consuls by the modern practice of nations, and it may be considered as settled law that consuls do not enjoy the protection of the law of nations any more than other persons who enter the country under a safe conduct. In civil and criminal cases they are equally subject to the laws of the country in which they reside. The same doctrine declared by the public jurists has been frequently laid down in the English and American courts of justice. It seems, however, from some decisions in France mentioned by Mr. Warden, that foreign consuls cannot be prosecuted before a French tribunal for acts done by them in France by order of their government and with the authorization of the French government, and that in general a consul cannot be prosecuted without the previous consent of his government. Consular privileges are much less extensive in Christian than in Mohammedan countries. In the latter, they cannot be imprisoned for any cause whatever, except by demanding justice against them of the Porte, and they partake very considerably of the character and importance of the resident ministers. They are diplomatic agents under the name of consuls, and enjoy the rights and privileges which the Ottoman Porte recognizes in relation to the foreign ministers resident at Constantinople. By treaty, an entire immunity is usually given to the persons, domestics, and effects of the resident consuls, and no consuls reside with the Barbary States but under the protection of treaties. Considering the importance of the consular functions, and the activity which is required of them in all great maritime ports, and the approach which consuls make to the efficacy and dignity of diplomatic characters, it was a wise provision in the Constitution of the United States which gave to the Supreme Court original jurisdiction in all cases affecting consuls, as well as ambassadors and other public ministers, and the federal jurisdiction is understood to be exclusive of the state courts. End of Section 4. Section 5 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 3. Of the Declaration and Other Early Measures of a State of War. In the last lecture, we considered the principal rights and duties of nations in a state of peace, and if those duties were generally and duly fulfilled,
a new order of things would arise and shed a brighter light over the history of human affairs. Peace is said to be the natural state of man, and war is undertaken for the sake of peace, which is its only lawful end and purpose. War, to use the language of Lord Bacon, is one of the highest trials of right, for as princes and states acknowledge no superior upon earth, they put themselves upon the justice of God by an appeal to arms. The history of mankind is an almost uninterrupted narration of a state of war, and gives color to the extravagant theory of Hobbes, who maintains that the natural state of man is a state of war of all against all, and it adds plausibility to the conclusions of those other writers who, having known and studied the Indian character, insist that continual war is the natural instinct and appetite of man in a savage state. It is, doubtless, true that a sincere disposition for peace and a just appreciation of its blessings are the natural and necessary result of science and civilization. Self-defense. The right of self-defense is part of the law of our nature, and it is the indispensable duty of civil society to protect its members in the enjoyment of their rights, both of person and property. This is the fundamental principle of the social compact. An injury either done or threatened to the perfect rights of the nation or of any of its members, and susceptible of no other redress, is a just cause of war. The injury may consist not only in the direct violation of personal or political rights, but in wrongfully withholding what is due, or in the refusal of a reasonable reparation for injuries committed, or of adequate explanation or security in respect to manifest and impending danger. Grotius condemns the doctrine that war may be undertaken to weaken the power of a neighbor, under the apprehension that its further increase may render him dangerous. This would be contrary to justice unless we were morally certain not only of a capacity, but of an actual intention to injure us. We ought rather to meet the anticipated danger by a diligent cultivation and prudent management of our own resources. We ought to conciliate the respect and goodwill of other nations, and secure their assistance in case of need, by the benevolence and justice of our conduct. War is not to be resorted to without absolute necessity, nor unless peace would be more dangerous and more miserable than war itself. An injury to an individual member of a state is a just cause of war, if redress be refused. But a nation is not bound to go to war on so slight a foundation, for it may of itself grant indemnity to the injured party, and if this cannot be done, yet the good of the whole is to be preferred to the welfare of a part. Every milder method of redress is to be tried before the nation makes an appeal to arms, and this is the sage and moral precept of the writers on natural law. If the question of right between two powers be in any degree dubious, they ought to forbear proceeding to extremities, and a nation would be condemned by the impartial voice of mankind if it voluntarily went to war upon a claim of which it doubted the legality. But, on political subjects, we cannot expect and are not to look for the same rigorous demonstration as in the physical sciences. Policy is a science of calculations and combinations arising out of times, places, and circumstances, and it cannot be reduced to absolute simplicity and certainty. We must act according to the dictates of a well-informed judgment, resting upon a diligent and careful examination of facts, and every pacific mode of redress is to be tried faithfully and perseveringly before the nation resorts to arms. Assistance by treaty. If one nation be bound by treaty to afford assistance in a case of war between its ally and a third power, the assistance is to be given whenever the casus foederis occurs. But a question will sometimes arise whether the government which is to afford the aid is to judge for itself of the justice of the war on the part of the ally, and to make the right to assistance depend on its own judgment. Grotius is of opinion that treaties of that kind do not oblige us to participate in a war which appears to be manifestly unjust on the part of the ally, and it is said to be a tacit condition annexed to every treaty made in time of peace, and stipulating to afford succors in time of war, that the stipulation is only to apply to a just war. To give assistance in an unjust war, on the ground of the treaty, would be contracting an obligation to do injustice, and no such contract is valid. But to set up a pretext of this kind, to avoid a positive engagement, is extremely hazardous, and it cannot be done, except in a very clear case, without exposing the nation to the imputation of a breach of public faith. In doubtful cases, the presumption ought to rather be in favor of our ally and of the justice of the war. The doctrine that one nation is not bound to assist another under any circumstances in a war clearly unjust is similar to the principle in the feudal law to be met with in the Book of Feuds, compiled from the usages of the Lombards and forming part of the common law of Europe during the prevalence of the feudal system. A vassal refusing to assist his liege lord in a just war forfeited his feud. If the justice of the war was even doubtful, or not known affirmatively to be unjust, the vassal was bound to assist. But if the war appeared to him to be manifestly unjust, he was under no obligation to help his lord to carry it on offensively. A nation which has agreed to render assistance to another is not obliged to furnish it when the case is hopeless, or when giving the succors would expose the state itself to imminent danger. Such extreme cases are tacit exceptions to the obligation of the treaty, but the danger must not be slight, remote, or contingent, for this would be to seek a frivolous cause to violate a solemn engagement. In the case of a defensive alliance, the condition of the contract does not call for the assistance unless the ally be engaged in a defensive war. For in a defensive alliance, the nation engages only to defend its ally in case he be attacked, and even then we are to inquire whether he be not justly attacked. The defensive alliance applies only to the case of a war first commenced, in point of fact, against the ally, and the power that first declares or actually begins the war makes what is deemed in the conventional law of nations an offensive war. The Treaty of Alliance between France and the United States in 1778 was declared by the second article to be a defensive alliance, and that declaration gave a character to the whole instrument and consequently the guarantee on the part of the United States of the French possessions in America could only apply to future defensive wars on the part of France. Upon that ground, the government of this country in 1793 did not consider themselves bound to depart from their neutrality and to take part with France in the war in which she was then engaged. The War of 1793 was first actually declared and commenced by France against all the allied powers of Europe, and the nature of the guarantee required us to look only to that fact. Declaration of War. In the ancient republics of Greece and Italy, the right of declaring war resided with the people, who retained in their collective capacity the exercise of a large portion of the sovereign power. Among the ancient Germans it belonged also to the popular assemblies, and the power was afterwards continued in the same channel and actually resided in the Saxon Wittenagemote. But in the monarchies of Europe, which arose upon the ruins of the feudal system, this important prerogative was generally assumed by the king, as appertaining to the duties of the executive department of government. Many publicists consider the power as a part of the sovereign authority of the state, of which the legislative department is an essential branch. There are, however, several exceptions to the generality of this position, for in the limited monarchies of England, France, and Holland, the king alone declares war, and yet the power to apply an observation of Vattel to the case is but a slender prerogative of the crown if the parliaments or legislative bodies of those kingdoms will act independently, since the king cannot raise the money requisite to carry on the war without their consent. The wild and destructive wars of Charles XII led the states of Sweden to reserve to themselves the right of declaring war, and in the form of government adopted in Sweden in 1772, the right to make war was continued in the same legislative body. This was the provision in those ephemeral constitutions which appeared in Poland and France the latter part of the last century, and as evidence of the force of public opinion on this subject, it may be observed that in the constitution proposed by Bonaparte on his reascension of the throne of France in 1815, the right to levy men and money for war was to rest entirely upon a law to be proposed to the House of Representatives of the people and assented to by them. In this country, the power of declaring war, as well as of raising the supplies, is wisely confided to the legislature of the Union, and the presumption is that nothing short of a strong case deeply affecting our essential rights, and which cannot receive a pacific adjustment after all reasonable efforts shall have been exhausted, will ever prevail upon Congress to declare war. It has been usual to precede hostilities by a public declaration communicated to the enemy. It was the custom of the ancient Greeks and Romans to publish a declaration of the injuries they had received, and to send a herald to the enemy's borders to demand satisfaction before they actually engaged in war. And invasions without notice were not looked upon as lawful. War was declared with religious preparation and solemnity. According to Ulpian, they alone were reputed enemies against whom the Roman people had publicly declared war. During the Middle Ages, a previous declaration of war was held to be requisite by the laws of honor, chivalry, and religion. Louis IX refused to attack the Sultan of Egypt until he made a previous declaration to him by a herald at arms, and one of his successors sent a herald with great formality to the government of the Low Countries when he declared war against that power in 1635. But in modern times, the practice of a solemn declaration made to the enemy has fallen into disuse, and the nation contents itself with making a public declaration of war within its own territory and to its own people. The jurists are, however, divided in opinion in respect to the necessity or justice of some previous declaration to the enemy in case of offensive war. Grotius considers a previous demand of satisfaction and a declaration as requisite to a solemn and lawful war, and Pufendorf holds acts of hostility which have not been preceded by a formal declaration of war to be no better than acts of piracy and robbery. Amerigon is of the same opinion, and he considered the hostilities exercised by England in the year 1755, prior to any declaration of war, to have been in contempt of the law of nations and condemned by all Europe. Vattel strongly recommends a previous declaration of war as being required by justice and humanity, and he says that the Physical law of the Romans gave such moderation and religious solemnity to a preparation of war, and bore such marks of wisdom and justice, that it laid the solid foundation of their future greatness. Binkershoek has devoted an entire chapter to this question, and he maintains that a declaration of war is not requisite by the law of nations, and that though it may very properly be made, it cannot be required as a matter of right. The practice rests entirely on manners and magnanimity, and it was borrowed from the ancient Romans. All that he contends for is that a demand of what we conceive to be due should be previously made. We are not bound to accompany that demand with threats of hostility, or to follow it with a public declaration of war, and he cites many instances to show that within the last 2 centuries wars have been frequently commenced without a previous declaration. Since the time of Binkershoek, it has become settled by the practice of Europe that war may lawfully exist by a declaration which is unilateral only, or without a declaration on either side. It may begin with mutual hostilities. After the Peace of Versailles in 1763, formal declaration of war of any kind seemed to have been discontinued, and all the necessary and legitimate consequences of war flow at once from a state of public hostilities duly recognized and explicitly announced by a domestic manifesto or state paper. In the war between England and France in 1778, the first public act on the part of the English government was recalling its minister, and that single act was considered by France as a breach of the peace between the 2 countries. There was no other declaration of war, though each government afterward published a manifesto in vindication of its claims and conduct. The same thing may be said of the war which broke out in 1793 and again in 1803, and indeed in the War of 1756, though a solemn and formal declaration of war in the ancient style was made in June 1756, vigorous hostilities had been carried on between England and France for a year preceding. In the war declared by the United States against England in 1812, hostilities were immediately commenced on our part as soon as the Act of Congress was passed, without waiting to communicate to the English government any notice of our intentions. But, though a solemn declaration or previous notice to the enemy be now laid aside, it is essential that some formal public act, proceeding directly from the competent source, should announce to the people at home their new relations and duties growing out of a state of war, and which should equally apprise neutral nations of the fact, to enable them to conform their conduct to the rights belonging to the new state of things. War, says Vattel, is at present published and declared by manifestos. Such an official act operates from its date to legalize all hostile acts in like manner as a treaty of peace operates from its date to annul them. As war cannot lawfully be commenced on the part of the United States without an act of Congress, Such an act is, of course, a formal official notice to all the world, and equivalent to the most solemn declaration. State of war binds subjects. When war is duly declared, it is not merely a war between this and the adverse government in their political characters. Every man is, in judgment of law, a party to the acts of his own government, and a war between the governments of two nations is a war between all the individuals of the one and all the individuals of which the other nation is composed. Government is the representative of the will of all the people, and acts for the whole society. This is the theory in all governments, and the best writers on the law of nations concur in the doctrine that when the sovereign of a state declares war against another sovereign, it implies that the whole nation declares war, and that all the subjects of the one are enemies to all the subjects of the other. Very important consequences concerning the obligations of subjects are deducible from this principle. Enemies' property within the country. When hostilities have commenced, the first objects that naturally present themselves for detention and capture are the persons and property of the enemy found within the territory on the breaking out of the war. According to strict authority, a state has a right to deal as an enemy with persons and property so found within its power, and to confiscate the property and detain the persons as prisoners of war. No one, says Binkershoek, ever required that notice should be given to the subjects of the enemy to withdraw their property, or it would be forfeited. The practice of nations is to appropriate it at once, without notice, if there be no special convention to the contrary. But, though Binkershoek lays down this as well as other rules of war with great harshness and severity, he mentions several instances arising in the 17th and one as early as the 15th century of stipulations in treaties allowing foreign subjects a reasonable time after the war breaks out to recover and dispose of their effects or to withdraw them. Such stipulations have now become an established formula in commercial treaties. Amerigon considers such treaties as an affirmance of common right, or the public law of Europe, and the general rule laid down by some of the later publicists is in conformity with that provision. The sovereign who declares war, says Vattel, can neither detain those subjects of the enemy who are in his dominions at the time of the declaration of war, nor their effects. They came into the country under the sanction of public faith. By permitting them to enter his territories and continue there, the sovereign tacitly promised them protection and security for their return. He is therefore to allow them a reasonable time to retire with their effects, and if they stay beyond the time, he has a right to treat them as disarmed enemies, unless detained by sickness or some other insurmountable necessity, and then they are to be allowed a further time. It has been frequently provided by treaty that foreign subjects should be permitted to remain and continue their business, notwithstanding a rupture between the governments, so long as they conducted innocently. And when there was no such treaty, such a liberal permission has often been announced in the very declaration of war. Sir Michael Foster mentions several instances of such declarations by the King of Great Britain, and he says that aliens were thereby enabled to acquire personal chattels and to maintain actions for the recovery of their personal rights in as full a manner as alien friends. Besides those stipulations in treaties, which have softened the rigors of war by the civilizing spirit of commerce, many governments have made special provision in their own laws and ordinances for the security of the persons and property of the enemy's subjects, found in the country at the commencement of war. It was provided by Magna Carta that, upon the breaking out of war, foreign merchants found in England and belonging to the country of the enemy should be attached, quote, without harm of body or goods, until it be known how English merchants were treated by the enemy, and, quote, if our merchants, said the charter, be safe and well treated there, theirs shall be likewise with us. It has been deemed extraordinary that such a liberal provision should have found a place in a treaty between a feudal king and his barons, and Montesquieu was struck with admiration at the fact that a protection of that kind should have been made one of the articles of English liberty. But this provision was confined to the effects of alien merchants who were within the realm at the commencement of the war, and it was understood to be confined to the case of merchants domiciled there. It was accompanied also with one very ominous qualification, and it was at least equalled, if not greatly excelled, by an ordinance of Charles V of France a century afterwards, which declared that foreign merchants who should be in France at the time of the declaration of war should have nothing to fear, for they should have liberty to depart freely with their effects. The spirit of the provision in Magna Carta was sustained by a resolution of the judges in the time of Henry VIII, when they resolved that if a Frenchman came to England before the war, neither his person nor goods should be seized. The Statute of Staples of 27 Edward III, Chapter 17, made a still more liberal and precise enactment in favor of foreign merchants residing in England when war commenced between their prince and the King of England. They were to have convenient warning of 40 days, by proclamation, to depart the realm with their goods, and if they could not do it within that time by reason of accident, they were to have 40 days more to pass with their merchandise and with liberty, in the meantime, to sell the same. The Act of Congress of the 6th of July, 1798, Chapter 73, was dictated by the same humane and enlightened policy. It authorized the President, in case of war, to direct the conduct to be observed towards subjects of the hostile nation, being aliens, and within the United States, and in what cases and upon what security their residence should be permitted. And it declared, in reference to those who were to depart, that they should be allowed such reasonable time as might be consistent with the public safety, and according to the dictates of humanity and national hospitality, quote, for the recovery, disposal, and removal of their goods and effects, and for their departure. Right of confiscation of enemies' property. But however strong the current of authority in favor of the modern and milder construction of the rule of national law on this subject, the point seems to be no longer open for discussion in this country, and it has become definitively settled in favor of the ancient and sterner rule by the Supreme Court of the United States. The effect of war upon British property found in the United States on land at the commencement of the war was learnedly discussed and thoroughly considered in the case of Brown, and the Circuit Court of the United States at Boston decided, as upon a settled rule of the law of nations, that the goods of the enemy found in the country, and all the vessels and cargoes found afloat in our ports, at the commencement of hostilities, were liable to seizure and confiscation, and the exercise of the right rested in the discretion of the sovereign of the nation. When the case was brought up on appeal before the Supreme Court of the United States, the broad principle was assumed that war gave to the sovereign full right to take the persons and confiscate the property of the enemy wherever found, and that the mitigations of this rigid rule, which the wise and humane policy of modern times had introduced into practice, might more or less affect the exercise of the right, but could not impair the right itself. Commercial nations have always considerable property in the possession of their neighbors, and when war breaks out, the question what shall be done with the enemy's property found in the country is one rather of policy than of law, and is one properly addressed to the consideration of the legislature, and not to the courts of law. The strict right of confiscation of that species of property existed in Congress, and without a legislative act authorizing its confiscation, it could not be judicially condemned, and the Act of Congress of 1812, declaring war against Great Britain, was not such an act. Until some statute directly applying to the subject be passed, the property would continue under the protection of the law and might be claimed by the British owner at the restoration of peace. Though this decision established the right contrary to much of modern authority and practice, yet a great point was gained over the rigor and violence of the ancient doctrine by making the exercise of the right to depend upon a special act of Congress. End of Section 5. Section 6 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 3 of the Declaration and Other Early Measures of a State of War, Part 2. Hostile embargoes. The practice, so common in modern Europe, of imposing embargoes at the breaking out of hostility, has apparently the effect of destroying that protection to property which the rule of faith and justice gives to it when brought into the country in the course of trade, and in the confidence of peace. Sir William Scott, in the case of the Buddhist Lust, explains this species of embargo to be an act of a hostile nature, and amounting to an implied declaration of war, though liable to be explained away and annulled by a subsequent accommodation between the nations. The seizure is an act at first equivocal as to the effect, though hostile in the mere execution, and if the matter in dispute terminates in reconciliation, the seizure becomes a mere civil embargo. But if it terminates otherwise, the subsequent hostilities have a retroactive effect and render the embargo a hostile measure ab initio. The property detained is deemed enemy's property and liable to condemnation. This species of reprisal for some previous injury is laid down in the books as a lawful measure according to the usage of nations, but it is often reprobated, and it cannot well be distinguished from the practice of seizing property found within the territory upon the declaration of war. It does not differ in substance from the conduct of the Syracusans in the time of Dionysius the Elder, and which Mitford considered to be a gross violation of the law of nations, for they voted a declaration of war against Carthage, and immediately seized the effects of Carthaginian traders in their warehouses, and Carthaginian richly laden vessels in their harbor, and sent a herald to Carthage to negotiate. But this act of the Syracusans, near 400 years before the Christian era, was no more than what is the ordinary practice in England, according to the observation of Lord Mansfield in Lindo v. Rodney. Upon the declaration of war or hostilities, all the ships of the enemy, he says, are detained in our ports to be confiscated as the property of the enemy if no reciprocal agreement is made. Letters of marque and reprisal. Reprisals by commission or letters of marque and reprisal, granted to one or more injured subjects in the name and by the authority of the sovereign, is another mode of redress for some specific injury which is considered to be compatible with a state of peace and permitted by the law of nations. The case arises when one nation has committed some direct and palpable injury to another, as by withholding a just debt or by violence to person or property, and has refused to give any satisfaction. The reprisals may be made in support of the rights of a subject, as well as of those of the sovereign, and for the acts of the subject as well as for those of the sovereign. The commission is not to be issued except in a case clearly just, in re minime dubia, and it authorizes the seizure of the property of the subjects as well as of the sovereign of the offending nation, and to bring it in to be detained as a pledge or disposed of under judicial sanction in like manner as if it were a process of distress under national authority for some debt or duty withheld. These letters of reprisal, as being applicable to a state of peace, have been frequently recognized and regulated by treaty. The French Ordinance of the Marine of 1681 regulates minutely this remedial process, and the judicial sanction requisite to the proceedings under letters of reprisal, and which Vélin considers to be sage precautions proper to temper the rigor of this perilous mode of redress. General reprisals upon the persons and property of the subjects of another power are equivalent to open war, but these special letters of marque and reprisal, limited to a specific object, are spoken of generally, and even in the Articles of Confederation of the United States in 1781, as issuing in times of peace. They are, however, regarded by Barberiac, Amerigon, and other publicists as a species of hostility, an imperfect war, and usually a prelude to open hostilities. The favorable or adverse issue of the hazardous experiment will depend in some degree upon the matter in demand, and in a much greater degree upon the relative situation, character, strength, and spirit of the nations concerned. Confiscation of debts. The claim of a right to confiscate debts contracted by individuals in a time of peace, and which remain due to subjects of the enemy at the declaration of war, rests very much upon the same principles as that concerning the enemy's tangible property found in the country at the opening of the war, though I think the objection to the right of confiscation in this latter case is much stronger. In former times, the right to confiscate debts was admitted as a doctrine of national law, and Grotius, Pufendorf, and Binkerscherk pronounce in favor of it. It had the countenance of the civil law, and even Cicero, in his Offences, when stating the cases in which promises are not to be kept, mentions that of the creditor becoming the enemy of the country of the debtor. Down to the year 1737, the general opinion of jurists was in favor of the right, but Vattel says that a relaxation of the rigor of the rule has since taken place among the sovereigns of Europe, and that, as the custom has been generally received, he who should act contrary to it would injure the public faith, for strangers trusted his subjects only from a firm persuasion that the general custom would be observed. There has frequently been a stipulation in modern treaties that debts or moneys in the public funds should not be confiscated in the event of war, and these conventional provisions are evidence of the sense of the governments which are parties to them, and that the right of confiscation of debts and things in action is against good policy and ought to be discontinued. The treaties between the United States and Colombia in 1825, and Chile in 1832, and Venezuela in 1836, and the Peru-Bolivian Confederation in 1838 contain such a provision. But the treaty between the United States and Great Britain in 1795 went further, and contained the explicit declaration that it was unjust and impolitic that the debts of individuals should be impaired by national differences. A very able discussion of this assumed right to confiscate debts was made by Mr. Hamilton in the Numbers of Camillus, published in 1795. He examined the claim to confiscate private debts or private property in banks or in public funds on the ground of reason and principle, on those of policy and expediency, on the opinion of jurists on usage and on conventional law, and his argument against the justice and policy of the claim was exceedingly powerful. He contended it to be against good faith for a government to lay its hands on private property acquired by the permission or upon the invitation of the government, and under a necessarily implied promise of protection and security. Vattel says that everywhere in case of a war, funds credited to the public are exempt from confiscation and seizure. Amerigon and Martins make the same declaration. The practice would have a very injurious influence upon the general sense of the inviolability and sanctity of private contracts, and with debtors who had a nice and accurate sense of justice and honor, the requisition of government would not be cheerfully or readily obeyed. Voltaire has given a striking instance of the impracticability of confiscating property deposited in trust with a debtor, and of the firmness of Spanish faith. When war was declared between France and Spain in 1684, the King of Spain endeavored to seize the property of the French in Spain, but not a single Spanish factor would betray his French correspondent. Notwithstanding the weight of modern authority and of argument against this claim of right on the part of the sovereign to confiscate the debts and funds of the subjects of his enemy during war, the judicial language in this country is decidedly in support of the right. In the case of Brown versus the United States already mentioned, Judge Story in the Circuit Court in Massachusetts laid down the right to confiscate debts and enemy property found in the country according to the rigorous doctrine of the elder jurists, and he said the opinion was fully confirmed by the judgment of the Supreme Court in Ware v. Hilton, where the doctrine was explicitly asserted by some of the judges, reluctantly admitted by others, and denied by none. Chief Justice Marshall, in delivering the opinion of the Supreme Court in the case of Brown, observed that between the debts contracted under the faith of laws and property acquired in the course of trade on the faith of the same laws, reason drew no distinction, and the right of the sovereign to confiscate debts was precisely the same with the right to confiscate other property found in the country. This right, therefore, was admitted to exist as a settled and decided right stricto jure, though at the same time it was conceded to be the universal practice to forbear to seize and confiscate debts and credits. We may, therefore, lay it down as a principle of public law, so far as the same is understood and declared by the highest judicial authorities in this country, that it rests in the direction of the legislature of the Union, by a special law for that purpose, to confiscate debts contracted by our citizens and due to the enemy, but as it is asserted by the same authority, this right is contrary to universal practice, and it may, therefore, be well considered as a naked and impolitic right, condemned by the enlightened conscience and judgment of modern times. If property should have been wrongfully taken by the state before the war, and be in the country at the opening of the war, such property cannot be seized, but must be restored, because to confiscate that species of enemy's property would be for the government to take advantage of its own wrong. The The celebrated report of the English law officers of the Crown in 1753, in answer to the Prussian memorial, stated that French ships taken before the War of 1741 were, during the heat of the war with France, as well as afterwards, restored by sentences of the Admiralty courts to the French owners. No such property was ever attempted to be confiscated, for had it not been for the wrong done, the property would not have been within the King's dominions. And yet even such property is considered to be subject to the rule of vindictive retaliation, and Sir William Scott observed, in the case of the Santa Cruz, that it was the constant practice of England to condemn property seized before the war if the enemy condemns, and to restore if the enemy restores. Trading with the enemy. One of the immediate and important consequences of the declaration of war is the absolute interruption and interdiction of all commercial correspondence, intercourse, and dealing between the subjects of the two countries. The idea that any commercial intercourse, or pacific dealing, can lawfully subsist between the people of the powers at war, except under the clear and express sanction of the government, and without a special license, is utterly inconsistent with the new class of duties growing out of a state of war. The interdiction flows necessarily from the principle already stated, that a state of war puts all the members of the two nations respectively in hostility to each other, and to suffer individuals to carry on a friendly or commercial intercourse while the two governments were at war would be placing the act of government and the acts of individuals in contradiction to each other. It would counteract the operations of war and throw obstacles in the way of the public efforts and lead to disorder, imbecility, and treason. Trading supposes the existence of civil contracts and relations, and a reference to courts of justice, and it is, therefore, necessarily contradictory to a state of war. It affords aid to the enemy in an ineffectual manner by enabling the merchants of the enemy's country to support their government, and it facilitates the means of conveying intelligence and carrying on a traitorous correspondence with the enemy. These considerations apply with peculiar force to maritime states, where the principal object is to destroy the marine and commerce of the enemy in order to force them to peace. It is a well-settled doctrine in the English courts, and with the English jurists, that there cannot exist at the same time a war for arms and a peace for commerce. The war puts an end at once to all dealing and all communication with each other, and places every individual of the respective governments, as well as the governments themselves, in a state of hostility. This is equally the doctrine of all the authoritative writers on the law of nations, and of the maritime ordinances of all the great powers of Europe. It is equally the received law of this country, and was so decided frequently by the Congress of the United States during the Revolutionary War, and again by the Supreme Court of the United States during the course of the last war, and it is difficult to conceive of a point of doctrine more deeply or extensively rooted in the general maritime law of Europe, and in the universal and immemorial usage of the whole community of the civilized world. Contracts with an enemy. It follows as a necessary consequence of the doctrine of the illegality of all intercourse or traffic, without express permission, that all contracts with the enemy, made during war, are utterly void. The insurance of enemy's property is an illegal contract, because it is a species of trade and intercourse with the enemy. The drawing of a bill of exchange by an alien enemy on a subject of the adverse country is an illegal and void contract, because it is a communication and contract. The purchase of bills on the enemy's country, or the remission and deposit of funds there, is a dangerous and illegal act, because it may be cherishing the resources and relieving the wants of the enemy. The remission of funds in money or bills to subjects of the enemy is unlawful. The inhibition reaches to every communication, direct or circuitous. All endeavors at trade with the enemy, by the intervention of third persons, or by partnerships, have equally failed, and no artifice has succeeded to legalize the trade without the express permission of the government. Every relaxation of the rule tends to corrupt the allegiance of the subject and prevents the war from fulfilling its end. The only exception to this strict and rigorous rule of international jurisprudence is the case of ransom bills, and they are contracts of necessity, founded on a state of war and engendered by its violence. It is also a further consequence of the inability of the subjects of the two states to commune or carry on any correspondence or business together, that all commercial partnerships existing between the subjects of the two parties prior to the war are dissolved by the mere force and act of the war itself, though other contracts existing prior to the war are not extinguished, but the remedy is only suspended, and this from the inability of an alien enemy to sue or to sustain, in the language of the civilians, a persona standi in judicio. The whole of this doctrine respecting the illegality of any commercial intercourse between the inhabitants of two nations at war was extensively reviewed, and the principal authorities, ancient and modern, foreign and domestic, were accurately examined, and the positions which have been laid down established, in the case of Griswold v. Waddington, decided in the Supreme Court of New York and afterwards affirmed on error. This strict rule has been carried so far in the British Admiralty as to prohibit a remittance of supplies even to a British colony during its temporary subjection to the enemy, and when the colony was under the necessity of supplies, and was only very partially and imperfectly supplied by the enemy. The same interdiction of trade applies to ships of truce, or cartel ships, which are a species of navigation intended for the recovery of the liberty of prisoners of war. Such a special and limited intercourse is dictated by policy and humanity, and it is indispensable that it be conducted with the most exact and exclusive attention to the original purpose, as being the only condition upon which the intercourse can be tolerated. All trade, therefore, by means of such vessels is unlawful, without the express consent of both the governments concerned. It is equally illegal for an ally of one of the belligerents, and who carries on the war conjointly, to have any commerce with the enemy. A single belligerent may grant licenses to trade with the enemy, and dilute and weaken his own rights at pleasure, but it is otherwise when allied nations are pursuing a common cause. The community of interests and object and action creates a mutual duty not to prejudice that joint interest, and it is a declared principle of the law of nations, founded on very clear and just grounds, that one of the belligerents may seize and inflict the penalty of forfeiture on the property of a subject of a co-ally engaged in a trade with the common enemy, and thereby affording him aid and comfort, whilst the other ally was carrying on a severe and vigorous warfare. It would be contrary to the implied contract in every such warlike confederacy that neither of the belligerents, without the other's consent, shall do anything to defeat the common object. Judicial decisions on public law. In the investigation of the rules of the modern law of nations, particularly with regard to the extensive field of maritime capture, reference is generally and freely made to the decisions of the English courts. They are in the habit of taking accurate and comprehensive views of the general jurisprudence, and they have been deservedly followed by the courts of the United States on all the leading points of national law. We have a series of judicial decisions in England and in this country in which the usages and the duties of nations are explained and declared with that depth of research and that liberal and enlarged inquiry which strengthen and embellish the conclusions of reason. They contain more intrinsic argument, more full and precise details, more accurate illustrations, and are of more authority than the loose dicta of elementary writers. When those courts in this country which are charged with the administration of international law have differed from the English adjudications, we must take the law from domestic sources. But such an alternative is rarely to be met with, and there is scarcely a decision in the English prize courts at Westminster on any general question of public right that has not received the express approbation and sanction of our national courts. We have attained the rank of a great commercial nation, and war on our part is carried on upon the same principles of maritime policy which have directed the forces and animated the councils of the naval powers of Europe. When the United States formed a component part of the British Empire, our prize law and theirs were the same, and after the Revolution it continued to be the same, as far as it was adapted to our circumstances, and was not varied by the power which was capable of changing it. The great value of a series of judicial decisions in prize cases and on other questions depending on the law of nations is that they render certain and stable the loose general principles of that law, and show their application, and how they are understood in the country where the tribunals are sitting. They are therefore deservedly received with very great respect, and as presumptive though not conclusive, evidence of the law in the given case. This was the language of the Supreme Court of the United States so late as 1815, and the decisions of the English High Court of Admiralty, especially since the year 1798, have been consulted and uniformly respected by that court as enlightened commentaries on the law of nations, and affording a vast variety of instructive precedents for the application of the principles of that law. They have also this to recommend them, that they are preeminently distinguished for sagacity, wisdom, and learning, as well as for the chaste and classical beauties of their composition. Many of the most important principles of public law have been brought into use and received a practical application and been reduced to legal precision since the age of Grotius and Pufendorf, and we must resort to the judicial decisions of the prize tribunals in Europe and in this country for information and authority on a great many points on which all the leading textbooks have preserved a total silence. The complexity of modern commerce has swelled beyond all bounds, the number and intricacy of questions upon national law, and particularly upon the very comprehensive head of maritime capture. The illegality and penal consequences of trade with the enemy, the illegality of carrying enemies' dispatches, or of engaging in the coasting, fishing, or other privileged trade of the enemy, the illegality of transfer of property in transitu between the neutral and belligerent, the rules which impress upon neutral property a hostile character arising either from the domicile of the neutral owner, or his territorial possessions, or his connection with a house in trade in the enemy's country, are all of them doctrines in the modern international law which are either not to be found at all, or certainly not with any fullness of discussion and power of argument, anywhere but in the judicial investigations to which I have referred, and which have given the highest authority and splendor to this branch of learning. End of section 6.
Section 7 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 4, of the various types of property liable to capture. Property when deemed hostile. It becomes important in a maritime war to determine with precision what relations and circumstances will impress a hostile character upon persons and property, and the modern international law of the commercial world is replete with refined and complicated distinctions on this subject. It is settled that there may be a hostile character merely as to commercial purposes, and hostility may attach only to the person as a temporary enemy, or it may attach only to the property of a particular description. This hostile character, in a commercial view, or one limited to certain intents and purposes only, will attach in consequence of having possessions in the territory of the enemy, or by maintaining a commercial establishment there, or by a personal residence, or by particular modes of traffic, as by sailing under the enemy's flag or passport. This hostile relation, growing out of particular circumstances, assumes as valid the distinction which has been taken between a permanent and a temporary alien enemy. A man is said to be permanently an alien enemy when he owes a permanent allegiance to the adverse belligerent, and his hostility is commensurate in point of time with his country's quarrel. But he who does not owe a permanent allegiance to the enemy is an enemy only during the existence and continuance of certain circumstances. A neutral, for instance, said Chancellor J. Eyre, can be an alien enemy only with respect to his acts done under a local or temporary allegiance to a power at war, and when his temporary allegiance determines, his hostile character determines also. It was considered by Sir William Scott in the case of the Phoenix, and again in the case of the Frau Anna Katharina, to be a fixed principle of maritime law that the possession of the soil impressed upon the owner the character of the country, so far as the produce of the soil was concerned, wherever the hostile residence of the owner might be. The produce of a hostile soil bears a hostile character for the purpose of capture, and is the subject of legitimate prize when taken in a course of transportation to any other country. The enemy's lands are supposed to be a great source of his wealth, and perhaps the most solid foundation of his power,
and whoever owns or possesses land in the enemy's country, though he may in fact reside elsewhere, and be in every other respect a neutral or friend, must be taken to have incorporated himself with the nation, so far as he is a holder of the soil, and the produce of that soil is held to be the enemy's property, independent of the personal residence or occupation of the owner. The reasonableness of this principle will be acceded to by all maritime nations, and it was particularly recognized as a valid doctrine by the Supreme Court of the United States in Benson v. Boyle. Domicile in the enemy's country. If a person residing elsewhere has a settlement in a hostile country by the maintenance of a commercial establishment there, he will be considered a hostile character, and a subject of the enemy's country in regard to his commercial transactions connected with that establishment. The position is, moreover, a clear one, that if a person goes into a foreign country to reside, and engages in trade there, he is, by the law of nations, to be considered a merchant of that country, and a subject for all civil purposes, whether that country be hostile or neutral, and he cannot be permitted to retain the privileges of a neutral character during his residence and occupation in an enemy's country, nor can he be subjected to the disadvantages of a hostile character during his residence and occupation in a neutral country. This general rule has been applied by the English courts to the case of Englishmen residing in a neutral country, and they are admitted, in respect to their bona fide trade, to the privileges of the neutral character. In the case of the Danos, the rule was laid down by the English House of Lords in 1802 in unrestricted terms, and a British-born subject resident in Portugal was allowed the benefit of the Portuguese character so far as to render his trade with Holland, then at war with England, not impeachable as an illegal trade. The same rule was afterwards applied to a natural-born British subject domiciled in the United States, and it was held that he might lawfully trade to a country at war with England, but at peace with the United States. This same principle, that for all commercial purposes the domicile of the party without reference to the place of birth becomes the test of national character, has been repeatedly and explicitly admitted in the courts of the United States. If he resides in a belligerent country, his property is liable to capture as enemy's property, and if he resides in a neutral country, he enjoys all the privileges and is subjected to all the inconveniences of the neutral trade. He takes the advantages and disadvantages, whatever they may be, of the country of his residence. This doctrine is founded on the principles of national law, and it accords with the reason and practice of all civilized nations. Migras jura amitat ac privilegia et immutatis domicilii prioris. A person is not, however, permitted to acquire a neutral domicile that will protect such a trade in opposition to the belligerent claims of his native country, if he emigrate from that country flagrante bello. The only limitation upon the principle of determining the character from residence is, that the party must not be found in hostility in his native country. He must do nothing inconsistent with his native allegiance, and this qualification is annexed to the rule by Sir William Scott in the case of the Emmanuel, and the same qualification exists in the French law as well since before their revolution. It has been questioned whether the rule does not go too far, even with this restriction, but it appears to be too well and solidly settled to be now shaken. Domicile, its test. It has been a question admitting of much discussion and difficulty, arising from the complicated character of commercial speculations, what state of facts constitutes a residence so as to change or fix the commercial character of the party. The animus monendi appears to have been the point to be settled. The presumption arising from actual residence in any place is, that the party is there animo monendi, and it lies upon him to remove the presumption if it should be requisite for his safety. If the intention to establish a permanent residence be ascertained, the recency of the establishment, though it may have been for a day only, is immaterial. If there be no such intention, and the residence be involuntary or constrained, then a residence, however long, does not change the original character of the party, or give him a new and hostile one. But the circumstances requisite to establish the domicile are flexible and easily accommodated to the real truth and equity of the case. Thus it requires fewer circumstances to constitute domicile in the case of a native subject who returns to reassume his original character than it does to impress the national character on a stranger. The quo animo is, in each case, the real subject of inquiry, and when the residence exists freely, without force or restraint, it is usually held to be complete, whether it be an actual or only an implied residence. When the character is once fixed and has communicated a national character to the party, it is not divested by a periodical absence or even by occasional visits to his native country. Nor is it invariably necessary that the residence be personal in order to impress a person with a national character. The general rule undoubtedly is that a neutral merchant may trade in the ordinary manner to the country of a belligerent by means of a stationed agent there, and yet not contract the character of a domiciled person. But if the principal be trading, not on the ordinary footing of a foreign merchant, but as a privileged trader of the enemy, such a privileged trade puts him on the same ground with their own subjects, and he would be considered as sufficiently invested with the national character by the residence of his agent. Sir William Scott, in the case of the Anna Catarina, applied this distinction to the case of a neutral, invested with the privileges of a Spanish merchant, and the full benefit of the Spanish character, and in this case has been followed to its fullest extent in this country. It affords a sample of that piercing and unwearied investigation which the courts of admiralty have displayed in unraveling the intricate process by which an enemy's trade was attempted to be protected from hostile seizure, and in the application of sound principles of national law to new and complex cases. On the same ground it has been decided that an American consul general in Scotland, committing his whole duty to vice-consuls, was deemed to have lost his neutral character by engaging in trade in France, and it is well settled that if a foreign consul carries on trade as a merchant in an enemy's country, his consular residence and character will not protect that trade from interruption by seizure and condemnation as enemy's property. A national character acquired by residence may be thrown off at pleasure by a return to the native country. It is an adventitious character, and ceases by non-residence, or when the party puts himself in motion bona fide to quit the country sine animo revertendi, and such an intention is essential in order to enable the party to reassume his native character. In the case of the Venus, the decisions of the English courts on the subject of national character acquired by residence, and on the consequences of such acquired character, were recognized as being founded on sound principles of public law. It was declared that the law of nations distinguishes between a temporary residence in a foreign country for a special purpose, and a residence accompanied with an intention to make it the party's domicile, or permanent place of abode, and that the doctrine of the prize courts and the common law courts of England was the same on this subject with that of the public jurists. As a consequence of the doctrine of domicile, the court decided that if a citizen of the United States should establish his commercial domicile in a foreign country, and hostilities should afterwards break out between that country and the United States, his property shipped before knowledge of the war, and while that domicile continued, would be liable to capture on the ground that his permanent residence had stamped him with the national character of that country. The hostile character was deemed, but not decided, to attach to the American citizen only with respect to his property connected with his residence, which here means domicile, in the enemy's country. And the converse of the proposition was also true, that the subject of a belligerent state, domiciled in a neutral country, was to be considered a neutral by both the belligerents in reference to his trade. The doctrine of enemy's property, arising from a domicile in an enemy's country, is enforced strictly, and equitable qualifications of the rule are generally disallowed for the sake of preventing frauds on belligerent rights, and to give the rule more precision and certainty. In the law of nations as to Europe, the rule is that men take their national character from the general character of the country in which they reside, and this rule applies equally to America. But in Asia and Africa, an immiscible character is kept up, and the Europeans, trading under the protection of a factory, take their national character from the establishment under which they live and trade. This rule applies to those parts of the world from obvious reasons of policy, because foreigners are not admitted there, as in Europe and the western part of the world, into the general body and mass of the society of the nation, but they continue strangers and sojourners, not acquiring any national character under the general sovereignty of the country. Character from traffic. National character may be acquired in consideration of the traffic in which the party is concerned. If a person connects himself with a house of trade in the enemy's country in time of war, or continues during a war a connection formed in a time of peace, he cannot protect himself by having his domicile in a neutral country. He is considered as impressed with a hostile character, in reference to so much of his commerce as may be connected with that establishment. The rule is the same whether he maintains that establishment as a partner or as a sole trader. The Supreme Court of the United States, referring to the English prize cases on this subject, observed that they considered the rule to be inflexibly settled, and that they were not at liberty to depart from it, whatever doubt might have been entertained if the case was entirely new. But though a belligerent has a right to consider as enemies all persons who reside in a hostile country or maintain commercial establishments there, whether they be by birth neutrals or allies or fellow subjects, yet the rule is accompanied with this equitable qualification, that, provided their settlement is not such as to give them a domicile among enemies, they are enemies sub modo only, or in reference to so much of their property as is connected with that residence or establishment. This nice and subtle distinction allows a merchant to act in two characters, so as to protect his property connected with his house in a neutral country, and to subject to seizure and forfeiture his effects belonging to the establishment in the belligerent country. Thus, his domicile being in the neutral country, his commercial establishment there has neutral privileges and securities, while his commercial establishment in the hostile country is subject to the usual disadvantages of hostility. But on the other hand, his domicile being in the hostile country, not only his commercial establishment there, but also that in the neutral country, are subject to loss by capture of ships and cargoes. If, in such case, he is a partner in the neutral house, his partners having a neutral domicile, his interest in the effects of this house is liable to be taken. So there may be a partnership between two persons, the one residing in a neutral and the other in a belligerent country, and the trade of one of them with the enemy will be held lawful, and that of the other unlawful, and consequently the share of one partner in the joint traffic will be condemned while that of the other will be restored. This distinction has been frequently sustained, notwithstanding the difficulties that may attend the discrimination between the innocent and the noxious trade, and the rule has been introduced into the maritime law of this country. Colonial trade of the enemy. The next mode in which a hostile character may be impressed, according to the doctrine of the English courts, is by dealing in those branches of commerce which were confined in time of peace to the subjects of the enemy. There can be no doubt that a special license granted by a belligerent to a neutral vessel to trade in her colony, with all the privileges of a native vessel in those branches of commerce which were before confined to native subjects, would warrant the presumption that such vessel was adopted and naturalized, or that such permission was granted in fraud of the belligerent right of capture, and the property so covered may reasonably be regarded as enemy's property. This was the doctrine in the case of Barons v. Rucker as early as 1760. But the English rules goes further, and it annexes a hostile character and the penal consequences of confiscation to the ship and cargo of a neutral engaged in the colonial or coasting trade of the enemy, not open to foreigners in time of peace, but confined to native subjects by the fundamental regulations of the state. This prohibition stands upon two grounds. First, that if the coasting or colonial trade reserved by the permanent policy of a nation to its own subjects and vessels be opened to neutrals during war, the act proceeds from the pressure of the naval force of the enemy, and to obtain relief from that pressure. The neutral who interposes to relieve the belligerent under such circumstances rescues him from the condition to which the arms of his enemy had reduced him, restores to him those resources which had been wrested from him by the arms of his adversary, and deprives that adversary of the advantages which successful war had given him. This the opposing belligerent pronounces a departure from neutrality and an interference in the war to his prejudice. Second, if the trade be not opened by law, the neutral employed in a trade reserved by the enemy to his own vessels identifies himself with that enemy and assumes his character. These principles first became a subject of interesting discussion in the War of 1756, and they are generally known in England and in this country by the appellation of the Rule of 1756, but the rule is said to have been asserted before that period. Rule of 1756. In the letter of Puffendorf to Groningius, published in 1701, he says that the English and the Dutch were willing to leave to neutrals the commerce they were accustomed to carry on in time of peace, but were not willing to allow them to avail themselves of the war to augment it, to the prejudice of the English and the Dutch. The French ordinances of 1704 and 1744 have been considered as founded upon the basis of the same rule, and regulations are made to enforce it, and to preserve to neutrals the same trade which they had been accustomed to enjoy in peace, and to prohibit them from engaging in the colonial trade of the enemy. There is some evidence also that in the reign of Charles II, neutral vessels were considered, both by England and Holland, to be liable to capture and condemnation for being concerned in the coasting trade of the enemy. The Dutch at that day contended for this neutral exclusion on the authority of general reasoning and the practice of nations, and the same rule is said to have been asserted in the English courts in the War of 1741, and the exclusion of neutral vessels from the coasting trade of the enemy was declared to stand upon the law of nations. But it was in the War of 1756 that the rule awakened general and earnest attention. Mr. Jenkinson, in his Discourse on the Conduct of Great Britain in Respect to Neutral Nations, written in 1757, considered it to be unjust and illegal for neutrals to avail themselves of the pressure of war, to engage in a new species of traffic not permitted in peace, and which the necessities of one belligerent obliged him to grant to the detriment or perhaps to the destruction of the other. On the other hand, Hübner, who published his treatise in 1759, is of the opinion that neutrals may avail themselves of this advantage presented by the war, though he admits the lawfulness of the trade to be a question of some uncertainty. Thus seemed to stand the authority of the rule in 1756, when it was revived and brought into operation by England in the War of 1793, and again upon the renewal of war in 1803. The rule was enforced by her under occasional relaxations during the long course of the wars arising out of the French Revolution, and it was frequently vindicated by Sir William Scott in the course of his judicial decisions, with his customary ability and persuasive manner, as a rule founded in natural justice and the established jurisprudence of nations. On the other hand, the government of the United States constantly and earnestly protested against the legality of the rule, to the extent claimed by Great Britain, and they insisted in their diplomatic intercourse that the rule was an attempt to establish a new principle of the law of nations, and one which subverted many other principles of great importance which have heretofore been held sacred among nations. They insisted that neutrals were of right entitled to trade with the exceptions of blockades and contrabands to and between all ports of the enemy and in all articles, although the trade should not have been opened to them in time of peace. It was considered to be the right of every independent power to treat in time of peace with every other nation, for leave to trade with its colonies and to enter into any trade, whether new or old, that was not of itself illegal, and a violation of neutrality. One state had nothing to do with the circumstances or motives which induced another nation to open her ports. The trade must have a direct reference to the hostile efforts of the belligerents, like dealing in contraband, in order to render it a breach of neutrality. The rule of 1756, especially in respect to colonial trade, has also been attacked and defended by writers in this country with ability and learning, and though the rule would seem to have received the very general approbation of British lawyers and statesmen, yet it was not exempted from severe criticism, even in distinguished publications in that country. The principle of the rule of 1756 may, therefore, fairly be considered as one unsettled and doubtful, and open to future and vexed discussion. The Chief Justice of the United States, in the case of the Commerson, alluded to the rule, but purposely avoided expressing any opinion on the correctness of the principle. It is very possible that if the United States should hereafter attain that elevation of maritime power and influence which their rapid growth and great resources seem to indicate, and which shall prove sufficient to render it expedient for her maritime enemy, if any such enemy shall ever exist, to open all his domestic trade to enterprising neutrals, we might be induced to feel more sensibly than we have hitherto done the weight of the arguments of the foreign jurists in favor of the policy and equity of the rule. Sailing under foreign flag. Sailing under the flag and pass of an enemy is another mode by which a hostile character may be affixed to property, for if a neutral vessel enjoys the privileges of a foreign character, she must expect, at the same time, to be subject to the inconveniences attaching to that character. This rule is necessary to prevent the fraudulent mask of enemies' property, but a distinction is made in the English cases between the ship and the cargo. Some countries have gone so far as to make the flag and pass of the ship conclusive on the cargo also, but the English courts have never carried the principle to that extent as to cargoes laden before the war. The English rule is to hold the ship bound by the character imposed upon it by the authority of the government from which all the documents issue. But goods which have no such dependence upon the authority of the state may be differently considered, and if the cargo be laden in time of peace, though documented as foreign property in the same manner as the ship, the sailing under a foreign flag and pass has not been held conclusive as to the cargo. The doctrine of the courts in this country has been very strict on this point, and it has been frequently decided that sailing under the license and passport of protection of the enemy, in furtherance of his views and interests, was, without regard to the object of the voyage or the port of destination, such an act of illegality as subjected both ship and cargo to confiscation as prize of war. The federal courts placed the objection to these licenses on the ground of a pacific dealing with the enemy, and as amounting to a contract that the party to whom the license is given should for that voyage withdraw himself from the war and enjoy the repose and blessings of peace. The illegality of such an intercourse was strongly condemned, and it was held that the moment the vessel sailed on a voyage with an enemy's license on board, the offense was irrevocably committed and consummated, and that the delictum was not done away with even by the termination of the voyage, but the vessel and cargo might be seized after arrival in a port of the United States and condemned as lawful prize. Property in transitu. Having thus considered the principal circumstances which have been held by the courts of international law to impress a hostile character upon commerce, it may be here observed that property which has a hostile character at the commencement of the voyage cannot change that character by assignment while it is in transitu, so as to protect it from capture. This would lead to fraudulent contrivances to protect the property from capture by colorable assignments to neutrals. During peace, a transfer in transitu may be made, but when war is existing or impending, the belligerent rule applies, and the ownership of the property which was hostile at the commencement of the voyage is deemed to continue as it was at the time of the shipment until actual delivery. This illegality of transfer, during or in contemplation of war, is for the sake of the belligerent right, and to prevent secret transfers from the enemy to neutrals in fraud of that right, and upon conditions and reservations which it might be impossible to detect. So, property shipped from a neutral to the enemy's country under a contract to become the property of the enemy on arrival may be taken in transitu as enemy's property, for capture is considered as delivery. The captor, by the rights of war, stands in the place of the enemy. The prize courts will not allow a neutral consignor and belligerent consignee, by a special agreement, to change the ordinary rule of peace, by which goods ordered and delivered to the master are considered as delivered to the consignee. All such agreements are held to be constructively fraudulent, and if they could operate, they would go to cover all belligerent property while passing between a belligerent and a neutral country, since the risk of capture would be laid alternately on the consignor or consignee, as the neutral factor should happen to stand in the one or the other of those relations. These principles of the English Admiralty have been explicitly recognized and acted upon by the prize courts in this country. The great principles of national law were held to require that, in war, enemy's property should not change its hostile character in transitu, and that no secret liens, no future elections, no private contracts looking to future events should be able to cover private property while sailing on the ocean. Captors disregard all equitable liens on enemy's property, and lay their hands on the gross tangible property, and rely on the simple title in the name and possession of the enemy. If they were to open the door to equitable claims, there would be no end to discussion and imposition, and the simplicity and celerity of proceedings in prize courts would be lost. All reservations of risk to the neutral consignors, in order to protect belligerent consignees, are held to be fraudulent, and these numerous and strict rules of the maritime jurisprudence of the prize courts are intended to uphold the rights of lawful maritime capture and to prevent frauds, and preserve candor and good faith in the intercourse between belligerents and neutrals. The modern cases contain numerous and striking instances of the acuteness of the captors in tracking out deceit and of the dexterity of the claimants in eluding investigation. End of section 7. Section 8 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 5. Of the Rights of Belligerent Nations in Relation to Each Other. Part 1. The end of war is to procure by force the justice which cannot otherwise be obtained, and the law of nations allows the means requisite to the end. The persons and property of the enemy may be attacked and captured, or destroyed, when necessary to procure reparation or security. There is no limitation to the career of violence and destruction if we follow the earlier writers on this subject, who have paid too much deference to the violent maxims and practices of the ancients and the usages of the Gothic ages. They have considered a state of war as a dissolution of all moral ties, and a license for every kind of disorder and intemperate fierceness. An enemy was regarded as a criminal and an outlaw, who had forfeited his rights, and whose life, liberty, and property lay at the mercy of the conqueror. Every thing done against an enemy was held to be lawful. He might be destroyed, though unarmed and defenseless. Fraud might be employed as well as force, and force without any regard to the means. But these barbarous rights of war have been questioned and checked in the progress of civilization. Public opinion, as it becomes enlightened and refined, condemns all cruelty and all wanton destruction of life and property as equally useless and injurious, and it controls the violence of war by the energy and severity of its reproaches. Ancient rules of war condemned. Grotius, even in opposition to many of his own authorities, and under a due sense of the obligations of religion and humanity, placed bounds to the ravages of war, and mentioned that many things were not fit and commendable, though they might be strictly lawful, and that the law of nature forbade what the law of nations, meaning thereby the practice of nations, tolerated. He held that the law of nations prohibited the use of poisoned arms, or the employment of assassins, or violence to women, or to the dead, or making slaves of prisoners, and the moderation which he inculcated had a visible influence upon the sentiments and manners of Europe. Under the sanction of his great authority, men began to entertain more enlarged views of national policy, and to consider a mild and temperate exercise of the rights of war to be dictated by an enlightened self-interest as well as by the precepts of Christianity, and, notwithstanding some subsequent writers, as Binkershoek and Wolfius, restored war to all its horrors by allowing the use of poison and other illicit arms, yet such rules became abhorrent to the cultivated reason and growing humanity of the Christian nations. Montesquieu insisted that the laws of war gave no other power over a captive than to keep him safely, and that all unnecessary rigor was condemned by the reason and conscience of mankind. Rutherford has spoken to the same effect, and Martins enumerates several modes of war and species of arms as being now held unlawful by the laws of war. Vattel has entered largely into the subject, and he argues, with great strength of reason and eloquence, against all unnecessary cruelty, all base revenge, and all mean and perfidious warfare, and he recommends his benevolent doctrines by the precepts of exalted ethics and sound policy, and by illustrations drawn from some of the most pathetic and illustrious examples. Plunder on land. There is a marked difference in the rights of war carried on by land and at sea. The object of a maritime war is the destruction of the enemy's commerce and navigation, in order to weaken and destroy the foundations of his naval power. The capture or destruction of private property is essential to that end, and it is allowed in maritime wars by the law and practice of nations. But there are great limitations imposed upon the operations of war by land, though depredations upon private property and despoiling and plundering the enemy's territory are still too prevalent, especially when the war is assisted by irregulars. Such conduct has been condemned in all ages by the wise and virtuous, and it is usually severely punished by those commanders of disciplined troops who have studied war as a science and are animated by a sense of duty or the love of fame. We may infer the opinion of Xenophon on this subject, and he was a warrior as well as a philosopher, when he states in the Chiropedia that Cyrus of Persia gave orders to his army, when marching upon the enemy's borders, not to disturb the cultivators of the soil, and there have been such ordinances in modern times for the protection of innocent and pacific pursuits. Vattel condemns very strongly the spoliation of a country without palpable necessity, and he speaks with a just indignation of the burning of the Palatinate by Turenne under the cruel instructions of Louvois, the war minister of Louis XIV. The general usage now is, not to touch private property upon land without making compensation, unless in special cases dictated by the necessary operations of war, or when captured in places carried by storm, and which repelled all the overtures for a capitulation. Contributions are sometimes levied upon a conquered country in lieu of confiscation of property, and as some indemnity for the expenses of maintaining order and affording protection. If the conqueror goes beyond these limits wantonly, or when it is not clearly indispensable to the just purposes of war, and seizes private property of pacific persons for the sake of gain, and destroys private dwellings or public edifices devoted to civil purposes only, or makes war upon monuments of art and models of taste, he violates the modern usages of war, and is sure to meet with indignant resentment, and to be held up to the general scorn and detestation of the world. Law of retaliation. Cruelty to prisoners and barbarous destruction of private property will provoke the enemy to severe retaliation upon the innocent. Retaliation is said by Rutherford not to be a justifiable cause for putting innocent prisoners or hostages to death, for no individual is chargeable by the law of nations with the guilt of a personal crime, merely because the community of which he is a member is guilty. He is only responsible as a member of the state, in his property, for reparation and damages for the acts of others, and it is on this principle that by the law of nations private property may be taken and appropriated in war. Retaliation, to be just, ought to be confined to the guilty individuals, who may have committed some enormous violation of public law. On this subject of retaliation, Professor Martins is not so strict. While he admits that the life of an innocent man cannot be taken, unless in extraordinary cases, he declares that cases will sometimes occur when the established usages of war are violated, and there are no other means except the influence of retaliation of restraining the enemy from further excesses. Vattel speaks of retaliation as a sad extremity, and it is frequently threatened without being put in execution, and probably without the intention to do it, and in hopes that fear will operate to restrain the enemy. Instances of resolutions to retaliate on innocent prisoners of war occurred in this country during the Revolutionary War as well as during the War of 1812, but there was no instance in which retaliation, beyond the measure of severe confinement, took place in respect to prisoners of war. Although a state of war puts all the subjects of the one nation in a state of hostility with those of the other, yet, by the customary law of Europe, every individual is not allowed to fall upon the enemy. If subjects confine themselves to simple defense, they are to be considered as acting under the presumed order of the state, and are entitled to be treated by the adversary as lawful enemies, and the captures which they make in such a case are allowed to be lawful prize. But they cannot, as banded marauders, engage upon land in offensive hostilities without the express permission of their sovereign, and if they so engage when they have not a regular commission, as evidence of that consent, they run the hazard of being treated by the enemy as lawless banditti, not entitled to the protection of the mitigated rules of modern warfare. It was the received opinion in ancient Rome, in the times of Cato and Cicero, that one who was not regularly enrolled as a soldier could not lawfully kill an enemy. But the law of Solon, by which individuals were permitted to form associations for plunder, was afterwards introduced into the Roman law, and has been transmitted to us as part of their system. During the lawless confusion of the feudal ages, the right of making reprisals was claimed and exercised without a public commission. Commission to cruise necessary. It was not until the 15th century that commissions were held necessary, and were issued to private subjects in time of war, and that subjects were forbidden to fit out vessels to cruise against enemies without license. There were ordinances in Germany, France, Spain, and England to that effect. It is now the practice of maritime states to make use of the voluntary aid of individuals against their enemies as auxiliary to the public force, and Binkerscherk says that the Dutch formerly employed no vessels of war but such as were owned by private persons, and to whom the government allowed a proportion of the captured property, as well as indemnity from the public treasury. Vessels are now fitted out and equipped by private adventurers, at their own expense, to cruise against the commerce of the enemy. they are duly commissioned, and it is said not to be lawful to cruise without a regular commission. Sir Matthew Hale held it to be depredation in a subject to attack the enemy's vessels, except in his own defense, without a commission. The subject has been repeatedly discussed in the Supreme Court of the United States, and the doctrine of the law of nations is considered to be that private citizens cannot acquire a title to hostile property unless seized under a commission, but they may still lawfully seize hostile property in their own defense. If, assuming the offensive on the high seas, they depredate upon the enemy without a commission, they act upon their peril, and are liable to be punished by their own sovereign. But the enemy are not warranted to consider them as criminals, and as respects the enemy, they violate no rights by capture. Such hostilities, without a commission, are, however, contrary to usage, and exceedingly irregular and dangerous, and they would probably expose the party to the unchecked severity of the enemy. But they are not acts of piracy unless committed in time of peace. Vattel, indeed, says that private ships of war, without a regular commission, are not entitled to be treated like captures made in a formal war. The observation is rather loose, and the weight of authority undoubtedly is that non-commissioned vessels of a belligerent nation may at all times capture hostile ships without being deemed by the law of nations pirates. They are lawful combatants, but they have no interest in the prizes they may take, and the property will remain subject to condemnation in favor of the government of the captor as droit of the Admiralty. It is said, however, that in the United States the property is not strictly and technically condemned upon that principle, but jure publicae, and it is the settled law of the United States that all captures made by non-commissioned captors are made for the government. Privateering. In order to encourage privateering, it is usual to allow the owners of private armed vessels to appropriate to themselves the property, or a large portion of the property they may capture, and to afford them and the crews other facilities and rewards for honorable and successful efforts. This depends upon the municipal regulations of each particular power, and as a necessary precaution against abuse, the owners of privateers are required by the ordinances of the commercial states to give adequate security that they will conduct the crews according to the laws and usages of war and the instructions of the government, and that they will regard the rights of neutrals and bring their prizes in for adjudication. These checks are essential to the character and safety of maritime nations. Privateering, under all the restrictions which have been adopted, is very liable to abuse. The object is not fame or chivalric warfare, but plunder and profit. The discipline of the crews is not apt to be of the highest order, and privateers are often guilty of enormous excesses, and become the scourge of neutral commerce. They are sometimes manned and officered by foreigners, having no permanent connection with the country or interest in its cause. This was a complaint made by the United States in 1819 in relation to irregularities and acts of atrocity committed by private armed vessels sailing under the flag of Buenos Aires. Under the best regulations, the business tends strongly to blunt the sense of private right and to nourish a lawless and fierce spirit of rapacity. Efforts have been made from time to time to abolish the practice. In the Treaty of Amity and Commerce between Prussia and the United States in 1785, it was stipulated that in case of war neither party should grant commissions to any private armed vessels to attack the commerce of the other. But the spirit and policy of maritime warfare will not permit such generous provisions to prevail. That provision was not renewed with the renewal of the treaty. A similar attempt to put an end to the practice was made in the agreement between Sweden and Holland in 1675, but the agreement was not performed. The French legislature, soon after the breaking out of the war with Austria in 1792, passed a decree for the total suppression of privateering. But that was a transitory act, and it was soon swept away in the tempest of the Revolution. The efforts to stop the practice have been very feeble and fruitless, notwithstanding that enlightened and enlarged considerations of national policy have shown it to be, for the general benefit of mankind, to surrender the licentious practice, and to obstruct, as little as possible, the freedom and security of commercial intercourse among the nations. Damages for illegal acts. It has been a question whether the owners and officers of private armed vessels were liable, in damages, for illegal conduct beyond the amount of the security given. Binkersherk has discussed this point quite at large, and he concludes that the owner, master, and sureties are jointly and severally liable in solido for the damages incurred, and that the master and owners are liable to the whole extent of the injury, though it may exceed the value of the privateer and her equipment, and the sureties are bound only to the amount of the sums for which they become bound. This rule is liable to the modifications of municipal regulations, and though the French law of prize was formerly the same as the rule laid down by Binkersherk, yet the new commercial code of France exempts the owners of private armed vessels in time of war from responsibility for trespasses at sea, beyond the amount of the security they may have given, unless they were accomplices in the tort. The English statute of 7 George II, chapter 15, is to the same effect, in respect to embezzlements in the merchant's service. It limits the responsibility to the amount of the vessel and freight, but it does not apply to privateers in time of war, and where there is no positive local law on the subject, and there is none with us, the general principle is that the liability is commensurate with the injury. This was the rule, as declared by the Supreme Court of the United States in Del Call v. Arnold, and though that case has since been shaken as to other points, it has not been disturbed as to the point before us. We may, therefore, consider it to be a settled rule of law and equity, that the measure of damages is the value of the property unlawfully injured or destroyed, and that each individual owner is responsible for the entire damages, and not rateably pro tanto. Vattel admits that an individual may, with a safe conscience, serve his country by fitting out privateers, but he holds it to be inexcusable and base to take a commission from a foreign prince to prey upon the subjects of a state in amity with his native country. The laws of the United States have made ample provision on this subject, and they may be considered as in affirmance of the law of nations, and as prescribing specific punishment for acts which were before unlawful. An act of Congress prohibits citizens to accept, within the jurisdiction of the United States, a commission, or for any person not transiently within the United States, to consent to be retained or enlisted to serve a foreign state in war against a government in amity with us. It likewise prohibits American citizens from being concerned, without the limits of the United States, in fitting out or otherwise assisting any private vessel of war to cruise against the subjects of friendly powers. Similar prohibitions are contained in the laws of other countries, and the French ordinance of the Marine of 1681 treated such acts as piratical. The better opinion is that a cruiser furnished with commissions from two different powers is liable to be treated as a pirate, for though the two powers may be allies, yet one of them may be in amity with a state with whom the other is at war. In the various treaties between the powers of Europe in the last 2 centuries, and in the several treaties between the United States and France, Holland, Sweden, Prussia, Great Britain, Spain, Colombia, Chile, etc., it is declared that no subject or citizen of either nation shall accept a commission or letter of marque to assist an enemy in hostilities against the other, under pain of being treated as a pirate. End of section 8. Section 9 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Lecture 4, of the Various Kinds of Property Liable to Capture, Part 2. Prizes. The right to all captures vests primarily in the sovereign, and no individual can have any interest in a prize, whether made by a public or private armed vessel, but what he receives under the grant of the state. This is a general principle of public jurisprudence, bello parta sedunt re publicae, and the distribution of the proceeds of prizes depends upon the regulations of each state, and unless the local laws have otherwise provided, the prizes vest in the sovereign. But the general practice, under the laws and ordinances of the belligerent governments, is to distribute the proceeds of captured property, when duly passed upon, and condemned as prize, and whether captured by public or private commissioned vessels, among the captors as a reward for bravery and a stimulus to exertion. When a prize is taken at sea, it must be brought with due care into some convenient port for adjudication by a competent court. Though, strictly speaking, as between the belligerent parties, the title passes and is vested when the capture is complete, and that was formerly held to be complete and perfect when the battle was over and the spes recuperandi was gone. Voet, in his Commentaries upon the Pandects and the authors he refers to, maintain with great strength, as Lord Mansfield observed in Goss v. Withers, that occupation of itself transferred the title to the captor per solum occupationem dominium praede hostibus acquiri. The question never arises but between the original owner and a neutral purchasing from the captor, and between the original owner and a recaptor. If a captured ship escapes from the captor, or is retaken, or if the owner ransoms her, his property is thereby revested. But if neither of these events happens, the question as to the change of title is open to dispute, and many arbitrary lines have been drawn, partly from policy, to prevent too easy dispositions of the property to neutrals, and partly from equity, to extend the jus polimini in favor of the owner. Grotius, and many other writers, and some marine ordinances, such as those of Louis XIV and of Congress during the American War, made 24 hours quiet possession by the enemy the test of title by capture. Binkershoek says that such a rule is repugnant to the laws and customs of Holland, and he insists that a firm possession at any time vests the property in the captor, and that ships and goods brought infra praesidia do most clearly change the property. But by the modern usage of nations, neither the 24 hours possession nor the bringing of the prize infra praesidia is sufficient to change the property in the case of a maritime capture. A judicial inquiry must pass upon the case, and the present enlightened practice of the commercial nations has subjected all such captures to the scrutiny of judicial tribunals as the only sure way to furnish due proof that the seizure was lawful. The property is not changed in favor of a neutral vendee or recaptor so as to bar the original owner, until a regular sentence of condemnation has been pronounced by some court of competent jurisdiction belonging to the sovereign of the captor, and the purchaser must be able to show documentary evidence of that fact to support his title. Until the capture becomes invested with the character of prize by a sentence of condemnation, the right of property is in abeyance, or in a state of legal sequestration. It cannot be alienated or disposed of, but the possession of it by the government of the captor is a trust for the benefit of those who may be ultimately entitled. This salutary rule, and one so necessary to check irregular conduct and individual outrage, has been long established in the English Admiralty, and it is now everywhere recognized as the law and practice of nations. The condemnation must be pronounced by a prize court of the government of the captor, sitting either in the country of the captor or of his ally. The prize court of an ally cannot condemn. Prize or no prize is a question belonging exclusively to the courts of the country of the captor. The reason of this rule is said to be that the sovereign of the captors has a right to inspect their behavior, for he is answerable to other states for the acts of the captor. The prize court of the captor may sit in the territory of the ally, but it is not lawful for such a court to act in a neutral territory. Neutral ports are not intended to be auxiliary to the operations of the power at war, and the law of nations has clearly ordained that a prize court of a belligerent captor cannot exercise jurisdiction in a neutral country. This prohibition rests not merely on the unfitness and danger of making neutral ports the theater of hostile proceedings, but it stands on the ground of the usage of nations. It was for some time supposed that a prize court, though sitting in the country of its own sovereign or of his ally, had no jurisdiction over prizes lying in a neutral port, because the court wanted that possession which was deemed essential to the exercise of a jurisdiction in a proceeding in rem. The principle was admitted to be correct by Sir William Scott, in the case of the Henrik and Maria, and he acted upon it in a prior case. But he considered that the English Admiralty had gone too far in supporting condemnations in England of prizes abroad in a neutral port to permit him to recall the vicious practice of the court to the acknowledged principle, and the English rule is now definitively settled, agreeably to the old usage and the practice of other nations. The Supreme Court of the United States has followed the English rule, and it has held valid the condemnations by a belligerent court of prizes carried into a neutral port and remaining there. This was deemed the most convenient practice for neutrals as well as for the parties at war, and though the prize was in fact within a neutral jurisdiction, it was still to be deemed under the control or sub potestate of the captor. Ransom. Sometimes circumstances will not permit property captured at sea to be sent into port, and the captor in such cases may either destroy it or permit the original owner to ransom it. It was formerly the general custom to redeem property from the hands of the enemy by ransom, and the contract is undoubtedly valid when municipal regulations do not intervene. It is now but little known in the commercial law of England, for several statutes in the reign of George III absolutely prohibited to British subjects the privilege of ransom of property captured at sea, unless in a case of extreme necessity, to be judged of by the Court of Admiralty. A ransom bill, when not locally prohibited, is a war contract protected by good faith and the law of nations, and notwithstanding that the contract is considered in England as tending to relax the energy of war and deprive cruisers of the chance of recapture, it is in many views highly reasonable and humane. Other maritime nations regard ransoms as binding, and to be classed among the few legitimate commercia belli. They have never been prohibited in this country, and the Act of Congress of August 2, 1813, interdicting the use of British licenses or passes, did not apply to the contract of ransom. The effect of a ransom is equivalent to a safe conduct granted by the authority of the state to which the captor belongs, and it binds the commanders of other cruisers to respect the safe conduct thus given, and under the implied obligation of the Treaty of Alliance, it binds equally the cruisers of the allies of the captor's country. From the very nature of the connection between allies, their compacts with the common enemy must bind each other when they tend to accomplish the objects of the alliance. If they did not, the ally would reap all the fruits of the compact without being subject to the terms and conditions of it, and the enemy with whom the agreement was made would be exposed, in regard to the ally, to all the disadvantages of it, without participating in the stipulated benefits. Such an inequality of obligation is contrary to every principle of reason and justice. The safe conduct implied in a ransom bill requires that the vessel should be found within the course prescribed, and within the time limited by the contract, unless forced out of her course by stress of weather or unavoidable necessity. If the vessel ransomed perishes by a peril of the sea before arrival in port, the ransom is nevertheless due, for the captor has not insured the prize against the perils of the sea, but only against recapture by cruisers of his own nation or of the allies of his country. If there should be a stipulation in the ransom contract that the ransom should not be due if the vessel was lost by sea perils, the provision ought to be limited to total losses by shipwreck, and not to mere stranding, which might lead to frauds in order to save the cargo at the expense of the ship. If the vessel should be recaptured out of the route prescribed by the contract for her return, or after the time allowed for her return, and be adjudged lawful prize, it has been made a question whether the debtors of the ransom are discharged from their contract. Vallon says that according to the constant practice, the debtors are discharged in such case, and the price of the ransom is deducted from the proceeds of the prize and given to the first captor, and the residue goes to the second taker. So, if the captor himself should afterwards be taken by an enemy's cruiser, together with his ransom bill, the ransom becomes part of the lawful conquest of the enemy, and the debtors of the ransom are consequently discharged from the contract under the ransom bill. In the case of Ricard versus Bettenham, an English vessel was captured by a French privateer in the War of 1756 and ransomed, and a hostage given as a security for the payment of the ransom bill. The hostage died while in possession of the French, and it was made a question in the K.B. in a suit brought upon the ransom bill after the peace, whether the death of the hostage discharged the contract, and whether the alien could sue on the ransom bill in the English courts. It was shown that such a contract was valid among the other nations of Europe, and that the owner of the bill was entitled to sue upon it, and that it was not discharged by the death of the hostage, who was taken as mere collateral security, and the plaintiff was accordingly allowed to recover. But it has been since decided, and it is now understood to be the law, that during war, and while the character of alien enemy continues, no suit will lie in the British courts by the enemy in proper person on a ransom bill, notwithstanding it is a contract arising jure belli. The remedy to enforce payment of the ransom bill for the benefit of the enemy captor is by an action by the imprisoned hostage in the courts of his own country for the recovery of his freedom. This severe technical objection would seem to be peculiar to the British courts, for it was shown in the case of Ricard v. Bettenham to be the practice in France and Holland to sustain such actions by the owner of the ransom contract. Lord Mansfield considered the contract as worthy to be sustained by sound morality and good policy, and as governed by the law of nations and the eternal rules of justice. The practice in France, when a French vessel has been ransomed and a hostage given to the enemy, is for the officers of the Admiralty to seize the vessel and her cargo on her return to port, in order to compel the owners to pay the ransom debt, and relieve the hostage, and this is of course dictated by a prompt and liberal sense of justice. The recapture of the ransom bill, according to Vallon, puts an end to the claim of the captor. He may be deprived of the entire benefit of his prize, as well as of the ransom bill, either by recapture or rescue, and the questions arising on them lead to the consideration of post limine and salvage. Upon recapture from pirates, the property is to be restored to the owner on the allowance of a reasonable compensation to the retaker in the nature of salvage, for it is a principle of the law of nations that a capture by pirates does not, like a capture by an enemy in solemn war, change the title, or divest the original owner of his right to the property, and it does not require the doctrine of post limine to restore it. In France, property may be reclaimed by the owner within a year and a day, but in some other countries, and Grotius mentions Spain and Venice, the rule formerly was that the whole property recaptured from pirates went to the retaker, and this rule was founded on the consideration of the desperate nature of the recovery. Jus post limine. The jus post limine was a fiction of the Roman law by which persons or things taken by the enemy were restored to their former state upon coming again under the power of the nation to which they formerly belonged. Post lineum flingit eum qui captus est in civitate semper fuisse. It is a right recognized by the law of nations and contributes essentially to mitigate the calamities of war. When, therefore, property taken by the enemy is either recaptured or rescued from him by the fellow subjects or allies of the original owner, it does not become the property of the recaptor or rescuer as if it had been a new prize, but it is restored to the original owner by right of post limine upon certain terms. Movables are not entitled by the strict rules of the laws of nations to the full benefit of post limine unless retaken from the enemy promptly after the capture, for then the original owner neither finds a difficulty in recognizing his effects nor is presumed to have relinquished them. Real property is easily identified, and therefore more completely within the right of post limine, and the reason for a stricter limitation of it in respect to personal property arises from its transitory nature and the difficulty of identifying it, and the consequent presumption that the original owner had abandoned the hope of recovery. This right does not take effect in neutral countries, because the neutral nation is bound to consider the war on each side as equally just, so far as relates to its effects, and to look upon every acquisition made by either party as a lawful acquisition, with the exception of cases where the capture itself is an infringement of the jurisdiction or rights of the neutral power. If one party was allowed, in a neutral territory, to enjoy the right of claiming goods taken by the other, it would be a departure from the duty of neutrality. The right of post limine takes place, therefore, only within the territories of the nation of the captors, or of his ally, and if a prize be brought into a neutral port by the captors, it does not return to the former owner by the law of post limine, because neutrals are bound to take notice of the military right which possession gives, and which is the only evidence of right acquired by military force, as contradistinguished from civil rights and titles. They are bound to take the fact for the law. Strictly speaking, there is no such thing as a marine tort between belligerents. All captures are deemed lawful, and they have never been held within the cognizance of the prize tribunals of neutral nations. With respect to persons, the right of post limine takes place even in a neutral country, so that if a captor brings his prisoners into a neutral port, he may, perhaps, confine them on board his ship, as being, by fiction of law, part of the territory of his sovereign, but he has no control over them on shore. In respect to real property, the acquisition by the conqueror is not fully consummated until confirmed by the treaty of peace, or by the entire submission or destruction of the state to which it belonged. If it be recovered by the original sovereign, it returns to the former proprietor, notwithstanding it may, in the meantime, have been transferred by purchase. The purchaser is understood to have taken the property at the hazard of a recovery or reconquest before the end of the war. But if the real property, as a town or portion of the territory, for instance, be ceded to the conqueror by the treaty of peace, the right of post limine is gone forever, and a previous alienation by the conqueror would be valid. In a land war, movable property, after it has been in complete possession of the enemy for 24 hours, and which goes by the name of booty and not prize, becomes absolutely his, without any right of post limine in favor of the original owner, and much more ought this species of property to be protected from the operation of the rule of post limine when it has not only passed into the complete possession of the enemy, but been bona fide transferred to a neutral. By the ancient and strict doctrine of the law of nations, captures at sea fell under the same rule as other movable property taken on land, and goods so taken were not recoverable by the original owner from the rescuer or retaker. But the municipal regulations of most states have softened the rigor of the law of nations on this point by an equitable extension of the right of post limine as against a recaption by their own subjects. The ordinances of several of the continental powers confined the right of restoration on recaption to cases where the property had not been in possession of the enemy above 24 hours. This was the rule of the French ordinance of 1681, but now the right is everywhere understood to continue until sentence of condemnation, and no longer. It is also a rule on this subject that if a treaty of peace makes no particular provisions relative to captured property, it remains in the same condition in which the treaty finds it, and it is tacitly conceded to the possessor. The right of post limine no longer exists after the conclusion of the peace. It is a right which belongs exclusively to a state of war, and therefore a transfer to a neutral before the peace, even without a judicial sentence of condemnation, is valid if there has been no recovery or recaption before the peace. The intervention of peace cures all defects of title, and vests a lawful possession in the neutral, equally as the title of the enemy captor himself is quieted by the intervention of peace. The title in the hands of such a neutral could not be defeated in favor of the original owner, even by his subsequently becoming an enemy. It would only be liable, with his other property, to be seized as prize of war. Every power is obliged to conform to these rules of the law of nations relative to post limine, where the interests of neutrals are concerned. But in cases arising between her own subjects, or between them and those of her allies, the principle may undergo such modifications as policy dictates. Thus, by several English statutes, the maritime right of post limine, as among English subjects, subsists to the end of the war, and therefore ships or goods captured at sea by an enemy and retaken at any period during the war, and whether before or after sentence of condemnation, are to be restored to the original proprietor on securing to the recaptors certain rates of salvage as a compensation or reward for the service they have performed. The maritime law of England gives the benefit of this liberal rule of restitution with respect to the recaptured property of her own subjects to her allies, unless it appears that they act on a less liberal principle, and then it treats them according to their own measure of justice. The allotment of salvage on recapture or rescue is a question not of municipal law merely, except as to the particular rates of it. It is a question of the jus gentium, when the subjects of allies or neutral states claim the benefit of the recaption. The restitution is a matter not of strict right after the property has been vested in the enemy, but one of favor and relaxation, and the belligerent recaptor has a right to annex a reasonable condition to his liberality. Neutral property retaken from the enemy is usually restored, without the payment of any salvage, unless, from the nature of the case or the usages of the enemy, there was a probability that the property would have been condemned if carried into the enemy's ports, and in that case a reasonable salvage ought to be allowed, for a benefit has been conferred. The United States, by the Act of Congress of the 3rd of March, 1800, directed restoration of captured property at sea to the foreign and friendly owner on the payment of reasonable salvage, but the act was not to apply when the property had been condemned as prize by a competent court before recapture, nor when the foreign government would not restore the goods or vessels of the citizens of the United States under the like circumstances. The statute continued the jus post limine until the property was divested by a sentence of condemnation and no longer, and this was the rule adopted in the English courts before the extension of the right of post limine by statutes in the reigns of George II and George III. End of section 9.
Section 10 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1. By James Kent. Section 10. Part 1 of the Law of Nations, of the General Rights and Duties of Neutrals. The rights and duties which belong to a state of neutrality form a very interesting title in the Code of International Law. They ought to be objects of particular study in this country, inasmuch as it is our true policy to cherish a spirit of peace, and to keep ourselves free from those political connections which would tend to draw us into the vortex of European contests. A nation that maintains a firm and scrupulously impartial neutrality, and commands the respect of all other nations by its prudence, justice, and good faith, has the best chance to preserve unimpaired the blessings of its commerce, the freedom of its institutions, and the prosperity of its resources. Belligerent nations are interested in the support of the just rights of neutrals, for the intercourse which is kept up by means of their commerce contributes greatly to mitigate the evils of war. The public law of Europe has established the principle that, in time of war, countries not parties to the war nor interposing in it shall not be materially affected by its action, but they shall be permitted to carry on their accustomed trade under the few necessary restrictions which we shall hereafter consider. Neutrals must be impartial. It belongs not to a common friend to judge between the belligerent parties, or to determine the question of right between them. The neutral is not to favor one of them to the detriment of the other, and it is an essential character of neutrality to furnish no aids to one party which the neutral is not equally ready to furnish to the other. A nation which would be admitted to the privileges of neutrality must perform the duties it enjoins. Even the loan of money to one of the belligerent parties is considered to be a violation of neutrality. A fraudulent neutrality is no neutrality. But the neutral duty does not extend so far as to prohibit the fulfillment of antecedent engagements, which may be kept consistently with an exact neutrality, unless they go so far as to require the neutral nation to become an associate in the war. If a nation be under a previous stipulation made in time of peace, to furnish a given number of ships or troops to one of the parties at war, the contract may be complied with, and the state of peace preserved. In 1788, Denmark furnished ships and troops to Russia in her war with Sweden in consequence of a previous treaty prescribing the amount, and this was declared by Denmark to be an act consistent with a spirit of amity and commercial intercourse with Sweden. It was answered by the latter in her counter-declaration that though she could not reconcile the practice with the law of nations, yet she embraced the Danish declaration and confined her hostility, so far as Denmark was concerned, to the Danish auxiliaries furnished to Russia. But if a neutral power be under contract to furnish succors to one party, he is said not to be bound if his ally was the aggressor,
and in this solitary instance the neutral may examine into the merits of the war, so far as to see whether the casus foederis exists. An inquiry of this kind, instituted by the party to the contract, for the purpose of determining on its binding obligation, holds out strong temptations to abuse, and in the language of Mr. Jenkinson, when the execution of guarantees depends on questions like these, it will never be difficult for an ally who hath a mind to break his engagements to find an evasion to escape. Neutral territory inviolable. A neutral has a right to pursue his ordinary commerce, and he may become the carrier of the enemy's goods without being subject to any confiscation of the ship or of the neutral articles on board, though not without the risk of having the voyage interrupted by the seizure of the hostile property. As the neutral has a right to carry the property of enemies in his own vessel, so, on the other hand, his own property is inviolable, though it be found in the vessels of enemies. But the general inviolability of the neutral character goes further than merely the protection of neutral property. It protects the property of the belligerents when within the neutral jurisdiction. It is not lawful to make neutral territory the scene of hostility, or to attack an enemy while within it, and if the enemy be attacked, or any capture made, under neutral protection, the neutral is bound to redress the injury and effect restitution. The books are full of cases recognizing this principle of neutrality. In the year 1793, the British ship Grange was captured in Delaware Bay by a French frigate, and, upon due complaint, the American government caused the British ship to be promptly restored. So, in the case of the Anna, the sanctity of neutral territory was fully asserted and vindicated, and restoration made of property captured by a British cruiser near the mouth of the Mississippi and within the jurisdiction of the United States. It is a violation of neutral territory for a belligerent ship to take her station within it in order to carry on hostile expeditions from thence, or to send her boats to capture vessels being beyond it. No use of neutral territory for the purpose of war can be permitted. This is the doctrine of the government of the United States. It was declared judicially in England in the case of the Twee Gebroeders, and though it was not understood that the prohibition extended to remote objects and uses, such as procuring provisions and other innocent articles which the law of nations tolerated, yet it was explicitly declared that no proximate acts of war were in any manner to be allowed to originate on neutral ground, and for a ship to station herself within the neutral line and send out her boats on hostile enterprises was an act of hostility much too immediate to be permitted. No act of hostility is to be commenced on neutral ground. No measure is to be taken that will lead to immediate violence. The neutral is to carry himself with perfect equality between both belligerents, giving neither the one nor the other any advantage, and if the respect due to neutral territory be violated by one party, without being promptly punished by just animadversion, it would soon provoke a similar treatment from the other party, and the neutral ground would become the theater of war. If a belligerent cruiser inoffensively passes over a portion of water lying within neutral jurisdiction, that fact is not usually considered such a violation of the territory as to affect and invalidate an ulterior capture made beyond it. The passage of ships over territorial portions of the sea is a thing less guarded than the passage of armies on land, because less inconvenient, and permission to pass over them is not usually required or asked. To vitiate a subsequent capture, the passage must at least have been expressly refused, or the permission to pass obtained under false pretenses. The right of a refusal of a pass over neutral territory to the troops of a belligerent power depends more upon the inconvenience falling on the neutral state than on any injustice committed to the third party, who is to be affected by the permission or refusal. It is no ground of complaint against the intermediate neutral state if it grants a passage to belligerent troops, though inconvenience may thereby ensue to the adverse belligerent. It is a matter resting in the sound discretion of the neutral power, who may grant or withhold the permission without any breach of neutrality. No belligerent power can claim the right of passage through a neutral territory unless founded upon a previous treaty, and it cannot be granted by a neutral where there is no antecedent treaty, unless an equality of privilege be allowed to both belligerents. This is the reasonable and just rule to be deduced from the opinions of jurists and the conventional law of modern nations. Binkershoek makes one exception to the general inviolability of neutral territory, and supposes that if an enemy be attacked on hostile ground, or in the open sea, and flee within the jurisdiction of a neutral state, the victor may pursue him dum fervet opus and seize his prize within the neutral state. He rests his opinion entirely on the authority and practice of the Dutch, and admits that he had never seen the distinction taken by the publicists or in the practice of nations. It appears, however, that Casaregus and several other foreign jurists mentioned by Azuni held a similar doctrine. But Dabreu, Valen, Emerigon, Vatel, Azuni, and others maintain the sounder doctrine that when the flying enemy has entered neutral territory, he is placed immediately under the protection of the neutral power. The same broad principle that would tolerate a forcible entrance upon neutral ground or waters in pursuit of the foe would lead the pursuer into the heart of a commercial port. There is no exception to the rule that every voluntary entrance into neutral territory with hostile purposes is absolutely unlawful. The neutral border must not be used as a shelter for making preparations to renew the attack, and though the neutral is not obliged to refuse a passage and safety to the pursued party, he ought to cause him to depart as soon as possible, and not permit him to lie by and watch his opportunity for further contest. This would be making the neutral country directly auxiliary to the war, and to the comfort and support of one party. In the case of the Anna, Sir William Scott was inclined to agree with Pinkershook to this extent, that if a vessel refused to submit to visitation and search, and fled within neutral territory, to places which were uninhabited, like the little mud islands before the mouth of the Mississippi, and the cruiser, without injury or annoyance to any person, should quietly take possession of his prey, he would not stretch the point so far on that account only as to hold the capture illegal. But in this case, as well as in every other case of the like kind, there is, in stricto jure, a violation of neutral jurisdiction, and the neutral power would have a right to insist on a restoration of the property. It was observed by the same high authority in another case, depending on a claim of territory, that when the fact is established it overrules every other consideration. The capture is done away, the property must be restored, notwithstanding that it may actually belong to the enemy. A neutral has no right to inquire into the validity of a capture, except in cases in which the rights of neutral jurisdiction were violated, and in such cases the neutral power will restore the property, if found in the hands of the offender, and within its jurisdiction, regardless of any sentence of condemnation by a court of a belligerent captor. It belongs solely to the neutral government to raise the objection to a capture and title founded on the violation of neutral rights. The adverse belligerent has no right to complain when the prize is duly libelled before a competent court. If any complaint is to be made on the part of the captured, it must be by his government to the neutral government for a fraudulent or unworthy or unnecessary submission to a violation of its territory, and such submission will naturally provoke retaliation. In the case of prizes brought within a neutral port, the neutral sovereign exercises jurisdiction so far as to restore the property of its own subjects illegally captured. And this is done, says Valen, by way of compensation for the asylum granted to the captor and his prize. It has been held in this country that foreign ships, offending against our laws, within our jurisdiction, may be pursued and seized upon the ocean, and rightfully brought into our ports for adjudication. The government of the United States was warranted by the law and practice of nations in the declarations made in 1793 of the rules of neutrality, which were particularly recognized as necessary to be observed by the belligerent powers in their intercourse with this country. These rules were that the original arming or equipping of vessels in our ports by any of the powers at war for military service was unlawful, and no such vessel was entitled to an asylum in our ports. The equipment by them of government vessels of war, in matters which, if done to other vessels, would be applicable equally to commerce or war, was lawful. The equipment by them of vessels fitted for merchandise and war, and applicable to either, was lawful. But if it were of a nature solely applicable to war, it was unlawful. And if the armed vessel of one nation should depart from our jurisdiction, no armed vessel, being within the same and belonging to an adverse belligerent power, should depart until 24 hours after the former, without being deemed to have violated the law of nations. Congress have repeatedly by statute made suitable provision for the support and due observance of similar rules of neutrality, and given sanction to the principle of them as being founded in the universal law of nations. It is declared to be a misdemeanor for any citizen of the United States, within the territory or jurisdiction thereof, to accept and exercise a commission to serve a foreign prince, state, colony, district, or people in war, by land or by sea, against any prince, state, colony, district, or people with whom the United States are at peace, or for any person except a subject or citizen of any foreign prince, state, colony, district, or people, transiently within the United States, on board of any foreign armed vessel within the territory or jurisdiction of the United States, to enlist or enter himself, or hire or retain another person to enlist or enter himself, or to go beyond the limits or jurisdiction of the United States, with intent to be enlisted or entered in the service of any foreign prince, state, colony, district, or people, as a soldier or mariner or seaman, or to fit out and arm, or to increase or augment the force of any armed vessel, with intent that such vessel be employed in the service of any foreign power at war with another power with whom we are at peace, or to begin or set on foot or provide or prepare the means for any military expedition or enterprise to be carried on from thence against the territory or dominions of any foreign prince or state or of any colony, district, or people with whom we are at peace, or to hire or enlist troops or seamen for foreign military or naval service, or to be concerned with fitting out any vessel, or cruise or commit hostilities in foreign service against a nation at peace with us. And the vessel in this latter case is made subject to forfeiture. The President of the United States is also authorized to employ force to compel any foreign vessel to depart, which by the law of nations or by treaty ought not to remain within the United States, and to employ the public force generally in enforcing the observance of the duties of neutrality prescribed by law. In the case of the Santissima Trinidad, it was decided that captures made by a vessel so illegally fitted out, whether a public or private armed ship, were torts, and that the original owner was entitled to restitution if the property was brought within our jurisdiction, but that an illegal outfit did not affect a capture made after the cruise to which the outfit had been applied had terminated. The offense was deposited with the voyage, and the delictum ended with the termination of the cruise. Prizes in neutral ports. Though a belligerent vessel may not enter within neutral jurisdiction for hostile purposes, she may, consistently with a state of neutrality, until prohibited by the neutral power, bring her prize into a neutral port, and sell it. The neutral power is, however, at liberty to refuse this privilege, provided the refusal be made, as the privilege ought to be granted, to both parties or to neither. The United States, while a neutral power, frequently asserted the right to prohibit, at discretion, the sale within their ports of prizes brought in by the belligerents, and the sale of French prizes was allowed as an indulgence merely until it interfered with the treaty with England of 1794 in respect to prizes made by privateers. In the opinion of some jurists, it is more consistent with a state of neutrality and the dictates of true policy to refuse this favor, for it must be very inconvenient to permit the privateers of contending nations to assemble, together with their prizes, in a neutral port. The Edict of the States General of 1656 forbade foreign cruisers to sell their prizes in their neutral ports, or cause them to be unladen, and the French Ordinance of the Marine of 1681 contained the same prohibition, and that such vessels should not continue in port longer than 24 hours, unless detained by stress of weather. The admission into neutral ports of the public ships of the belligerent parties, without prizes and under due regulations, is considered to be a favor required on the principle of hospitalities among friendly powers, and it has been uniformly conceded on the part of the United States. Enemy's property in a neutral vessel. But neutral ships do not afford protection to enemy's property, and it may be seized if found on board of a neutral vessel, beyond the limits of the neutral jurisdiction. This is a clear and well-settled principle of the law of nations. It was formerly a question whether the neutral ship conveying enemy's property was not liable to confiscation for that cause. This was the old law of France, in cases in which the master of the vessel knowingly took on board enemy's property. But Binkershoek truly observes that the master's knowledge is immaterial in this case, and that the rule in the Roman law, making the vessel liable for the fraudulent act of the master, was a mere fiscal regulation, and did not apply. And for the neutral to carry enemy's goods is not unlawful, like smuggling, and does not affect the neutral ship. If there be nothing unfair in the conduct of the neutral master, he will even be entitled to his reasonable demurrage, and his freight for the carriage of the goods, though he has not carried them to the place of destination. They are said to be seized and condemned not ex delicto, but only ex re. The capture of them by the enemy is a delivery to the person who, by the rights of war, was substituted for the owner. Binkershoek thinks the master is not entitled to freight because the goods were not carried to the port of destination, though he admits that the Dutch lawyers and the consolato give freight. But the allowance of freight in that case has been the uniform practice of the English Admiralty for near 2 centuries past, except when there was some circumstance of mala fides, or a departure from a strictly proper neutral conduct. The freight is paid, not pro rata, but in toto, because capture is considered as delivery, and the captor pays the whole freight, because he represents his enemy by possessing himself of the enemy's goods, jure belli, and he interrupts the actual delivery to the consignee. The right to take enemy's property on board a neutral ship has been much contested by particular nations, whose interests it strongly opposed. This was the case with the Dutch in the War of 1756, and Mr. Jenkinson, afterwards Earl of Liverpool, published in 1757 a discourse, very full and satisfactory, on the ground of authority and usage in favor of the legality of the right when no treaty intervened to control it. The rule has been steadily maintained by Great Britain. In France it has been fluctuating. The Ordinance of the Marine of 1681 asserted the ancient and severe rule that the neutral ship, having on board enemy's property, was subject to confiscation. The same rule was enforced by the arrêts of 1692 and 1704, and relaxed by those of 1744 and 1778. In 1780, the Empress of Russia proclaimed the principles of the Baltic Code of Neutrality, and declared she would maintain them by force of arms. One of the articles of that code was that all effects belonging to the subjects of the belligerent powers should be looked upon as free on board of neutral ships, except only such goods as were contraband. The principal powers of Europe, as Sweden, Denmark, Prussia, Germany, Holland, France, Spain, Portugal, and Naples, and also these United States, acceded to the Russian principles of neutrality. But the want of the consent of a power of such decided maritime superiority as that of Great Britain was an insuperable obstacle to the success of the Baltic conventional law of neutrality, and it was abandoned in 1793 by the naval powers of Europe as not sanctioned by the existing law of nations in every case in which the doctrines of that code did not rest upon positive compact. During the whole course of the wars growing out of the French Revolution, the government of the United States admitted the English rule to be valid as the true and settled doctrine of international law, and that enemy's property was liable to seizure on board of neutral ships and to be confiscated as prize of war. It has, however, been very usual in commercial treaties to stipulate that free ships should make free goods, contraband of war always excepted, but such stipulations are to be considered as resting on conventional law merely, and as exceptions to the operation of the general rule, which every nation not a party to the stipulation is at perfect liberty to exact or surrender. The Ottoman Porte was the first power to abandon the ancient rule, and she stipulated, in her treaty with France in 1604, that free ships should make free goods, and she afterwards consented to the same provision in her treaty with Holland in 1612, and according to Azuni, Turkey has, at all times on international questions, given an example of moderation to the more civilized powers of Europe. The effort made by the Baltic powers in 1801 to recall and enforce the doctrines of the armed and neutrality in 1780 was met and promptly overpowered, and the Confederacy dissolved by the naval power of England. Russia gave up the point, and by her convention with England of the 17th of June, 1801, expressly agreed that enemy's property was not to be protected on board of neutral ships. The rule has since been very generally acquiesced in, and it was expressly recognized in the Austrian Ordinance of Neutrality, published at Vienna the 7th of August, 1803. Its reason and authority have been ably vindicated by English statesmen and jurists, and particularly by Mr. Ward in his treatise of the relative rights and duties of belligerent and neutral powers in maritime affairs, published in 1801, and which exhausted all the law and learning applicable to the question. Neutral property in an enemy's vessel. It is also a principle of the law of nations relative to neutral rights, that the effects of neutrals, found on board of enemies' vessels, shall be free, and it is a right as fully and firmly settled as the other, though, like that, it is often changed by positive agreement. The principle is to be met with in the Consolato del Mare, and the property of the neutral is to be restored without any compensation for detention and the other necessary inconveniences incident to the capture. The former ordinances of France of 1543, 1585, and 1681 declared such goods to be lawful prize, and Verla justifies the ordinances on the ground that the neutral, by putting his property on board of an enemy's vessel, favors the enemy's commerce, and agrees to abide the fate of the vessel. But it is fully and satisfactorily shown, by the whole current of modern authority, that the neutral has a perfect right to avail himself of the vessel of his friend to transport his property, and Binkerscherk has devoted an entire chapter to the vindication of the justice and equity of the right. The two distinct propositions, that enemy's goods found on board a neutral ship may be lawfully seized as prize of war, and that the goods of a neutral found on board of an enemy's vessel were to be restored, have been explicitly incorporated into the jurisprudence of the United States, and declared by the Supreme Court to be founded in the law of nations. The rule, as it was observed by the Court, rested on the simple and intelligible principle that war gave a full right to capture the goods of an enemy, but gave no right to capture the goods of a friend. The neutral flag constituted no protection to enemy's property, and the belligerent flag communicated no hostile character to neutral property. The character of the property depended upon the fact of ownership, and not upon the character of the vehicle in which it is found. After vindicating the simplicity and justice of the original rule of the law of nations against the speculations of modern theorists, and the ultima ratio of the armed neutrality, which is attempted to effect by force a revolution in the law of nations, the Court stated that nations have changed this simple and natural principle of public law by conventions between themselves, in whole or in part, as they believed it to be for their interest, but that the one proposition, that free ships should make free goods, did not necessarily imply the converse proposition, that enemies' ships should make enemies' goods. If a treaty established the one proposition and was silent as to the other stood precisely as if there had been no stipulation and upon the ancient rule. The stipulation that neutral bottoms should make neutral goods was a concession made by the belligerent to the neutral, and it gave to the neutral flag a capacity not given to it by the law of nations. On the other hand, the stipulation subjecting neutral property found in the vessel of an enemy to condemnation as prize of war was a concession made by the neutral to the belligerent, and took from the neutral a privilege he possessed under the law of nations. But neither reason nor practice rendered the two concessions so indissoluble that the one could not exist without the other. It rested entirely in the discretion of the contracting parties, whether either or both should be granted. The two propositions are distinct and independent of each other, and they have frequently been kept distinct by treaties which stipulated for the one and not for the other. The government of the United States, in their recent negotiations with the republics in South America, have pressed very earnestly for the introduction and establishment of the principle of the Baltic Code of 1780, that the friendly flag should cover the cargo, and this principle is incorporated into the treaty between the United States and Colombia in 1825, and into the Treaty of Navigation and Commerce between the United States and the Republic of Chile in 1832. The introduction of those new republics into the great community of civilized nations has justly been deemed a very favorable opportunity to inculcate and establish, under their sanction, more enlarged and liberal doctrines on the subject of national rights. It has been the desire of our government to obtain the recognition of the fundamental principles consecrated by the treaty with Prussia in 1785 relative to the perfect equality and reciprocity of commercial rights between nations, the abolition of private war upon the ocean, and the enlargement of the privileges of neutral commerce. The rule of public law, that the property of an enemy is liable to capture in the vessel of a friend, is now, that is, about 1825, declared on the part of our government to have no foundation in natural right, and that the usage rests entirely on force. Though the high seas are a general jurisdiction, common to all, yet each nation has a special jurisdiction over its own vessels, and all the maritime nations of modern Europe have, at times, acceded to the principle that the property of an enemy should be protected in the vessel of a friend. No neutral nation, it is said, is bound to submit to the usage, and the neutral may have yielded at one time to the usage without sacrificing the right to vindicate by force the security of the neutral flag at another. The neutral right to cover enemy's property is conceded to be subject to this qualification, that a belligerent nation may justly refuse to neutrals the benefit of this principle, unless it be conceded also by the enemy of the belligerent to the same neutral flag. But whatever may be the utility or reasonableness of the neutral claim, under such a qualification, I should apprehend the belligerent right to be no longer an open question, and that the authority and usage on which that right rests in Europe, and the long, explicit, and authoritative admission of it by this country, have precluded us from making it a subject of controversy, and that we are bound, in truth and justice, to submit to its regular exercise in every case, and with every belligerent power who does not freely renounce it. It has been a matter of discussion whether the captor of the enemy's vessel be entitled to freight from the owner of the neutral goods found on board and restored. Under certain circumstances, the captor has been considered to be entitled to freight, even though the goods were carried to the claimant's own country and restored, and he clearly is entitled to freight if he performs the voyage and carries the goods to the port of original destination. In no other case is freight due to the captor, and the doctrine of pro rata freight is entirely rejected, because it would involve a prize court in a labyrinth of minute inquiries and considerations in the endeavor to ascertain in every case the balance of advantage or disadvantage which an interruption and loss of the original voyage by capture might have produced to the owner of the goods. In the case of the Neredi, the Supreme Court of the United States carried the principle of immunity of neutral property on board an enemy's vessel to the extent of allowing it to be laden on board an armed belligerent cruiser, and it was held that the goods did not lose their neutral character, not even in consequence of resistance made by the armed vessel, provided the neutral did not aid in such armament or resistance, notwithstanding he had chartered the whole vessel and was on board at the time of the resistance. The act of arming was the act of the belligerent party, and the neutral goods did not contribute to the armament further than the freight, which would be paid if the vessel was unarmed, and neither the goods nor the neutral owner were chargeable for the hostile acts of the belligerent vessel if the neutral took no part in the resistance. A contemporary decision of an opposite character on the same point was made by the English High Court of Admiralty in the case of the Fanny, and it was there observed that a neutral subject was at liberty to put his goods on board the merchant vessel of a belligerent, but if he placed them on board an armed belligerent ship, he showed an intention to resist visitation and search by means of the association, and, so far as he does this, he was presumed to adhere to the enemy and to withdraw himself from his protection of neutrality. If a neutral chooses to take the protection of a hostile force instead of his own neutral character, he must take, it was observed, the inconvenience with the convenience, and his property would, upon just and sound principles, be liable to condemnation along with the belligerent vessel. The question decided in the case of the Neredi is a very important one in prize law and of infinite importance in its practical results, and it is to be regretted that the decisions of two courts of the highest character on such a point should have been in direct contradiction to each other. The same point afterwards arose and was again argued, and the former decision repeated, in the case of the Atalanta. It was observed in this latter case that the rule with us was correct in principle, and the most liberal and honorable to the jurisprudence of this country. The question may, therefore, be considered here as at rest, and as having received the most authoritative decision that can be rendered by any judicial tribunal on this side of the Atlantic. The end of Section 10. Section 11 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Section 11 of Restrictions upon Neutral Trade, Part 1. The principal restriction which the law of nations imposes on the trade of neutrals is the prohibition to furnish the belligerent parties with warlike stores and other articles which are directly auxiliary to warlike purposes. Such goods are denominated contraband of war, but in the attempt to define them, the authorities vary or are deficient in precision, and the subject has long been a fruitful source of dispute between neutral and belligerent nations. Contraband of war. In the time of Grotius, some persons contended for the rigor of war, and others for the freedom of commerce. As neutral nations are willing to seize the opportunity which war presents of becoming carriers for the belligerent powers, it is natural that they should desire to diminish the list of contraband as much as possible. Grotius distinguishes between things which are useful only in war, as arms and ammunition, and things which serve merely for pleasure, and things which are of a mixed nature and useful both in peace and war. He agrees with other writers in prohibiting neutrals from carrying articles of the first kind to the enemy, as well as in permitting the second kind to be carried. As to articles of the third class, which are of indiscriminate use in peace and war, as money, provisions, ships, and naval stores, he says that they are sometimes lawful articles of neutral commerce, and sometimes not, and the question will depend upon circumstances existing at the time. They would be contraband if carried to a besieged town, camp, or port. In a naval war, it is admitted that ships and materials for ships become contraband, and horses and saddles may be included. Vattel speaks with some want of precision, and only says in general terms that commodities particularly used in war are contraband, such as arms, military and naval stores, timber, horses, and even provisions, in certain junctures, when there are hopes of reducing the enemy by famine. Losenius, and some other authorities referred to by Valen, consider provisions as generally contraband, but Valen and Pothier insist that they are not so, either by the law of France or the common law of nations, unless carried to besieged or blockaded places. The marine ordinance of Louis XIV included horses and their equipage, transported for military service within the list of contraband, because they were necessary to war equipments, and this is, doubtless, the general rule. They are included in the restricted list of contraband articles mentioned in the treaty between the United States and Colombia in 1825. Valen says that naval stores have been regarded as contraband from the beginning of the last century, and the English prize law is very explicit on this point. Naval stores, and materials for shipbuilding, and even corn, grain, and victuals of all sorts, going to the dominions of the enemy, were declared contraband by an ordinance of Charles I in 1626. Sailcloth is now held to be universally contraband, even on a destination to ports of mere mercantile naval equipment, and in the case of the Maria, it was held that tar, pitch, and hemp, and whatever other materials went to the construction and equipment of vessels of war, were contraband by the modern law of nations, though formerly, when the hostilities of Europe were less naval than at the present day, they were of a disputable nature. The executive government of this country has frequently conceded that the materials for the building, equipment, and armament of ships of war, as timber and naval stores, were contraband. But it does not seem that ship timber is, in se, in all cases, to be considered a contraband article, though destined to an enemy's port. In the case of the Austrian vessel Il Volante, captured by the French privateer L'Étoile de Bonaparte, and which was carrying ship timber to Messina, an enemy's port, it was held by the Council of Prizes at Paris in 1807, upon the opinion of the Advocate General M. Collet d'Exrotil, that the ship timber in that case was not contraband of war, it being ship timber of an ordinary character, and not exclusively applicable to the building of ships of war. Questions of contraband were much discussed during the continuance of our neutral character in the furious war between England and France, commencing in 1793, and we professed to be governed by the modern usage of nations on this point. The National Convention of France on the 9th of May 1793 decreed that neutral vessels, laden with provisions, destined to an enemy's port, should be arrested and carried into France, and one of the earliest acts of England in that war was to detain all neutral vessels going to France and laden with corn, meal, or flour. It was insisted on the part of England that by the law of nations all provisions were to be considered as contraband in the case where the depriving the enemy of those supplies was one of the means employed to reduce him to reasonable terms of peace. and that the actual situation of France was such as to lead to that mode of distressing her, inasmuch as she had armed almost the whole laboring class of her people for the purpose of commencing and supporting hostilities against all the governments of Europe. This claim on the part of England was promptly and perseveringly resisted by the United States, and they contended that corn, meal, and flour, being the produce of the soil and labor of the country, were not contraband of war, unless carried to a place actually invested. The Treaty of Commerce with England in 1794, in the list of contraband, stated that whatever materials served directly to the building and equipment of vessels, with the exception of unwrought iron and fir planks, should be considered contraband and liable to confiscation. But the treaty left the question of provisions open and unsettled, and neither power was understood to have relinquished the construction of the law of nations which it had assumed. The treaty admitted that provisions were not generally contraband, but might become so according to the existing law of nations in certain cases, and those cases were not defined. It was only stipulated by way of relaxation of the penalty of the law that whenever provisions were contraband, the captors or their government should pay to the owner the full value of the articles together with the freight and a reasonable profit. Our government has repeatedly admitted that, as far as the treaty enumerated contraband articles, it was declaratory of the law of nations, and that the treaty conceded nothing on the subject of contraband. The doctrine of the English Admiralty on the subject of provisions being considered contraband was laid down very fully and clearly in the case of the Jonga Margareta. It was there observed that the catalogue of contraband had varied much, and sometimes in such a manner as to make it difficult to assign the reasons of the variations, owing to particular circumstances, the history of which had not accompanied the history of the decisions. In 1673, certain articles of provision, as corn, wine, and oil, were deemed contraband, according to the judgment of a person of great knowledge and experience in the practice of the Admiralty, and in much later times, many other sorts of provisions have been condemned as contraband. In 1747 and 1748, butter and salted fish and rice were condemned as contraband, and those cases show that articles of human food have been considered as contraband when it was probable that they were intended for naval or military use. The modern established rule is that provisions are not generally contraband, but may become so under circumstances arising out of the particular situation of the war, or the condition of the parties engaged in it. Among the circumstances which tend to preserve provisions from being liable to be treated as contraband, one is that they are of the growth of the country which produces them. Another circumstance, to which some indulgence is shown by the practice of nations, is when the articles are in their native and unmanufactured state. Thus, iron is treated with indulgence, though anchors and other instruments fabricated out of it are directly contraband. Hemp is more favorably considered than cordage, and wheat is not considered as so noxious a commodity when going to an enemy's country as any of the final preparations of it for human use. The most important distinction is whether the articles were intended for the ordinary use of life, or even for mercantile ships' use, or whether they were going with a highly probable destination to military use. The nature and quality of the port to which the articles are going is not an irrational test. If the port be a general commercial one, it is presumed the articles are going for civil use, though occasionally a ship of war may be constructed in that port. But if the great predominant character of that port, like Brest in France, or Portsmouth in England, be that of a port of naval military equipment, it will be presumed that the articles were going for military use, although it is possible that the articles might have been applied to civil consumption. As it is impossible to ascertain the final use of an article anticipitus usus, it is not an injurious rule which deduces the final use from the immediate destination, and the presumption of a hostile use, founded on its destination to a military port, is very much inflamed if, at the time when the articles were going, a considerable armament was notoriously preparing, to which a supply of those articles would be eminently useful. These doctrines of the English prize law were essentially the same with that adopted by the American Congress in 1775, for they declared that all vessels, to whomsoever belonging, carrying provisions or other necessaries to the British Army or Navy within the colonies, should be liable to seizure and confiscation. They were likewise fully adopted by the Supreme Court of the United States when we came to know and feel the value of belligerent rights by becoming a party to a maritime war. In the case of the Commercen, a neutral vessel, captured by one of our cruisers in the act of carrying provisions for the use of the British armies in Spain, the court held that provisions being neutral property, but the growth of the enemy's country and destined for the supply of the enemy's military or naval force, were contraband. The court observed that by the modern law of nations, provisions were not generally contraband, but they might become so on account of the particular situation of the war or on account of their destination. If destined for the ordinary use of life in the enemy's country, they were not contraband. But it was otherwise if destined for the army or navy of the enemy, or for his ports of military or naval equipment. And if the provisions were the growth of the enemy's country, and destined for the enemy's use, they were to be treated as contraband and liable to forfeiture, even though the army or navy were in a neutral port, for it would be a direct interposition in the war. This case followed the decisions of Sir William Scott, and carried the doctrine of contraband, as applied to provisions, to as great an extent. It held the voyage of the Swedish neutral so illegal as to preserve the infliction of the penalty of loss of freight. It is the usus bellici which determine an article to be contraband, and as articles come into use as implements of war, which were before innocent, there is truth in the remark that as the means of war vary and shift from time to time, the law of nations shifts with them, not indeed by the change of principles, but by a change in the application of them to new cases, and in order to meet the varying uses of war. When goods are once clearly shown to be contraband, confiscation to the captor is the natural consequence. This is the practice in all cases, as to the article itself, excepting provisions, and as to them, when they become contraband, the ancient and strict right of forfeiture is softened down to a right of preemption on reasonable terms. But, generally, to stop contraband goods would, as Vattel observes, prove an ineffectual relief, especially at sea. The penalty of confiscation is applied in order that the fear of loss might operate as a check on the avidity for gain, and deter the neutral merchant from supplying the enemy with contraband articles. The ancient practice was to seize the contraband goods and keep them on paying the value. But the modern practice of confiscation is far more agreeable to the mutual duties of nations, and more adapted to the preservation of their rights. It is a general understanding, grounded on true principles, that the powers at war may seize and confiscate all contraband goods without any complaint on the part of the neutral merchant, and without any imputation of a breach of neutrality in the neutral sovereign himself. It was contended on the part of the French nation, in 1796, that neutral governments were bound to restrain their subjects from selling or exporting articles, contraband of war, to the belligerent powers. But it was successfully shown on the part of the United States that neutrals may lawfully sell, at home, to a belligerent purchaser, or carry themselves to the belligerent powers, contraband articles subject to the right of seizure, in transitu. This right has since been explicitly declared by the judicial authorities of this country. The right of the neutral to transport and of the hostile power to seize are conflicting rights, and neither party can charge the other with a criminal act. Contraband articles are said to be of an infectious nature, and they contaminate the whole cargo belonging to the same owners. The innocence of any particular article is not usually admitted to exempt it from the general confiscation. By the ancient law of Europe, the ship also was liable to condemnation, and such a penalty was deemed just, and supported by the general analogies of law, for the owner of the ship had engaged it in an unlawful commerce, and contraband goods are seized and condemned ex delicto. But the modern practice of the courts of admiralty, since the age of Grotius, is milder, and the act of carrying contraband articles is attended only with the loss of freight and expenses, unless the ship belongs to the owner of the contraband articles, or the carrying of them has been connected with malignant and aggravating circumstances. and among those circumstances, a false destination and false papers are considered as the most heinous. In those cases, and in all cases of fraud in the owner of the ship, or of his agent, the penalty is carried beyond the refusal of freight and expenses, and is extended to the confiscation of the ship and the innocent parts of the cargo. This is now the established doctrine, but it is sometimes varied by treaty, in like manner as all the settled principles and usages of nations are subject to conventional modification. Law of blockades. A neutral may also forfeit the immunities of his national character by violations of blockade, and among the rights of belligerents there is none more clear and incontrovertible, or more just and necessary in the application, than that which gives rise to the law of blockade. Beckershoek says, it is founded on the principles of natural reason, as well as on the usage of nations, and Grotius considers the carrying of supplies to a besieged town or a blockaded port as an offense exceedingly aggravated and injurious. They both agree that a neutral may be dealt with severely, and Vattel says he may be treated as an enemy. The law of blockade is, however, so harsh and severe in its operation that in order to apply it, the fact of the actual blockade must be established by clear and unequivocal evidence, and the neutral must have had due previous notice of its existence, and the squadron allotted for the purpose of its execution must be competent to cut off all communication with the interdicted place or port, and the neutral must have been guilty of some act of violation, either by going in, or attempting to enter, or by coming out with a cargo laden after the commencement of the blockade. The failure of either of the points requisite to establish the existence of a legal blockade amounts to an entire defeasance of the measure, even though the notification of the blockade had issued from the authority of the government itself. A blockade must be existing in point of fact, and in order to constitute that existence, there must be a power present to enforce it. All decrees and orders, declaring extensive coasts and whole countries in a state of blockade, without the presence of an adequate naval force to support it, are manifestly illegal and void, and have no sanction in public law. The ancient authorities all referred to a strict and actual siege or blockade. The language of Grotius is oppidum obsessum vel portus clausus, and the investing power must be able to apply its force to every point of the blockaded place, so as to render it dangerous to attempt to enter, and there is no blockade of that part where its power cannot be brought to bear. The definition of a blockade, given by the Convention of the Baltic Powers in 1780, and again in 1801, and by the Ordinance of Congress in 1781, required that there should be actually a number of vessels stationed near enough to the port to make the entry apparently dangerous. The government of the United States has uniformly insisted that the blockade should be effective by the presence of a competent force stationed and present at or near the entrance of the port, and they have protested with great energy against the application of the right of seizure and confiscation to ineffectual or fictitious blockades. The occasional absence of the blockading squadron, produced by accident, as in the case of a storm, and when the station is resumed with due diligence, does not suspend the blockade, provided the suspension and the reason of it be known, and the law considers an attempt to take advantage of such an accidental removal as an attempt to break the blockade, and as a mere fraud. The American government seemed disposed to admit the continuance of the blockade in such a case, and the language of the judicial authorities in New York has been in favor of the solidity and justness of the English doctrine of blockade on this point. But if the blockade be raised by the enemy, or by applying the naval force or part of it, though only for a time, to other objects, or by the mere remissness of the cruisers, the commerce of neutrals to the place ought to be free. The presence of a sufficient force is the natural criterion by which the neutral is enabled to ascertain existence of the blockade. He looks only to the matter of fact, and if the blockading squadron is removed when he arrives before the port, and he is ignorant of the cause of the removal, or if he be not ignorant, and the cause be not an accidental one but voluntary or produced by an enemy, he may enter without being answerable for a breach of the blockade. When a blockade is raised voluntarily or by a superior force, it puts an end to it absolutely, and if it be resumed, neutrals must be charged with notice de novo, and without reference to the former state of things, before they can be involved in the guilt of a violation of the blockade. The object of a blockade is not merely to prevent the importation of supplies, but to prevent export as well as import, and to cut off all communication of commerce with the blockaded port. The act of egress is as culpable as the act of ingress if it be done fraudulently, and a ship coming out of a blockaded port is, in the first instance, liable to seizure, and, to obtain a release, the party must give satisfactory proof of the innocence of his intention. But, according to modern usage, a blockade does not rightfully extend to a neutral vessel found in a port when the blockade was instituted, nor prevent her coming out with the cargo bona fide purchased and laden on board before the commencement of the blockade. The modern practice does not require that the place should be invested by land as well as by sea in order to constitute a legal blockade, and if a place is blockaded by sea only, it is no violation of belligerent rights for the neutral to carry on commerce with it by inland communications. It is absolutely necessary that the neutral should have had due notice of the blockade, in order to affect him with the penal consequences of a violation of it. This information may be communicated to him in two ways, either actually, by a formal notice from the blockading power, or constructively, by notice to his government, or by the notoriety of the fact. It is immaterial in what way the neutral comes to the knowledge of the blockade. If the blockade actually exists, and he has knowledge of it, he is bound not to violate it. A notice to a foreign government is a notice to all the individuals of that nation, and they are not permitted to aver ignorance of it, because it is the duty of the neutral government to communicate the notice to their people. In the case of a blockade without regular notice, notice is in fact generally requisite, and there is this difference between a blockade regularly notified and one without such notice, that in the former case the act of sailing for the blockaded place, with an intent to evade it, or to enter contingently, amounts, from the very commencement of the voyage, to a breach of the blockade, for the port is to be considered as closed up until the blockade be formally revoked or actually raised, whereas in the latter case of a blockade de facto, the ignorance of the party as to its continuance may be received as an excuse for sailing to the blockaded place on a doubtful and provisional destination. The question of notice is a question of evidence, to be determined by the facts applicable to the case. The notoriety of a blockade is of itself sufficient notice of it to vessels lying within the blockaded port. In the case of the Adelaide, it was the doctrine of the English Admiralty that a notification given to one state must be presumed, after a reasonable time, to have reached the subjects of neighboring states, and it affects them with the knowledge of the fact on just grounds of evidence. And after the blockade is once established, and due notice received, either actually or constructively, the neutral is not permitted to go to the very station of the blockading force, under pretense of inquiring whether the blockade had terminated, because this would lead to fraudulent attempts to evade it, and would amount in practice to a universal license to attempt to enter, and on being prevented, to claim the liberty of going elsewhere. Some relaxation was very reasonably given to this rule in its application to distant voyages from America, and ships sailing for Europe, before knowledge of the blockade reached them, were entitled to notice even at the blockaded port. If they sailed after notice, they might sail on a contingent destination for the blockaded port, with the purpose of calling for information at some European port, and be allowed the benefit of such a contingent destination, to be rendered definite by the information. But in no case is the information, as to the existence of the blockade, to be sought at the mouth of the port. A neutral cannot be permitted to place himself in the vicinity of a blockaded port, if his situation be so near that he may, with impunity, break the blockade whenever he pleases and slip in without obstruction. If that were to be permitted, it would be impossible that any blockade could be maintained. It is a presumption, almost de jure, that the neutral, if found on the interdicted waters, goes there with an intention to break the blockade, and it would require very clear and satisfactory evidence to repel the presumption of a criminal intent. The judicial decisions in England and in this country have given great precision to the law of blockade by the application of it to particular cases, and by the extent and clearness and equity of their illustrations. They are distinguished likewise for general coincidence and harmony in their principles. All the cases admit that the neutral must be chargeable with knowledge, either actual or constructive, of the existence of the blockade, and with an intent and with some attempt to break it, before he is to suffer the penalty of a violation of it. The evidence of that intent and of the overt act will vary greatly according to circumstances, and the conclusion to be drawn from those circumstances will depend in some degree upon the character and judgment of the prize courts. But the true principles which ought to govern have rarely been a matter of dispute. The fact of clearing out or sailing for a blockaded port is in itself innocent, unless it be accompanied with knowledge of the blockade. Such a vessel, not possessed of such previous knowledge, is to be first warned of the fact, and a subsequent attempt to enter constitutes the breach. This was the provision in the treaty with England in 1794, and it has been declared in other cases, and is considered to be a correct exposition of the law of nations. It has been a question in the courts in this country whether they ought to admit the law of the English prize courts, that sailing for a blockaded port, knowing it to be blockaded, was in itself an attempt and an act sufficient to charge the party with a breach of the blockade, without reference to the distance between the port of departure and the port invested, or to the extent of the voyage performed when the vessel was arrested. But in Yaton v. Fry, the Supreme Court of the United States coincided essentially with the doctrine of the English prize courts, for they held that sailing from Tobago for Curaçao, knowing the latter to be blockaded, was a breach of the blockade, and according to the opinion of Mr. Justice Story, in the case of the Nereid, the act of sailing with an intent to break a blockade is a sufficient breach to authorize confiscation. The offense continues, although at the moment of capture the vessel be, by stress of weather, driven in a direction from the port, for the hostile intention still remains unchanged. The distance or proximity of the two ports would certainly have an effect upon the equity of the application of the rule. A Dutch ordinance in 1630 declared that vessels bound to the blockaded ports of Flanders were liable to confiscation, though found at a distance from them, unless they had voluntarily altered the voyage before coming in sight of the port, and Binkershoek contends for the reasonableness of the order. What that distance must be is not defined, and if the ports be not very wide apart, the act of sailing for the blockaded port may reasonably be deemed evidence of a breach of it, and an overt act of fraud upon the belligerent rights. But a relaxation of the rule has been required and granted in the case of distant voyages, such as those across the Atlantic, and the vessel is allowed to sail on a contingent destination for a blockaded port, subject to the duty of subsequent inquiry at suitable places. The Ordinance of Congress of 1781 seems to have conceded this point to the extent of the English rule, for they made it lawful to take and condemn all vessels, of all nations, destined to any such port, without saying anything of notice or proximity. The consequence of a breach of blockade is the confiscation of the ship, and the cargo is always, prima facie, implicated in the guilt of the owner, or master of the ship, and it lays with them to remove the presumption that the vessel was going in for the benefit of the cargo and with the direction of the owner. The old doctrine was much more severe, and often inflicted not merely a forfeiture of the property taken, but imprisonment, and other personal punishment. But the modern and milder usage has confined the penalty to the confiscation of the ship and goods. If a ship has contracted guilt by a breach of blockade, the offense is not discharged until the end of the voyage. The penalty never travels on with the vessel further than to the end of the return voyage, and if she is taken in any part of that voyage, she is taken in delicto. This is deemed reasonable because no other opportunity is afforded to the belligerent force to vindicate the law. The penalty for a breach of blockade is also held to be remitted if the blockade has been raised before the capture. The delictum is completely done away when the blockade ceases. Neutral carrying enemy's dispatches. There are other acts of illegal assistance afforded to a belligerent, besides supplying him with contraband goods and relieving his distress under a blockade. Among these acts, the conveyance of hostile dispatches is the most injurious, and deemed to be of the most hostile and noxious character. The carrying of 2 or 3 cargoes of stores is necessarily an assistance of a limited nature, but in the transmission of dispatches may be conveyed the entire plan of a campaign, and it may lead to a defeat of all the projects of the other belligerent in that theater of the war. The appropriate remedy for this offense is the confiscation of the ship, and in doing so the courts make no innovation on the ancient law, but they only apply established principles to new combinations of circumstances. There would be no penalty in the mere confiscation of the dispatches. The proper and efficient remedy is the confiscation of the vehicle employed to carry them, and if any privity subsists between the owners of the cargo and the master, they are involved by implication in his delinquency. If the cargo be the property of the proprietor of the ship, then, by the general rule ob continentiam delecti, the cargo shares the same fate, and especially if there was an active interposition in the service of the enemy, concerted and continued in fraud. A distinction has been made between carrying dispatches of the enemy between different parts of his dominions, and carrying dispatches of an ambassador from a neutral country to his own sovereign. The effect of the former dispatches is presumed to be hostile, but the neutral country has a right to preserve its relations with the enemy, and it does not necessarily follow that the communications are of a hostile nature. Ambassadors resident in a neutral country are favored objects of the protection of the law of nations, and their object is to preserve the relations of amity between the governments, and the presumption is that the neutral state preserves its integrity and is not concerned in any hostile design. The end of section 11.
Section 12 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Section 12 of Restrictions upon Neutral Trade, Part 2. Right of Search at Sea. In order to enforce the rights of belligerent nations against the delinquencies of neutrals, and to ascertain the real as well as assumed character of all vessels on the high seas, the law of nations arms them with the practical power of visitation and search. The duty of self-preservation gives to belligerent nations this right. It is founded upon necessity, and is strictly and exclusively a war right, and does not exist in time of peace. All writers upon the law of nations, and the highest authorities, acknowledge the right as resting on sound principles of public jurisprudence, and upon the institutes and practice of all great maritime powers. And if, upon making the search, the vessel be found employed in contraband trade, or in carrying enemy's property, or troops, or dispatches, she is liable to be taken and brought in for adjudication before a prize court. Neutral nations have frequently been disposed to question and resist the exercise of this right. This was particularly the case with the Baltic Confederacy during the American War, and with the Convention of the Baltic Powers in 1801. The right of search was denied, and the flag of the state was declared to be a substitute for all documentary and other proof, and to exclude all right of search. Those powers armed for the purpose of defending their neutral pretensions, and England did not hesitate to consider it as an attempt to introduce by force a new code of maritime law, inconsistent with her belligerent rights, and hostile to her interests, and one which would go to extinguish the right of maritime capture. The attempt was speedily frustrated and abandoned, and the right of search has since that time been considered incontrovertible. The whole doctrine was ably discussed in the English High Court of Admiralty in the case of the Maria, and it was adjudged that the right was incontestable, and that a neutral sovereign could not, by the interposition of force, vary that right. Two powers may agree among themselves that the presence of one of their armed ships along with their merchant ships shall be mutually understood to imply that nothing is to be found, in that convoy of merchant ships, inconsistent with amity or neutrality. But no belligerent power can legally be compelled, by mere force, to accept of such a pledge, and every belligerent power who is no party to the agreement has a right to insist on the only security known to the law of nations on this subject, independent of any special covenant, and that is the right of personal visitation and search, to be exercised by those who have an interest in making it. The penalty for the violent contravention of this right is the confiscation of the property so withheld from visitation, and the infliction of this penalty is conformable to the settled practice of nations,
as well as to the principles of the municipal jurisprudence of most countries in Europe. There may be cases in which the master of a neutral ship may be authorized, by the natural right of self-preservation, to defend himself against extreme violence threatened by a cruiser grossly abusing his commission, but, except in extreme cases, a merchant vessel has no right to say for itself, and an armed vessel has no right to say for it, that it will not submit to visitation or search, or to be carried into a proximate port for judicial inquiry. Upon these principles a fleet of Swedish merchant ships, sailing under convoy of a Swedish ship of war, and under instructions from the Swedish government to resist by force the right of search claimed by British lawfully commissioned cruisers, was condemned. The resistance of the convoying ship was a resistance of the whole convoy, and justly subjected the whole to confiscation. The doctrine of the English Admiralty on the right of visitation and search, and on the limitation of the right, has been recognized in its fullest extent by the courts of justice in this country. The very act of sailing under the protection of a belligerent or neutral convoy for the purpose of resisting search is a violation of neutrality. The Danish government asserted the same principle in its correspondence with the government of the United States and in the royal instructions of the 10th of March 1810, and none of the powers of Europe have called in question the justice of the doctrine. Confiscation is applied by way of penalty for resistance of search to all vessels, without any discrimination as to the national character of the vessel or cargo, and without separating the fate of the cargo from that of the ship. This right of search is confined to private merchant vessels, and does not apply to public ships of war. Their immunity from the exercise of any jurisdiction but that of the sovereign power to which they belong is uniformly asserted, claimed, and conceded. A contrary doctrine is not to be found in any jurist or writer on the law of nations, or admitted in any treaty, and every act to the contrary has been promptly met and condemned. The exercise of the right of visitation and search must be conducted with due care, and regard to the rights and safety of the vessel. If the neutral has acted with candor and good faith, and the inquiry has been wrongly pursued, the belligerent cruiser is responsible to the neutral in costs and damages, to be assessed by the prize court which sustains the judicial examination. The mere exercise of the right of search involves the cruiser in no trespass, for it is strictly lawful. But if he proceeds to capture the vessel as prize, and sends her in for adjudication, and there was no probable cause, he is responsible. It is not the search but the subsequent capture which is treated in such a case as a tortious act. If the capture be justifiable, the subsequent detention for adjudication is never punished with damages, and in all cases of marine torts, courts of admiralty exercise a large discretion in giving or withholding damages. A rescue effected by the crew after capture, and when the captors are in actual possession, is unlawful, and considered to be a resistance within the application of the penalty of confiscation, for it is delivery by force from force, and where the penalty attaches at all, it attaches as completely to the cargo as to the ship, for the master acted as agent of the owner of the cargo, and his resistance was a fraudulent attempt to withdraw it from the rights of war. Neutral documents. A neutral is bound not only to submit to search, but to have his vessel duly furnished with the genuine documents requisite to support her neutral character. The most material of these documents are the register, passport or sea letter, muster roll, logbook, charter party, invoice, and bill of lading. The want of some of these papers is strong presumptive evidence against the ship's neutrality, yet the want of any one of them is not absolutely conclusive. Sed aliquid ex solemnibus deficiat, cum equitas possit subveniendum est. The concealment of papers material for the preservation of the neutral character justifies a capture, and carrying into port for adjudication, though it does not absolutely require a condemnation. It is good ground to refuse costs and damages on restitution, or to refuse further proof to relieve the obscurity of the case, where the cause labored under heavy doubts, and there was prima facie ground for condemnation independent of the concealment. The spoliation of papers is a still more aggravated and inflamed circumstance of suspicion. That fact may exclude further proof, and be sufficient to infer guilt, but it does not in England, as it does by the maritime law of other countries, create an absolute presumption juris et de jure, and yet a case that escapes with such a brand upon it is saved so as by fire. The Supreme Court of the United States has followed the less rigorous English rule, and held that the spoliation of papers was not, of itself, sufficient ground for condemnation, and that it was a circumstance open for explanation, for it may have arisen from accident, necessity, or superior force. If the explanation be not prompt and frank, or be weak and futile, if the cause labors under heavy suspicions, or there be a vehement presumption of bad faith, or gross prevarication, it is good cause for the denial of further proof, and the condemnation ensues from defects in the evidence which the party is not permitted to supply. The observation of Lord Mansfield in Bernardi v. Monteau was to the same effect. By the maritime law of all countries, he said, throwing papers overboard was considered as a strong presumption of enemy's property, but in all his experience he had never known a condemnation on that circumstance only. The end of section 12. Section 13 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Section 13 of Truces, Passports, and Treaties of Peace. Having considered the rights and duties appertaining to a state of war, I proceed to examine the law of nations relative to negotiations, conventions, and treaties, which either partially interrupt the war or terminate in peace. Effect of a truce. 1. A truce, or suspension of arms, does not terminate the war, but it is one of the commercia belli which suspends its operations. These conventions rest upon the obligation of good faith, and as they lead to pacific negotiations and are necessary to control hostilities and promote the cause of humanity, they are sacredly observed by civilized nations. A particular truce is only a partial cessation of hostilities, as between a town and an army besieging it, but a general truce applies to the operations of the war, and if it be for a long or indefinite period of time, it amounts to a temporary peace, which leaves the state of the contending parties and the questions between them remaining in the same situation as it found them. A partial truce may be made by a subordinate commander, and it is a power necessarily implied in the nature of his trust, but it is requisite to a general truce, or suspension of hostilities throughout the nation, or for a great length of time, that it be made by the sovereign of the country or by his special authority. The general principle on the subject is, that if a commander makes a compact with the enemy, and it to be of such a nature that the power to make it could be reasonably implied from the nature of the trust, it would be valid and binding, though he abused his trust. The obligation he is under not to abuse his trust regards his own state, and not the enemy. A truce binds the contracting parties from the time it is concluded, but it does not bind the individuals of the nation so as to render them personally responsible for a breach of it until they have had actual or constructive notice of it. Though an individual may not be held to make pecuniary compensation for a capture made or destruction of property after the suspension of hostilities and before notice of it had reached him, yet the sovereign of the country is bound to cause restoration to be made of all prizes made after the date of a general truce. To prevent the danger and damage that might arise from acts committed in ignorance of the truce, it is common and proper to fix a prospective period for the cessation of hostilities, with a due reference to the distance and situation of places. A truce only temporarily stays hostilities, and each party to it may, within his own territories, do whatever he would have a right to do in time of peace. He may continue active preparations for war by repairing fortifications, levying and disciplining troops, and collecting provisions and articles of war. He may do whatever, under all the circumstances, would be deemed compatible with good faith and the spirit of the agreement, but he is justly restrained from doing what would be directly injurious to the enemy, and could not safely be done in the midst of hostilities. Thus, in the case of a truce between the governor of a fortified town and the army besieging it, neither party is at liberty to continue works constructed either for attack or defense, and which could not safely be done if hostilities had continued, for this would be to make a mischievous and fraudulent use of the cessation of arms. So it would be a fraud upon the rights of the besieging army, and an abuse of the armistice for the garrison to avail themselves of the truce to introduce provision and succors into the town, in a way or through passages which the besieging army would have been competent to prevent. The meaning of every such compact is, that all things should remain as they were in the places contested, and of which the possession was disputed at the moment of the conclusion of the truce. At the expiration of the truce, hostilities may recommence without any fresh declaration of war, but if it be for an indefinite time, justice and good faith would require due notice of an intention to terminate it. Grotius and Vattel, as well as other writers on national law, have agitated the question whether a truce for a given period, as for instance from the 1st of January to the 1st of February, will include or exclude the first day of each of these months. Grotius says that the day from whence a truce is to be computed is not one of the days of the truce, but that it will include the whole of the first day of February as being the day of its termination. Vattel, on the other hand, is of the opinion that the day of the commencement of the truce would be included, and as the time ought to be taken largely and liberally for the sake of humanity, the last day mentioned would also be included. Every ambiguity of this kind ought always to be prevented by positive and precise stipulations, as from such a day to such a day, both inclusive. Of a passport. 2. A passport or safe conduct is a privilege granted in war, and exempting the party from the effects of its operation during the time and to the extent prescribed in the permission. It flows from the sovereign authority, but the power of granting a passport may be delegated by the sovereign to persons in subordinate command, and they are invested with that power either by an express commission or by the nature of their trust. The general of an army, from the very nature of his power, can grant safe conducts, but the permission is not transferable by the person named in the passport, for it may be that the government had special reasons for granting the privilege to the very individual named, and it is presumed to be personal. If the safe conduct be granted, not for persons but for effects, those effects may be removed by others besides the owner, provided no person be selected as the agent against whom there may exist a personal objection sufficient to render him an object of suspicion or danger within the territories of the power granting the permission. He who promises security by a passport is morally bound to afford it against any of his subjects or forces, and to make good any damage the party might sustain by a violation of the passport. The privilege being so far a dispensation from the legal effects of war, it is always to be taken strictly, and must be confined to the purpose and place and time for which it was granted. A safe conduct generally includes the necessary baggage and servants of the person to whom it is granted, and to save doubt and difficulty, it is usual to enumerate, with precision, every particular branch and extent of the indulgence. If a safe conduct be given for a stated term of time, the person in whose favor it was granted must leave the enemy's country before the time expires, unless detained by sickness or some unavoidable circumstance, and then he remains under the same protection. The case is different with an enemy who comes into the country of his adversary during a truce. He is at his own peril, takes advantage of a general liberty allowed by the suspension of hostilities, and at the expiration of the truce, the war may freely take its course without being impeded by any claims of such a party for protection. It is stated that a safe conduct may even be revoked by him who granted it for some good reason, for it is a general principle in the law of nations that every privilege may be revoked when it becomes detrimental to the state. If it be a gratuitous privilege, it may be revoked purely and simply, but if it be a purchased privilege, the party interested in it is entitled to indemnity against all injurious consequences, and every party affected by the revocation is to be allowed time and liberty to depart in safety. Enemy's license to trade. The effect of a license given by the enemy to the subjects of the adverse party to carry on a specified trade has already been considered in respect to the light in which it is viewed by the government of the citizens accepting it. A very different effect is given to those licenses by the government which grants them, and they are regarded and respected as lawful relaxations or suspensions of the rules of war. It is the assumption of a state of peace to the extent of the license, and the act rests in the discretion of the sovereign authority of the state, which alone is competent to decide how far considerations of commercial and political expediency may, in particular cases, control the ordinary consequences of war. In the country which grants them, licenses to carry on a pacific commerce are stricti juris, as being exceptions to a general rule, though they are not to be construed with pedantic accuracy, nor will every small deviation be held to vitiate the fair effect of them. An excess in the quantity of goods permitted to be imported might not be considered as noxious to any extent, but a variation in the quality or substance of the goods might be more significant. Whenever any part of the trade assumed under the license is denuded of any authority under it, such part is subject to condemnation. Another material circumstance in all licenses is the limitation of time in which they are to be carried into effect, for what is proper at one time may be very unfit and mischievous at another time. Where a license was limited to be in force until the 29th of September, and the ship did not sail from the foreign port until the 4th of October, yet, as the goods were laden on board by the 12th of September, and there was an entire bona fides on the part of the person holding the license, this was held to be legal. But where a license was to bring away a cargo from Bordeaux, and the party thought proper to change the license and accommodate it to another port in France, it was held by the English Admiralty, in the case of the Twee Gobreeders, that the license was vitiated, and the vessel and cargo were condemned. It has also been held that the license must be limited to the use of the precise persons for whose benefit it was obtained. The great principle in these cases is that subjects are not to trade with the enemy without the special permission of the government, and a material object of the control which the government exercises over such a trade is that it may judge of the particular persons who are fit to be entrusted with an exemption from the ordinary restrictions of a state of war. Treaties of Peace. 3. The object of war is peace, and it is the duty of every belligerent power to make war fulfill its end with the least possible mischief, and to accelerate, by all fair and reasonable means, a just and honorable peace. The same power which has the right to declare and carry on war would seem naturally to be the proper power to make and conclude a treaty of peace. But the disposition of this power will depend upon the local constitution of every nation, and it sometimes happens that the power of making peace is committed to a body of men who have not the power to make war.
In Sweden, after the death of Charles XII,
the king could declare war without the consent of the national diet, but he made peace in conjunction with the Senate. So, by the Constitution of the United States, the President, by and with the advice and consent of 2/3 of the Senate, may make peace, but it is reserved to Congress to declare war. This provision in our Constitution is well adapted, as will be shown more fully hereafter, to unite in the negotiation and conclusion of treaties the advantage of talents, experience, stability, and a comprehensive knowledge of national interest, with the requisite secrecy and dispatch. Treaties of peace, when made by the competent power, are obligatory upon the whole nation. If the treaty requires the payment of money to carry it into effect, and the money cannot be raised but by an act of the legislature, the treaty is morally obligatory upon the legislature to pass the law, and to refuse it would be a breach of public faith. The department of the government that is entrusted by the Constitution with the treaty-making power is competent to bind the national faith in its discretion, for the power to make treaties of peace must be coextensive with all the exigencies of the nation, and necessarily involves in it that portion of the national sovereignty which has the exclusive direction of diplomatic negotiations and contracts with foreign powers. All treaties made by that power become of absolute efficacy, because they are the supreme law of the land. There can be no doubt that the power competent to bind the nation by treaty may alienate the public domain and property by treaty. If a nation has conferred upon its executive department, without reserve, the right of treating and contracting with other states, it is considered as having invested it with all the power necessary to make a valid contract. That department is the organ of the nation, and the alienations by it are valid because they are done by the reputed will of the nation. The fundamental laws of a state may withhold from the executive department the power of transferring what belongs to the state, but if there be no express provision of that kind, the inference is that it has confided to the department charged with the power of making treaties a discretion commensurate with all the great interests and wants and necessities of the nation. A power to make treaties of peace necessarily implies a power to decide the terms on which they shall be made, and foreign states could not deal safely with the government upon any other presumption. The power that is entrusted generally and largely with authority to make valid treaties of peace can, of course, bind the nation by alienation of part of its territory, and this is equally the case whether that territory be already in the occupation of the enemy or remains in the possession of the nation, and whether the property be public or private. In the case of the schooner Peggy, the Supreme Court of the United States admitted that individual rights acquired by war and vested rights of the citizens might be sacrificed by treaty for national purposes. So, in the case of Ware v. Hilton, it was said to be a clear principle of national law that private rights might be sacrificed by treaty to secure the public safety, though the government would be bound to make compensation and indemnity to the individuals whose rights had thus been surrendered. The power to alienate and the duty to make compensation are both laid down by Grotius in equally explicit terms. A treaty of peace is valid and binding on the nation, if made with the present ruling power of the nation or the government de facto. Other nations have no right to interfere with the domestic affairs of any particular nation, or to examine and judge of the title of the party in possession of the supreme authority. They are to look only to the fact of possession. And it is an acknowledged rule of international law that the principal party in whose name the war is made cannot justly make peace without including those defensive allies in the pacification who have afforded assistance, though they may not have acted as principals, for it would be faithless and cruel for the principal in the war to leave his weaker ally to the full force of the enemy's resentment. The ally is, however, to be no further a party to the stipulations and obligations of the treaty than he has been willing to consent. All that the principal can require is that his ally be considered as restored to a state of peace. Every alliance in which all the parties are principals in the war obliges the allies to treat in concert, though each one makes a separate treaty of peace for himself. The effect of a treaty of peace is to put an end to the war and to abolish the subject of it. Peace relates to the war which it terminates. It is an agreement to waive all discussion concerning the respective rights of the parties and to bury in oblivion all the original causes of the war. It forbids the revival of the same war by taking arms for the cause which it first kindled it, though it is no objection to any subsequent pretensions to the same thing on other foundations. After peace, the revival of grievances arising before the war is not to be encouraged, for treaties of peace are intended to put an end to such complaints, and if grievances then existing are not brought forward at the time when peace is concluded, it is to be presumed that it is not intended to bring them forward at any future time. Peace leaves the contracting parties without any right of committing hostility for the very cause which kindled the war, or for what has passed in the course of it. It is therefore no longer permitted to take up arms again for the same cause. But this will not preclude the right to complain and resist if the same grievances which kindled the war be renewed and repeated, for that would furnish a new injury and a new cause of war equally just with the former war. If an abstract right be in question between the parties, the right, for instance, to impress at sea one's own subjects from the merchant vessels of the other, and the parties make peace without taking any notice of the question, it follows, of course, that all past grievances, damages, and injury arising under such claim are thrown into oblivion by the amnesty which every treaty implies. But the claim itself is not thereby settled either one way or the other. It remains open for future discussion because the treaty wanted an express concession or renunciation of the claim itself. A treaty of peace leaves everything in the state in which it finds it, if there be no express stipulation on the subject. If nothing be said in the treaty of peace about the conquered country or places, they remain with the possessor, and his title cannot afterwards be called in question. During war, the conqueror has only a usufructory right to the territory he has subdued, and the latent right and title of the former sovereign continues until a treaty of peace, by its silence or by its express stipulation, shall have extinguished his title forever. The peace does not affect private rights which had no relation to the war. Debts existing prior to the war, and injuries committed prior to the war, but which made no part of the reasons for undertaking it, remain entire, and the remedies are revived. There are certain cases in which even debts contracted or injuries committed between two subjects of the belligerent powers during the war are the ground of a valid claim, as in the case of ransom bills and of contracts made by prisoners of war for subsistence, or in a trade carried on under a license. This would be the case if the debt between them was contracted or the injury was committed in a neutral country. The time when treaties take effect. A treaty of peace binds the contracting parties from the moment of its conclusion, and that is understood to be from the day it is signed. But, like a truce, it cannot affect the subjects of the nation with guilt by reason of acts of hostility subsequent to the date of the treaty, provided they were committed before the treaty was known. All that can be required in such cases is that the government make immediate restitution of things captured after the cessation of hostilities, and to guard against inconvenience from the want of due knowledge of the treaty, it is usual to fix the periods at which hostilities are to cease at different places and for the restitution of property taken afterwards. But though individuals are not deemed criminal for continuing hostilities after the date of the peace, so long as they are ignorant of it, a more difficult question to determine is whether they are responsible civiliter in such cases. Grotius says, they are not liable to answer in damages, but it is the duty of the government to restore what has been captured and not destroyed. In the case of the American ship Mentor, which was taken and destroyed off Delaware Bay by British ships of war in 1783 after the cessation of hostilities, but before that fact had come to the knowledge of either of the parties, the point was much discussed, and it was held that the injured party could not pass over the person from whom the alleged injury had been received, and fix it on the commander of the English squadron on that station, who was totally ignorant of the whole transaction, and at the distance of 30 leagues from the place where it passed. There was no instance in the annals of the prize courts of such a remote and consequential responsibility in such a case. The actual wrongdoer is the person to answer in judgment, and to him the responsibility, if any, is attached. He may have other persons responsible over him, but the injured party could look only to him. The better opinion was that though such an act be done through ignorance of the cessation of hostilities, yet mere ignorance of that fact would not protect the officer from civil responsibility in a prize court, and that if he acted through ignorance, his own government must protect him and save him harmless. When a place or country is exempted from hostility by articles of peace, it is the duty of the government to use due diligence to give its subjects notice of the fact, and the government ought, in justice, to indemnify its subjects who act in ignorance of the peace. And yet it would seem, from that case, that the American owner was denied redress in the British Admiralty, not only against the admiral of the fleet on that station, but against the immediate author of the injury. Sir William Scott denied the relief against the admiral, and 10 years before that time, relief had equally been denied by his predecessor against the person who did the injury. If that decision was erroneous, an appeal ought to have been prosecuted. We have, then, the decision of the English High Court of Admiralty, denying any relief in such a case, and an opinion of Sir William Scott, many years afterwards, that the original wrongdoer was liable. The opinions cannot otherwise be reconciled than upon the ground that the prize courts have a large and equitable discretion in allowing or withholding relief, according to the special circumstances of the individual case, and that there is no fixed or inflexible general rule on the subject. If a time be fixed by the treaty for hostilities to cease in a given place, and a capture be previously made, but with knowledge of the peace, it has been a question among the writers on public law whether the captured property should be restored. The better and the more reasonable opinion is that the capture would be null, though made before the day limited, provided the captor was previously informed of the peace, For, as Amerigon observes, since constructive knowledge of the peace, after the time limited in different parts of the world, renders the capture void, much more ought actual knowledge of the peace to produce that effect. Another question arose subsequent to the Treaty of Ghent of 1814, in one of the British Vice-Admiralty courts, on the validity of a recapture by a British ship of war of a British vessel captured by an American privateer. The capture made by the American cruiser was valid, being made before the period fixed for the cessation of hostilities, and in ignorance of the fact. But the prize had not been carried into port and condemned, and while at sea she was recaptured by the British cruiser after the period fixed for the cessation of hostilities, but without knowledge of the peace. It was decided that the possession of the vessel by the American privateer was a lawful possession, and that the British cruiser could not, after the peace, lawfully use force to divest this lawful possession. The restoration of peace put an end, from the time limited, to all force, and then the general principle applied, that things acquired in war remain, as to title and possession, precisely as they stood when the peace took place. The jus possidetis is the basis of every treaty of peace, unless it be otherwise agreed. Peace gives a final and perfect title to captures without condemnation, and as it forbids all force, it destroys all hopes of recovery as much as if the vessel was carried infra praesidia and condemned. A similar doctrine was held in the case of the schooner Sophie, and a treaty of peace has the effect of quieting all titles of possession arising from the war, and of putting an end to the claim of all former proprietors to things of which possession was acquired by right of war. If nothing be said to the contrary, things stipulated to be restored are to be returned in the condition in which they were taken, but this does not relate to alterations which have been the natural consequence of time and of the operations of war. A fortress or town is to be restored in the condition it was when taken, as far as it shall still be in that condition when the peace is made. There is no obligation to repair, as well as restore, a dismantled fortress or a ravaged territory. The peace extinguishes all claim for damages done in war or arising from the operation of war. Things are to be restored in the condition the peace found them, and to dismantle a fortification, or to waste a country after the conclusion of the peace and previous to the surrender, would be an act of perfidy. Obligations of treaties. Treaties of every kind, when made by the competent authority, are as obligatory upon nations as private contracts are binding upon individuals, and they are to receive a fair and liberal interpretation according to the intention of the contracting parties, and to be kept with the most scrupulous good faith. Their meaning is to be ascertained by the same rules of construction and course of reasoning which we apply to the interpretation of private contracts. If a treaty should in fact be violated by one of the contracting parties, either by proceedings incompatible with the particular nature of the treaty, or by an intentional breach of any of its articles, it rests alone with the injured party to pronounce it broken. The treaty in such a case is not absolutely void, but voidable at the election of the injured party. If he chooses not to come to a rupture, the treaty remains obligatory. He may waive or remit the infraction committed, or he may demand a just satisfaction. There is a very material and important distinction made by the writers on public law between a new war for some new cause and a breach of a treaty of peace. In the former case, the permanent rights acquired by the treaty subsist, notwithstanding the new war, but in the latter case, they are, at the election of the party injured, annulled by the breach of the treaty of peace on which they are founded. A new war may interrupt the exercise of the rights acquired by the former treaty, and, like other rights, they may be wrested from the rightful party by the force of arms. But then they become to the conqueror newly acquired rights, and partake of the operation and result of the new war. To recommence a war by breach of the articles of a treaty of peace is deemed much more odious than to provoke a war by some new demand and aggression, for the latter is simply injustice, but in the former case the party is guilty both of perfidy and injustice. The violation of any one article of a treaty is a violation of the whole treaty, for all the articles are dependent on each other, and one is to be deemed a condition of the other, and a violation of any single article overthrows the whole treaty, if the injured party elects so to consider it. This may, however, be prevented by an express provision that if one article be broken, the others shall, nevertheless, continue in full force. We have a strong instance in our own history of the annihilation of treaties by the act of the injured party. In 1798, the Congress of the United States declared that the treaties with France were no longer obligatory on the United States, as they had been repeatedly violated on the part of the French government, and all just claims for reparation refused. As a general rule, the obligations of treaties are dissipated by hostility. But if a treaty contains any stipulations which contemplate a state of future war, and make provision for such an exigency, they preserve their force and obligation when the rupture takes place. All those duties of which the exercise is not necessarily suspended by the war subsist in their full force. The obligation of keeping faith is so far from ceasing in a time of war that its efficacy becomes increased from the increased necessity of it. What would become of prisoners of war and the terms of capitulation of garrisons and towns if the word of an enemy was not to be relied on? The faith of promises and treaties which have reference to a state of war is to be held as sacred in war as in peace, and among enemies as among friends. All the writers on public law admit this position, and they have never failed to recommend the duty and the observance of good faith by the most powerful motives, and the most pathetic and eloquent appeals which could be addressed to the reason and to the moral sense of nations. The 10th article of the treaty between the United States and Great Britain in 1794 may be mentioned as an instance of a stipulation made for war. It provided that debts due from individuals of the one nation to those of the other, and the shares or moneys which they might have in the public funds, or in public or private banks, should never in any event of war be sequestered or confiscated. There can be no doubt that the obligation of that article was not impaired by the War of 1812, but remained throughout that war, and continues to this day binding upon the two nations, and will continue so until they mutually agree to rescind the article. For it is a principle of universal jurisprudence that a compact cannot be rescinded by one party only, if the other party does not consent to rescind it, and does not act to destroy it. In the case of the Society for Propagating the Gospel v. New Haven, the Supreme Court of the United States would not admit the doctrine that treaties became extinguished ipso facto by war, unless revived by an express or implied renewal on the return of peace. Such a doctrine is not universally true. Where treaties contemplate a permanent arrangement of national rights, or which by their terms are meant to provide for the event of an intervening war, it would be against every principle of just interpretation to hold them extinguished by the event of war. They revive at peace, unless waived, or new and repugnant stipulations be made. Cessation of territory. With respect to the cessation of places or territories by a treaty of peace, though the treaty operates from the making of it, it is a principle of public law that the national character of the place agreed to be surrendered by treaty continues as it was under the character of the ceding country until it be actually transferred. Full sovereignty cannot be held to have passed by the mere words of the treaty without actual delivery. To complete the right of property, the right to the thing, and the possession of the thing must be united. This is a necessary principle in the law of property in all systems of jurisprudence. There must be both the jus in rem and the jus in re, according to the distinction of the civilians, and which Barbeyrac says they borrowed from the canon law. This general law of property applies to the right of territory no less than to other rights. The practice of nations has been conformable to this principle, and the conventional law of nations is full of instances of this kind, and several of them were stated by Sir William Scott in the opinion which he gave in the case of the Fama. The release of a territory from the dominion and sovereignty of the country, if that cession be the result of coercion or conquest, does not impose any obligation upon the government to indemnify those who may suffer a loss of property by the cession. The Annals of New York furnish a strong illustration of this position. The territory composing the state of Vermont belonged to this state, and it separated from it and erected itself into an independent state without the consent and against the will of the government of New York. The latter continued for many years to object to this separation and to discover the strongest disposition to reclaim by force the allegiance of the inhabitants of that state. But they were unable to do it, and it was a case of a revolution effected by force, analogous to that which was then in action between this country and Great Britain. And when New York found itself under the necessity of acknowledging the independence of Vermont, a question arose before the legislature whether they were bound in duty to make compensation to individual citizens whose property would be sacrificed by the event, because their titles to land lying within the jurisdiction of Vermont and derived from New York would be disregarded by the government of that state. The claimants were heard at the bar of the House of Assembly by counsel in 1787, and it was contended on their behalf that the state was bound, upon the principles of the social compact, to protect and defend the rights and property of all its members, and that, whenever it became necessary, upon grounds of public expediency and policy, to withdraw the protection of government from the property of any of its citizens, without actually making the utmost efforts to reclaim the jurisdiction of the country, the state was bound to make compensation for the loss. In answer to this argument, it was stated that the independence of Vermont was an act of force beyond the power of this state to control, and equivalent to a conquest of that territory, and the state had not the competent ability to recover by force of arms their sovereignty over it, and it would have been folly and ruin to have attempted it. All pacific means had been tried without success, and as the state was compelled to yield to a case of necessity, it had discharged its duty, and it was not required upon any of the doctrines of public law or principles of political or moral obligation to indemnify the sufferers. The cases in which compensation had been made for losses consequent upon revolutions in government were peculiar and gratuitous, and rested entirely on benevolence, and were given from motives of policy or as a reward for extraordinary acts of loyalty and exertion. No government can be supposed to be able, consistently with the welfare of the whole community, and it is therefore not required, to assume the burthen of losses produced by conquest, or the violent dismemberment of the state. It would be incompatible with the fundamental principles of the social compact. This was the doctrine which prevailed, and when the Act of July 14, 1789 was passed, authorizing commissioners to declare the consent of the state to the independence of Vermont, it was expressly declared that the act was not to be construed to give any person claiming lands in Vermont under title from this state any right to any compensation whatsoever from New York. The end of Section 13.
Section 14 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Section 14 of Offences against the Law of Nations, Part 1. The violation of a treaty of peace or other national compact is a violation of the law of nations, for it is a breach of public faith. Nor is it to be understood that the law of nations is a code of mere elementary speculation, without any efficient sanction. It has a real and propitious influence on the fortunes of the human race. It is a code of present, active, durable, and binding obligation. As its great fundamental principles are founded in the maxims of eternal truth, in the immutable law of moral obligation, and in the suggestions of an enlightened public interest, they maintain a steady influence, notwithstanding the occasional violence by which that influence may be disturbed. The law of nations is placed under the protection of public opinion. It is enforced by the censures of the press, and by the moral influences of those great masters of public law, who are consulted by all nations as oracles of wisdom, and who have attained by the mere force of written reason the majestic character and almost the authority of universal lawgivers, controlling by their writings the conduct of rulers, and laying down precepts for the government of mankind. No nation can violate public law without being subjected to the penal consequence of reproach and disgrace, and without incurring the hazard of punishment to be inflicted in open and solemn war by the injured party. The law of nations is likewise enforced by the sanctions of municipal law
and the offences which fall more immediately under its cognizance, and which are the most obvious, the most extensive, and most injurious in their effects, are the violations of safe conduct, infringements of the rights of ambassadors, and piracy. To these we may add the slave trade, which may now be considered not indeed as a piratical trade, absolutely unlawful by the law of nations, but as a trade condemned by the general principles of justice and humanity, openly professed and declared by the powers of Europe. Violation of passports. 1. A safe conduct or passport contains a pledge of the public faith that it shall be duly respected, and the observance of this duty is essential to the character of the government which grants it. The statute law of the United States has provided, in furtherance of the general sanction of public law, that if any person shall violate any safe conduct or passport granted under the authority of the United States, he shall on conviction be imprisoned not exceeding 3 years, and fined at the discretion of the court. Of ambassadors. 2. The same punishment is inflicted upon those persons who infringe the law of nations, by offering violence to the persons of ambassadors and other public ministers, or by being concerned in prosecuting or arresting them, or their domestic servants. This is an offense highly injurious to a free and liberal communication between different governments, and mischievous in its consequences to the dignity and well-being of the nation. It tends to provoke the resentment of the sovereign whom the ambassador represents, and to bring upon the state the calamities of war. The English Parliament, under an impression of the danger to the community from violation of the rights of embassy, and urged by the spur of a particular occasion, carried the provisions of the statute of 7 Anne, chapter 12, to a dangerous extent. That statute prostrated all the safeguards to life, liberty, and property which the wisdom of the English common law had established. It declared that any person convicted of suing out or executing civil process upon an ambassador or his domestic servants, by the oath of the party or of one witness, before the Lord Chancellor and the 2 Chief Justices, or any 2 of them, might have such penalties and corporal punishment inflicted upon him as the judges should think fit. The preamble to the statute contains a special and inflamed recital of the breach of the law of nations which produced it, by the arrest of the Russian minister in the streets of London. The Congress of the United States, during the time of the American War, discovered great solicitude to maintain inviolate the obligations of the law of nations, and to have infractions of it punished in the only way that was then lawful, by the exercise of the authority of the legislatures of the several states. They recommended to the states to provide expeditious, exemplary, and adequate punishment for the violation of safe conducts or passports granted under the authority of Congress to the subjects of a foreign power in time of war, and for the commission of acts of hostility against persons in amity or league with the United States, and for the infractions of treaties and conventions to which the United States were a party, and for infractions of the immunities of ambassadors and other public ministers. Piracy. 3. Piracy is robbery, or a forceful depredation on the high seas without lawful authority, and done animo furandi, and in the spirit and intention of universal hostility. It is the same offense at sea with robbery on land, and all the writers on the law of nations and on the maritime law of Europe agree in this definition of piracy. Pirates have been regarded by all civilized nations as the enemies of the human race, and the most atrocious violators of the universal law of society. They are everywhere pursued and punished with death, and the severity with which the law has animadverted upon this crime arises from its enormity and danger, the cruelty that accompanies it, the necessity of checking it, the difficulty of detection, and the facility with which robberies may be committed upon Pacific traders in the solitude of the ocean. Every nation has a right to attack and exterminate them without any declaration of war, for though pirates may form a loose and temporary association among themselves, and re-establish in some degree those laws of justice which they have violated with the rest of the world, yet they are not considered as a national body, or entitled to the laws of war as one of the community of nations. They acquire no rights by conquest, and the law of nations and the municipal law of every country authorize the true owner to reclaim his property taken by pirates wherever it can be found, and they do not recognize any title to be derived from an act of piracy. The principle that a piratus et latronibus capta dominum non mutant is the received opinion of ancient civilians, and modern writers on general jurisprudence, and the same doctrine was maintained in the English courts of common law prior to the great modern improvements made in the science of the law of nations. By the Constitution of the United States, Congress are authorized to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. In pursuance of this authority, it was declared by the Act of Congress of April 30th, 1790, Chapter 9, Section 8, that murder or robbery committed on the high seas, or in any river, haven, or bay, out of the jurisdiction of any particular state, or any other offense which, if committed within the body of a country, would, by the laws of the United States, be punishable with death, should be adjudged to be piracy and felony, and punishable with death. It was further declared that if any captain or mariner should piratically and feloniously run away with any vessel, or any goods or merchandise to the value of $50, or should yield up any such vessel voluntarily to pirates, or if any seaman should forcibly endeavor to hinder his commander from defending the ship or goods committed to his trust, or should make a revolt in the ship, every such offender should be adjudged a pirate and felon and be punishable with death. Accessories to such piracies before the fact are punishable in like manner, but accessories after the fact are only punishable by a fine and imprisonment. And by the Act of March 3rd, 1819, Chapter 76, Section 5, Congress declared that if any person on the high seas should commit the crime of piracy as defined by the law of nations, he should on conviction suffer death. This act was but temporary in its limitation and has expired, but it was again declared, and essentially to the same effect, by the Act of Congress of 15th of May, 1820, Chapter 113, Section 3, that if any person upon the high seas, or in any open roadstead, or bay or river, where the sea ebbs and flows, commits the crime of robbery in and upon any vessel, or the lading thereof, or the crew, he shall be adjudged a pirate. So if any person engaged in any piratical enterprise, or belonging to the crew of any piratical vessel, should land and commit robbery on shore, such an offender shall also be adjudged a pirate. The statute in this respect seems to be only declaratory of the law of nations, and upon the doctrine of the case of Lindo v. Rodney, such plunder and robbery ashore, by the crew, and with the aid of vessels, is a marine case and of admiralty jurisdiction. The statute further declared that the above provision was not to be construed to deprive any particular state of its jurisdiction over such offenses, when committed within the body of a county, or to authorize the courts of the United States to try any such offenders after conviction or acquittance for the same offense in a state court. Under these legislative provisions, it has been made a question whether it was sufficient to refer to the law of nations for a definition of piracy without giving the crime a precise definition in terms. The point was settled in the case of the United States v. Smith, and it was there held not to be necessary to give by statute a more logical enumeration in detail of all the facts constituting the offense, and that Congress might as well define it by using a term of a known and determinate meaning, as by expressly mentioning all the particulars included in that term. The crime of piracy was defined by the law of nations with reasonable certainty, and it does not depend upon the particular provisions of any municipal code for its definition and punishment. Robbery on the high seas is, therefore, piracy by the Act of Congress as well as by the law of nations. There can be no doubt of the right of Congress to pass laws punishing pirates, though they may be foreigners, and may have committed no particular offense against the United States. It is of no importance for the purpose of giving jurisdiction on whom or where a piratical offense has been committed. A pirate, who is one by the law of nations, may be tried and punished in any country where he may be found, for he is reputed to be out of the protection of all laws and privileges. The statute of any government may declare an offense committed on board its own vessels to be piracy, and such an offense will be punishable exclusively by the nation which passes the statute. But piracy under the law of nations is an offense against all nations, and punishable by all. In the case of the United States v. Palmer, it was held that the Act of Congress of 1790 was intended to punish offenses against the United States, and not offenses against the human race, and that the crime of robbery, committed by a person who was not a citizen of the United States on the high seas, on board of a ship belonging exclusively to subjects of a foreign state, was not piracy under the Act, and was not punishable in the courts of the United States. The offense in such a case must therefore be left to be punished by the nation under whose flag the vessel sailed, and within whose particular jurisdiction all on board the vessel were. This decision was according to the law and practice of nations, for it is a clear and settled principle that the jurisdiction of every nation extends to its own citizens on board of its own public and private vessels at sea. The case applied only to the fact of robbery committed at sea on board of a foreign vessel, at the time belonging exclusively to subjects of a foreign state, and it was not intended to decide that the same offense, committed on board of a vessel not belonging to the subject of any foreign power, was not piracy. The same court afterwards, in the case of United States v. Clintock, admitted that murder or robbery committed on the high seas by persons on board of a vessel not at that time belonging to the subjects of any foreign power, but in possession of a crew acting in defiance of all law, and acknowledging obedience to no government or flag whatsoever, fell within the purview of the Act of Congress, and was punishable in the courts of the United States. Persons of that description were pirates and proper objects for the penal code of all nations. The Act of Congress did not apply to offenses committed against the particular sovereignty of a foreign power, or to murder or robbery committed in a vessel belonging at the time, in fact as well as in right, to the subject of a foreign state, and in virtue of such property subject at the time to its control. But it applied to offenses committed against all nations by persons who, by common consent, were equally amenable to the laws of all nations. It was further held in the case of United States v. Pirates, and in the case of the United States v. Holmes, in pursuance of the same principle, that the moment a vessel assumed a piratical character, and was taken from her officers, and proceeded on a piratical cruise, she lost all claim to national character, and the crew, whether citizens or foreigners, were equally punishable under the Act of Congress for acts of piracy, and it would be immaterial what was the national character of the vessel before she assumed a piratical character. Piracy is an offense within the criminal jurisdiction of all nations. It is against all and punished by all, and the plea of autrefois acquit, resting on a prosecution instituted in the courts of any civilized state, would be a good plea in any other civilized state. As the Act of Congress of 1790 declares every offense committed at sea to be piracy, which would be punishable with death if committed on land, it may be considered as enlarging the definition of piracy so as not only to include every offense which is piracy by the law of nations, and the Act of Congress of 1819, but other offenses which were not piracy until made so by statute. An alien under the sanction of a national commission cannot commit piracy while he pursues his authority. His acts may be hostile, and his nation responsible for them. They may amount to a lawful cause of war, but they are never to be regarded as piracy. The Barbary powers, notwithstanding some doubts which formerly existed, are now, and for a century past have been, regarded as lawful powers and not pirates. They have all the insignia of regular independent governments, and are competent to maintain the European relations of peace and war. Cicero, and after him Grotius, define a regular enemy to be a power which hath the elements or constituents of a nation, such as a government, a code of laws, a national treasury, the consent and agreement of the citizens, and which pays a regard to treaties of peace and alliance. And all these things, says Bickershoek, are to be found among the states of Barbary. In some respects their laws of war have retained the barbarity of the Middle Ages, for they levy tribute or contributions on all such Christian powers as are not able to protect their commerce by force, and they also make slaves of their prisoners, and require a heavy ransom for their redemption. But this, Bickershoek insists, is conformable to the strict laws of war, and the nations of Europe who carried on war with the Barbary states, such as Spain, Naples, Holland, etc., have heretofore exercised the same rule of ancient warfare upon the principle of retaliation. When Lord Exmouth, in 1816, attacked Algiers, and compelled the Dey to terms of peace, he compelled him also to stipulate that in the event of future wars with any European power, no Christian prisoners of war should be consigned to slavery, but they should be treated with all humanity as prisoners of war until regularly exchanged according to the European practice, and at the termination of hostilities the prisoners should be restored without ransom. By that treaty of peace, upwards of 1,000 prisoners belonging to Italy, Spain, Portugal, Holland, and Greece were released from galling slavery, and in which part of them had subsisted for 35 years. This stipulation in favor of general humanity deserves some portion of that exalted eulogy bestowed by Montesquieu on the treaty made by Gelon, king of Syracuse, with the Carthaginians. It would have been still more worthy of a comparison if it had not left color for the construction that the renunciation of the practice of condemning Christian prisoners of war to slavery was to be confined to the event of future wars with any European power, and if a great Christian power on this side of the Atlantic, whose presence and whose trade are constantly seen and felt in the Mediterranean, had not seemed to have been entirely forgotten. But notwithstanding Binkershoek had insisted, near a century ago, that captures by the Barbary powers worked a change of property by the laws of war, in like manner as captures made by regular powers. Yet, in a case in which the English Admiralty, so late as 1801, it was contended that the capture and sale of an English ship by Algerines was an invalid and unlawful conversion of the property, on the ground of being a piratical seizure. It was, however, decided that the African states had long acquired the character of established governments, and that, though their notions of justice differ from those entertained by the Christian powers, their public acts could not be called in question, and a derivative title, founded on an Algerine capture, and matured by a confiscation in their way, was good against the original owner. In the time of Richard I, when the laws of Oleron were compiled, all infidels were, by that code, regarded as pirates, and their property liable to seizure wherever found. It was a notion at that time that such persons could not have any fellowship or communion with Christians. In a case which occurred in 1675, Sir Leoline Jenkins held that the commander of a privateer regularly commissioned was liable to be treated as a pirate if he exceeded the bounds of his commission. Binkershoek justly opposes this dangerous opinion, and the true rule undoubtedly is that the vessel must have lost its national and assumed a piratical character before jurisdiction over it to that extent could be exercised. If a natural-born subject was to take prizes belonging to his native country in pursuance of a foreign commission, he would, on general principles, be protected by his commission from the charge of piracy. But to prevent the mischief of such conduct, the United States have followed the provisions of the English statute of 11 and 12 William III, Chapter 7, and the general practice of other nations, and have, by the Act of Congress of April 30, 1790, Section 9, declared that if any citizen should commit any act of hostility against the United States, or any citizen thereof upon the high seas, under color of any commission from any foreign prince or state, or on pretense of authority from any person, such offender shall be adjudged to be a pirate, felon, and robber, and on being thereof convicted shall suffer death. The Act of Congress not only authorizes a capture but a condemnation in the courts of the United States for all piratical aggressions by foreign vessels, and whatever may be the responsibility incurred by the nation to foreign powers in executing such laws, there can be no doubt that courts of justice are bound to obey and administer them. All such hostile and criminal aggressions on the high seas, under the flag of any power, render property taken in delicto subject to confiscation by the law of nations. The end of Section 14. Section 15 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Shoesmith. Commentaries on American Law, Volume 1, by James Kent. Section 15 of Offences against the Law of Nations, Part 2. Slave Trade. 4. The African slave trade is an offense against the municipal laws of most nations in Europe, and it is declared to be piracy by the statute laws of England and the United States. Whether it is to be considered as an offense against the law of nations, independent of compact, has been a grave question, much litigated in the courts charged with the administration of public law, and it will be useful to take a short view of the progress and present state of the sense and practice of nations on this subject. Personal slavery, arising out of forcible captivity, has existed in every age of the world, and among the most refined and civilized people. The possession of persons so acquired has been invested with the character of property. captives in war were sold as slaves by Greek and Roman commanders. The slave trade was a regular branch of commerce among the ancients, and a great object of Athenian traffic with the Greek settlements on the Euxine was procuring slaves from the barbarians for the Greek market. In modern times, treaties have been framed and national monopolies sought to facilitate and extend commerce in this species of property. It has been interwoven in the municipal institutions of all the European colonies in America, and with the approbation and sanction of the parent states. It forms to this day the foundation of large masses of property in the southern parts of these United States. But for half a century past, the African slave trade began to awaken a spirit of remorse and sympathy in the breasts of men, and a conviction that the traffic was repugnant to the principles of Christian duty and the maxims of justice and humanity. Montesquieu, who has disclosed so many admirable truths and so much profound reflection, in his Spirit of Laws not only condemned all slavery as useless and unjust, but he animadverted upon the African slave trade by the most pungent reproaches. It was impossible, he observed, that we could admit the Negroes to be human beings, because if we were once to admit them to be men, we should soon come to believe that we ourselves were not Christians. Why has it not, says he, entered into the heads of European princes, who make so many useless conventions, to make one general stipulation in favor of humanity? We shall see presently that this suggestion was in some degree carried into practice by a modern European Congress. The Constitution of the United States laid the foundation of a series of provisions to put a final stop to the progress of this great moral pestilence by admitting a power in Congress to prohibit the importation of slaves after the expiration of the year 1807. The Constitution evidently looked forward to the year 1808 as the commencement of an epoch in the history of human improvement. Prior to that time, Congress did all on this subject that it was within their competence to do. By the Acts of March 22, 1794, and May 10, 1800, the citizens of the United States, and residents within them, were prohibited from engaging in the transportation of slaves from the United States to any foreign place or country, or from one foreign country or place to another for the purpose of traffic. These provisions prohibited our citizens from all concern in the slave trade, with the exception of direct importation into the United States, and the most prompt and early steps were taken, within the limits of the Constitution, to interdict also that part of the traffic. By the Act of 2nd March 1807, it was prohibited under severe penalties to import slaves into the United States after the 1st January 1808, and on the 20th April 1818 the penalties and punishments were increased, and the prohibition extended not only to importation, but generally against any citizen of the United States being concerned in the slave trade. It has been decided that these statute prohibitions extend as well to the carrying slaves on freight as to cases where they were the property of American citizens, and to carrying them from one port to another of the same foreign empire, as well as from one foreign country to another. The object was to prevent, on the part of our citizens, all concern whatever in such a trade. The Act of March 3, 1819, went a step further, and authorized national armed vessels to be sent to the coast of Africa to stop the slave trade, so far as citizens or residents of the United States were engaged in that trade, and their vessels and effects were made liable to seizure and confiscation. The Act of 15th May, 1820, went still further and declared that if any citizen of the United States, being of the crew of any foreign vessel engaged in the slave trade, or any person whatever, being of the crew of any vessel owned in whole or in part, or navigated for or in behalf of any citizen of the United States, should land on any foreign shore, and seize any Negro or mulatto not held to service or labor by the laws of either of the states or territories of the United States, with intent to make him a slave, or should decoy or forcibly bring or receive such person on board such vessel with like intent, or should forcibly confine or detain on board any Negro or mulatto not lawfully held to service with intent to make him a slave, or should on board any such vessel offer to sell as a slave any Negro or mulatto not held to service as aforesaid, or should on the high seas or on any tidewater transfer or deliver over to any other vessel any such Negro or mulatto with intent to make him a slave, or should deliver on shore, from on board any such vessel, any negro or mulatto with like intent. Such citizen or person should be adjudged a pirate, and, on conviction, should suffer death. It is to be observed that the statute operates only where our municipal jurisdiction might be applied consistently with the general theory of public law to the persons of our citizens or to foreigners on board of American vessels. Declaring the crime piracy does not make it so within the purview of the law of nations, if it were not so without the statute, and the legislature intended to legislate only where they had a right to legislate over their own citizens and vessels. The question, notwithstanding these expressions in the statute, still remained to be discussed and settled, whether the African slave trade could be adjudged piracy or any other crime within the contemplation of the Code of International Law. It has been attempted, by negotiation between this country and Great Britain, to agree that both nations should consider the slave trade piratical, but the convention for that purpose between the two nations has not yet been ratified, though the British nation have carried their statute denunciation of the trade as far as the law of the United States. The first British statute that declared the slave trade unlawful was in March 1807. This was a great triumph of British justice. It was called for by the sense of the nation, which had become deeply convinced of the impolicy and injustice of the slave trade, and by the subsequent statute of 51 George III. The trade was declared to be contrary to the principles of justice, humanity, and sound policy. And lastly, by the Act of Parliament of 31st March 1824, the trade is declared to be piracy. England is thus, equally with the United States, honestly and zealously engaged in promoting the universal abolition of the trade and in holding out to the world her sense of its extreme criminality. Almost every maritime nation in Europe has deliberately and solemnly, either by legislative acts or by treaties and other formal engagements, acknowledged the injustice and inhumanity of the trade and pledged itself to promote its abolition. By the Treaty of Paris of the 30th May 1814, between Great Britain and France, Louis XVIII agreed that the traffic was repugnant to the principles of natural justice, and he engaged to unite his efforts at the ensuing Congress to induce all the powers of Christendom to decree the abolition of the trade, and that it should cease definitively on the part of the French government in the course of 5 years. The ministers of the principal European powers, who met in Congress at Vienna on the 8th February 1815, solemnly declared, in the face of Europe and the world, that the African slave trade had been regarded by just and enlightened men in all ages as repugnant to the principles of humanity and of universal morality, and that the public voice in all civilized countries demanded that it should be suppressed, and that the universal abolition of it was conformable to the spirit of the age and the generous principles of the Allied powers. In March 1815, the Emperor Napoleon decreed that the slave trade should be abolished, but this effort of ephemeral power was afterwards held to be null and void, as being the act of a usurper, and in July following, Louis XVIII gave directions that this odious and wicked traffic should from that present time cease. The first French decree, however, that was made public, abolishing the trade, was of the date of the 8th January 1817, and that was only a partial and modified decree. In December 1817, the Spanish government prohibited the purchase of slaves on any part of the coast of Africa after the 31st of May 1820, and this was in pursuance of the treaty between Great Britain and Spain of the 23rd September 1817, made for the abolition of the slave trade. In January 1818, the Portuguese government made the like prohibition as to the purchase of slaves on any part of the coast of Africa north of the equator. In 1821, there was not a flag of any European state which could legally cover this traffic to the north of the equator, and yet, in 1825, the importation of slaves covertly continued, if it was not openly countenanced, from the Rio de la Plata to the Amazon and through the whole American archipelago. The case of the Amédée was the earliest decision in the English courts on the great question touching the legality of the slave trade on general principles of international law. That was the case of an American vessel employed in carrying slaves from the coast of Africa to a Spanish colony. She was captured by an English cruiser, and the vessel and cargo were condemned to the captors in a vice-admiralty court in the West Indies, and on appeal to the Court of Appeals in England, the judgment was affirmed. Sir William Grant, who pronounced the opinion of the court, observed that the slave trade being abolished by both England and the United States, the court was authorized to assert that the trade, abstractly speaking, could not have a legitimate existence, and was, prima facie, illegal, upon principles of universal law. The claimant, to entitle him to restitution, must show affirmatively a right of property under the municipal laws of his own country, for if it be unprotected by his own municipal law, he can have no right of property in human beings carried as his slaves, for such a claim is contrary to the principles of justice and humanity. The Fortuna was condemned on the authority of the Amédée, and the same opinion was again affirmed. But in the subsequent case of the Diana, the doctrine was not carried so far as to hold the trade itself to be piracy or a crime against the law of nations. A Swedish vessel was taken by a British cruiser on the coast of Africa, engaged in carrying slaves from Africa to a Swedish island in the West Indies, and she was restored to the owner on the ground that Sweden had not then prohibited the trade, and had tolerated it in practice. England had abolished the trade as unjust and criminal, but she claimed no right of enforcing that prohibition against the subjects of those states which had not adopted the same opinion. And England did not mean to set herself up as the legislator and custos morum for the whole world, or presume to interfere with the commercial regulations of other states. The principle of the case of the Amédée was that where the municipal law of the country to which the parties belonged had prohibited the trade, English tribunals would hold it to be illegal, upon general principles of justice and humanity, but they would respect the property of persons engaged in it under the sanction of the laws of their own country. The doctrine of these cases is that the slave trade, abstractedly speaking, is immoral and unjust, and it is illegal when declared so by treaty or municipal law, but that it is not piratical or illegal by the common law of nations, because if it were so, every claim founded on the trade would at once be rejected everywhere and in every court on that ground alone. The whole subject underwent further and a most full, elaborate, and profound discussion in the case of the Le Louis. A French vessel, owned and documented as a French vessel, was captured by a British armed force on the coast of Africa, after resistance made to a demand to visit and search. She was carried into Sierra Leone, and condemned by a court of vice-admiralty for being concerned in the slave trade, contrary to the French law. On appeal to the British High Court of Admiralty, the question respecting the legality of the capture and condemnation was argued, and it was judicially decided that the right of visitation and search on the high seas did not exist in time of peace. If it belonged to one nation, it equally belonged to all, and would lead to gigantic mischief and universal war. Other nations had refused to accede to the English proposal of a reciprocal right of search in the African seas, and it would require an express convention to give the right of search in time of peace. The slave trade, though unjust and condemned by the statute law of England, was not piracy, nor was it a crime by the universal law of nations. To make it piracy, or such a crime, it must have been so considered and treated in practice by all civilized states, or made so by virtue of a general convention. On the contrary, it had been carried on by all nations, even by Great Britain herself, until within a few years, and was then carried on by Spain and Portugal, and not absolutely prohibited by France. It was therefore not a criminal traffic by the law of nations, and every nation, independent of treaty, retained a legal right to carry it on. No one nation had a right to force the way to the liberation of Africa by trampling on the independence of other states, or to procure an eminent good by means that were unlawful, or to press forward to a great principle by breaking through other great principles that stood in the way. The condemnation of the French vessel at Sierra Leone was, therefore, reversed, and the penalties imposed by the French law, if any there were left to be enforced, not in an English, but in a French court. The same subject was brought into discussion in the K.B. in 1820, in Madrazo v. Willis. The court held that the British statutes against the slave trade were only applicable to British subjects, and only rendered the slave trade unlawful when carried on by them. The British Parliament could not prevent the subjects of other states from carrying on the trade out of the limits of the British dominions. If a ship be acting contrary to the general law of nations, she is thereby subject to condemnation, but it is impossible to say that the slave trade was contrary to the law of nations. It was, until lately, carried on by all the nations of Europe, and a practice so sanctioned can only be rendered illegal on the principle of international law by the consent of all the powers. Many states had so consented, but others had not, and the cases had gone no further than to establish the rule that ships belonging to countries that had prohibited the trade were liable to capture and condemnation if found engaged in it. The final decision of the question in this country has been the same as in the case of the Le Louis. In the case of the La Jeune Eugénie, it was decided in the Circuit Court of the United States in Massachusetts, after a masterly discussion, that the slave trade was prohibited by universal law. But subsequently, in the case of the Antelope, the Supreme Court of the United States declared that the slave trade, though contrary to the law of nature, had been sanctioned in modern times by the laws of all nations who possessed distant colonies, and a trade could not be considered as contrary to the law of nations, which had been authorized and protected by the usages and laws of all commercial nations. It was not piracy, except so far as it was made so by the treaties or statute of the nation to which the party belonged. It might still be lawfully carried on by the subjects of those nations who have not prohibited it by municipal acts or treaties. The end of section 15.
Section 16 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of the History of the American Union. The government of the United States was erected by the free voice and joint will of the people of America for their common defense and general welfare. Its powers apply to those great interests which relate to this country in its national capacity, and which depend for their stability and protection on the consolidation of the Union. It is clothed with the principal attributes of political sovereignty, and it is justly deemed the guardian of our best rights, the source of our highest civil and political duties, and the sure means of national greatness. The Constitution and jurisprudence of the United States deserve the most accurate examination, and a historical view of the rise and progress of the Union and of the establishment of the present Constitution, as the necessary fruit of it, will tend to show the genius and value of the government, and prepare the mind of the student for an investigation of its powers. The association of the American people into one body politic took place while they were colonies of the British Empire and owed allegiance to the British Crown. That the union of this country was essential to its safety, its prosperity, and its greatness had been generally known, and frequently avowed long before the late Revolution or the claims of the British Parliament which produced it. Confederacy of the New England Colonies. The people of the New England colonies were very early in the habit of confederating together for their common defense. As their origin and their interests were the same, and their manners, their religion, their laws, and their civil institutions exceedingly similar, they were naturally led to a very intimate connection, and were governed by the same wants and wishes, the same sympathies and spirit. The colonies of Massachusetts, Plymouth, Connecticut, and New Haven, as early as 1643, under the impression of danger from the surrounding tribes of Indians, and for protection against the claims and encroachments of their Dutch neighbors, entered into a league offensive and defensive, which they declared should be firm and perpetual, and be distinguished by the name of the United Colonies of New England. By their Articles of Confederation, each colony was to have exclusive jurisdiction within its own territory, and in every war, offensive and defensive, each of the Confederates was to furnish its quota of men and money in a ratio to its population. And a Congress of 2 commissioners delegated from each colony was to be held annually, with power to deliberate and decide on all affairs of war and peace, and on all points of common concern. And every determination in which 3/4 in numbers of the assembly concurred was to be binding upon the whole Confederacy. This association may be considered as the foundation of a series of efforts for a more extensive and more perfect union of the colonies. It contained some provident and jealous provisions calculated to give security and stability to the whole. It provided that no 2 colonies were to join in jurisdiction without the consent of all, and it required the like unanimous consent to admit any other colony into the Confederacy. And if any one member violated any article of it or any way injured another colony, the commissioners of the other colonies were to take cognizance of the matter and determine upon it. In this transaction and under the authority of this union, the New England colonies acted in fact as independent states, and free from the control of any superior power, because the civil war in which England was then involved occupied the whole attention of the mother country, and this first step towards a future independence was suffered to pass without much notice and without any animadversion. The Confederacy subsisted with some alterations for upwards of 40 years, and for part of that time with the countenance of the government in England. It was not dissolved until the year 1686, when the charters of the New England colonies were in effect vacated by a commission from King James II. The people of this country, after the dissolution of this earliest league, continued to afford other instructive precedents of association for their safety. Congress of 1754. A Congress of governors and commissioners from other colonies, as well as from New England, was occasionally held to make arrangements for the more effectual protection of our interior frontier, and we have an instance of one of these assemblies at Albany in 1722. But a much more interesting Congress was held there in the year 1754, and it consisted of commissioners from New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, Pennsylvania, and Maryland, and it was called at the instance of the Lords Commissioners for Trade and the Plantations to take into consideration the best means of defending America in case of a war with France, which was then impending. The object of the English administration in calling this convention was in reference to treaties of friendship with the Indian tribes. But the colonies had more enlarged views, and the commissioners which met in Congress and who enrolled among their number some of the most distinguished names in our colonial history asserted and promulgated several invaluable truths, the proper reception of which in the minds of their countrymen prepared the way for their future independence and our present greatness. One of the colonies, Massachusetts, expressly instructed her delegates to enter into articles of union and confederation with the other colonies for their general security in peace as well as in war. The convention unanimously resolved that a union of the colonies was absolutely necessary for their preservation. They rejected all proposals for a division of the colonies into separate confederacies and proposed a plan of federal government consisting of a general council of delegates to be triennially chosen by the provincial assemblies and a president general to be appointed by the crown. In this council was vested, subject to the immediate negative of the president and the eventual negative of the king in council, the rights of war and peace in respect to the Indian nations, and the Confederacy was to embrace all the then existing colonies from New Hampshire to Georgia. The council were to have authority to make laws for the government of new settlements upon territories to be purchased from the Indians, and to raise troops and build forts, and even to equip vessels of force to guard the coast and protect trade, as well as on the ocean as upon the lakes and rivers. They were likewise to make laws and lay and levy general duties, imposts, and taxes for those necessary proposes. But the times were not yet ripe, nor the minds of men sufficiently enlarged, for such a comprehensive proposition, and this bold project of a continental union had the singular fate of being rejected, not only on the part of the crown, but by every provincial assembly. It was probably supposed, on the one hand, that the operation of the union would teach the colonies the secret of their own strength, and the proper means to give it activity and direction, while, on the other, the colonies were jealous of the preponderating influence of the royal prerogative. We were destined to remain for some years longer separate and in a considerable degree alien commonwealths, emulous of each other in obedience to the parent state, and in devotion to her interests, but jealous of each other's prosperity and divided by policy, institutions, prejudice, and manners. So strong was the force of these considerations, and so exasperated were the people of the colonies in their disputes with each other concerning boundaries and charter claims, that Dr. Franklin, who was one of the commissioners to the Congress that formed the plan of union in 1754, observed in the year 1760 that a union of the colonies against the mother country was absolutely impossible, or at least without being forced by the most grievous tyranny and oppression. Congress of 1765. The great value of a federate union of the colonies had, however, sunk deep into the minds of men. The subject was familiar to our colonial ancestors. They had been in the habit, especially in seasons of danger and difficulty, of forming associations more or less extensive. The necessity of union had been felt, its advantages perceived, its principles explained, the way to it pointed out, and the people of this country were led by the force of irresistible motives to resort to the same means of defense and security when they considered that their liberties were in danger, not from the vexations and irregular warfare of the Indian tribes, but from the formidable claims and still more formidable power of the parent state. The assertion by the British Parliament of an unqualified right of binding the colonies in all cases whatsoever, and specifically of the right of taxing them without their consent, and the denial by the colonies of the right of taxation without representation, and the attempt of the King and Parliament to enforce it by the power of the sword, were the immediate causes of the American Revolution. Soon after the first unfriendly attempt upon our chartered privileges by the statute for raising a revenue in the colonies by means of a stamp duty, a Congress of delegates from 9 colonies was assembled at New York in October 1765. Upon the recommendation of Massachusetts, and they digested a Bill of Rights in which the sole power of taxation was declared to reside in their own colonial legislatures. This was preparatory to a more extensive and general association of the colonies, which took place in September 1774 and laid the foundations of our independence and permanent glory. Congress of 1774. The more serious claims of the British Parliament and the impending oppressions of the British Crown at this last critical period induced the 12 colonies which were spread over this vast continent from Nova Scotia to Georgia to an interchange of opinions and views, and to unite in sending delegates to Philadelphia, with authority and direction to meet and consult together for the common welfare. In pursuance of their authority, this First Continental Congress, whose names and proceedings are still familiar to the present age, and will live in the gratitude of a distant posterity, took into consideration the afflicted state of their country, asserted by a number of declaratory resolutions what they deemed to be the unalienable rights of English freemen, pointed out to their constituents the system of violence which was preparing against those rights, and bound them by the most sacred of all ties, the ties of honor and of their country, to renounce commerce with Great Britain as being the most salutary means to avert the one and to secure the blessings of the other. These resolutions received prompt and universal obedience, and the Union being thus auspiciously formed, it was continued by a succession of delegates in Congress, and through every period of the war and through every revolution of our government, this Union has been revered and cherished as the guardian of our peace and the only solid foundation of national independence. In May 1775, a Congress again assembled at Philadelphia and was clothed with ample discretionary powers. The delegates were chosen, as those of the preceding Congress had been, partly by the popular branch of the colonial legislatures when in session, but principally by conventions of the people in the several colonies. They were instructed to concert, agree upon, direct order, and prosecute such measures as they should deem most fit and proper to obtain redress of American grievances, or, in more general terms, they were to take care of the liberties of the country. Soon after this meeting, Georgia acceded to and completed the confederacy of the 13 colonies. Hostilities had already commenced in the province of Massachusetts, and the claim of the British Parliament to an unconditional and unlimited sovereignty over the colonies was to be asserted by an appeal to arms. The Continental Congress, charged with the protection of the rights and interests of the people of the United Colonies, and entrusted with the power and sustained by the zeal and confidence of their constituents, prepared for resistance. They published a declaration of the causes and necessity of taking up arms, and proceeded immediately to levy and organize an army, to prescribe rules for the government of their land and naval forces, to contract debts, and emit a paper currency upon the faith of the Union. And gradually assuming all the powers of national sovereignty, they at last, on the 4th day of July, 1776, took a separate and equal station among the nations of the earth by declaring the United Colonies to be free and independent states. Declaration of Independence. This memorable declaration, in imitation of that published by the United Netherlands on a similar occasion, recapitulated the oppressions of the British King, asserted it to be the natural right of every people to withdraw from tyranny, and with the dignity and fortitude of conscious rectitude it contained a solemn appeal to mankind, in vindication of the necessity of the measure. By this declaration made in the name and by the authority of the people, the colonies were absolved from all allegiance to the British Crown, and all political connection between them and Great Britain was totally dissolved. The principle of self-preservation and the right of every community to freedom and happiness gave a sanction to this separation. When the government established over any people becomes incompetent to fulfill its purpose, or destructive to the essential ends for which it was instituted, it is the right of that people, founded on the law of nature and the reason of mankind, and supported by the soundest authority and some very illustrious precedents, to throw off such government and provide new guards for their future security. This right is the more apparent, and the duty of exercising it becomes the more clear and unequivocal in the case of colonies, which are situated at a great distance from the mother country, and which cannot be governed by it without vexations and continually increasing inconvenience. And when they have arrived at maturity in strength and resources, or in the language of Montesquieu, which he applied to our very case, when they have grown great nations in the forest they were sent to inhabit. If, in addition to these intrinsic causes gradually and powerfully tending to a separation, the parent state should think fit, in the arrogance of power and superiority, to deny to her colonies the equal blessings of her own free government, and should put forth a claim to an unlimited control in her own discretion over all their rights and the whole administration of their affairs, the consequence would then be almost inevitable that the colonists would rise and repel the claim. And more certainly would this be the case if they were a spirited and intelligent race of men true to themselves and just to their posterity. Articles of Confederation. The general opinion in favor of the importance and value of the Union appears evident in all the proceedings of Congress, and as early as the Declaration of Independence it was thought expedient for its security and duration to define with precision and by a formal instrument the nature of our compact, the powers of Congress, and the residuary sovereignty of the states. On the 11th of June, 1776, Congress undertook to digest and prepare Articles of Confederation, but the business was attended with much embarrassment and delay, and notwithstanding these states were then surrounded by the same imminent dangers, and were contending for the same illustrious prize, it was not until the 15th of November, 1777, that Congress could so far unite the discordant interests and prejudices of 13 distinct communities as to agree to the Articles of Confederation. And when those articles were submitted to the state legislatures for their perusal and ratification, they were declared to be the result of impending necessity and of a disposition for conciliation, and that they were agreed to, not for their intrinsic excellence, but as the best system which could be adapted to the circumstances of all, and at the same time afford any tolerable prospect of general assent. These celebrated articles met with still greater obstacles in their progress through the states. Most of the legislatures ratified them with a promptitude which showed their sense of the necessity of the Confederacy and of the indulgence of a liberal spirit of accommodation. But Delaware did not accede to them until the year 1779, and Maryland explicitly rejected them. She instructed her delegates to withhold their assent to the articles until there was an amendment or additional agreement to appropriate the uncultivated and unpatented lands in the western parts of the Union as a common fund to defray the expenses of the war. These lands were claimed by the states within whose asserted limits and jurisdictions they were situated, and several of them, from a deep sense of the importance of the Union, agreed to an unconditional ratification of the Articles, or in other words, to a separate confederacy between the states so ratifying the same, though Maryland or other states should withhold their approbation and sanction. The legislature of New York, by their acts of the 23rd of October, 1779, and 19th of February, 1780, even consented to a release of the unsettled lands in the western part of the state for the use and benefit of such of the United States as should become members of the Federal Alliance, and to resign the jurisdiction as well as the right of preemption over her waste and uncultivated territory. The refusal of Maryland, so long persisted in, gave encouragement to the enemy and injured the common cause and dampened the hopes of the friends of America at home and abroad. These considerations at last induced that state to make a generous sacrifice of her pretensions, and on the 1st of March, 1781, and which was upward of 3 years from their first promulgation, the Articles of Confederation received the unanimous approbation of the United States. The difficulties which impeded the framing and adopting the Articles of Confederation even during the pressure of common calamity, and which nothing at last but a sense of common danger could surmount, form a striking example of the mighty force of local interests and discordant passions, and they teach a monetary lesson of moderation to political councils. Notwithstanding the Articles of Confederation conferred upon Congress, though in a very imperfect manner and under a most unskillful organization, the chief rights of the political supremacy, the jura summi imperii, by which our existence as an independent people was bound up together, and known and acknowledged by the nations of the world. Yet they were, in fact, but a digest and even a limitation in the shape of a written compact, of those undefined and discretionary sovereign powers which were delegated by the people of the colonies to Congress in 1775, which had been freely exercised and implicitly obeyed. A remarkable instance of the exercise of this original, dormant, and vast discretion appears on the Journals of Congress, the latter end of the year 1776. The progress of the British arms had, at that period, excited the most alarming apprehensions for our safety, and Congress transferred to the Commander-in-Chief, for the term of 6 months, complete dictatorial power over the liberty and property of the citizens of the United States, in like manner as the Roman Senate, in the critical times of the Republic, was wont to have recourse to a dictator Ne quid res publica detrimenti capiat. Such loose, undefined authority as the Union originally possessed was absolutely incompatible with any regular notions of liberty. Though it was exercised in the instance we have referred to and in other strong cases with the best intentions and under the impulse of an irresistible necessity, yet such an irregular sovereignty never can be durable. It will either dwindle into insignificance or degenerate into despotism. Imbecility of the Confederation. The powers of Congress, as enumerated in the Articles of Confederation, would perhaps have been competent for all the essential purposes of the Union, had they been duly distributed among the departments of a well-balanced government and been carried down, through the medium of a national judicial and executive power, to the individual citizens of the Union. The exclusive cognizance of our foreign relations, the rights of war and peace, and the right to make unlimited requisitions of men and money were confided to Congress, and the exercise of them was binding upon the states. But, in imitation of all the former confederacies of independent states, either in ancient Greece or in modern Europe, the Articles of Confederation carried the decrees of the Federal Council to the states in their sovereign or collective capacity. This was the great fundamental defect in the Confederation of 1781. It led to its eventual overthrow, and it had proved pernicious or destructive to all other federal governments which adopted the principle. Disobedience to the laws of the Union must either be submitted by the government to its own disgrace, or those laws must be enforced by arms. The mild influence of the civil magistrate, however strongly it may be felt and obeyed by private individuals, will not be heeded by an organized community conscious of its strength and swayed by its passions. The history of the federal governments of Greece, Germany, Switzerland, and Holland afford melancholy examples of destructive civil war springing from the disobedience of the separate members. I will mention only a single instance to this effect taken from the generally uninteresting annals of the Swiss cantons. By one of the articles of the Helvetic Alliance, the cantons were bound to submit any difference which might arise between them to arbitrators. In the year 1440, a dispute arose between Zurich on the one side and the cantons of Schwyz and Glarus on the other, respecting some territorial claims. Zurich refused to submit to a decision against her, and the contending parties took to arms. All Switzerland was, of course, armed against Zurich, the refractory member. She sought protection from her ancient enemy, the House of Austria, and the controversy was not terminated in favor of the federal decree until after 6 years of furious and destructive war. Had there been sufficient energy in the government of the United States under the Articles of Confederation to have enforced the constitutional requisitions, it might have proved fatal to public liberty, for Congress as then constituted was a most unfit and unsafe depository of political power, since all the authority of the nation in one complicated mass of jurisdiction was vested in a single body of men. It was, indeed, exceedingly fortunate, as the event had subsequently shown, that the state legislatures even refused to confer upon Congress the right to levy and collect a general impost, notwithstanding the refusal appeared to be extremely disastrous at the time, and was deeply regretted by the intelligent friends of the Union. Had such a power been granted, the effect to amend the Confederation would probably not have been made, and the people of this country might have been languishing to this day, the miserable victims of a feeble and incompetent Union. There was no provision in the Articles of Confederation enabling Congress to add a sanction to its laws. In this respect, they were more defective than some of the other federal governments which are to be met with in history. The Amphictyonic Council in Greece had authority to fine and punish their refractory states. Lacedaemon and Phocas were both prosecuted before the Council of the Amphictyons, which was a council of the representatives of 12 nations of Greece, and all the Greek states were required by proclamation to enforce the decree. The Germanic Diet, as it has formerly existed, could put its members under the ban of the empire, by which their property was confiscated, and it was aided in enforcing obedience to its laws by a federal judiciary and an executive head. Congress was under the old Confederation, like the States General under the Dutch Confederacy, were restricted from any constructive assumption of power, however essential it might have been deemed to the complete enjoyment and exercise of that which was given. No express grant conveyed any implied power, and it is easy to perceive that a strict and rigorous adherence to the letter of the grant, without permission to give it a liberal and equitable interpretation, in furtherance of the beneficent ends of the government, must in many cases frustrate entirely the purposes of the power. A government too restricted for the due performance of its high trusts will either become insignificant or be driven to usurpation. We have examples of this in the government of the United Netherlands before it was swept away by the violence of the French Revolution. While that government moved within its constitutional limits, it was more absolutely nerveless than any other government which ever existed. The States General could neither make war or peace, or contract alliances, or raise money without the consent of every province, nor the provincial states conclude those points without the consent of every city having a voice in their assemblies. The consequence was that the federal head was frequently induced by imperious necessity to assume power unwarranted by the fundamental charter of the Union, and to dispense with the requisite unanimity. This was done in the years 1648, 1657, and 1661, as well as in another strong instance in 1668 given by Sir William Temple, and of which he was the author. The former confederation of this country was defective in not giving complete authority to Congress to interfere in contests between the several states, and to protect each state from internal violence and rebellion. In many respects, our confederation was superior to those of Germany, Holland, or Switzerland, and particularly in the absolute prohibition to the several states from any interference or concern in foreign or domestic alliances, or from the maintenance of land or naval forces in time of peace. But in the leading features which I have suggested, and in others of inferior importance, it was a most unskillful fabric, and totally incompetent to fulfill the ends for which it was erected. Almost as soon as it was ratified, the states began to fail in a prompt and faithful obedience to its laws. As danger receded, instances of neglect became more frequent, and before the peace of 1783, the inherent imbecility of the government had displayed itself with alarming rapidity. The delinquencies of one state became a pretext or apology for those of another. The idea of supplying the pecuniary exigencies of the nation from acquisitions on the states was soon found to be altogether delusive. The national engagements seem to have been entirely abandoned. Even the contributions for the ordinary expenses of the government fell almost entirely upon the two states which had the most domestic resources. Attempts were very early made by Congress, and in remonstrances the most manly and persuasive, to obtain from the several states the right of levying, for a limited time, a general impost for the exclusive purpose of providing for the discharge of the national debt. It was found impracticable to unite the states in any provision for the national safety and honor. Interfering regulations of trade and interfering claims of territory were dissolving the friendly attachments and the sense of common interest which had cemented and sustained the Union during the arduous struggles of the Revolution. Symptoms of distress and marks of humiliation were rapidly accumulating. It was with difficulty that the attention of the states could be sufficiently exerted to induce them to keep up a sufficient representation in Congress to form a quorum for business. The finances of the nation were annihilated. The whole army of the United States was reduced in 1784 to 80 persons, and the states were urged to provide some of the militia to garrison the western posts. In short, to use the language of the authors of the Federalist, each state, yielding to the voice of immediate interest or convenience, successively withdrew its support from the Confederation till the frail and tottering edifice was ready to fall upon our heads and to crush us beneath its ruins. Most of the federal constitutions in the world have degenerated or perished in the same way and by the same means. They are to be classed among the most defective political institutions which have been erected by mankind for their security. The great and incurable defect of all former federal governments, such as the Amphictyonic, the Achaean and Lycian confederacies in ancient Greece, and the Germanic, the Helvetic, and the Hanseatic and the Dutch republics in modern history, is that they were sovereignties over sovereigns and legislations, not for private individuals but for communities in their political capacity. The only coercion for disobedience was physical force, instead of the decree and the pacific arm of the civil magistrate. The inevitable consequence in every case in which a member of such a confederacy chooses to be disobedient is either a civil war or an annihilation of national authority. Convention of States in 1786. The first effort to relieve the people of this country from a state of national degradation and ruin came from Virginia, in a proposition from its legislature in January 1786 for a convention of delegates from the several states to regulate our commerce with foreign nations. The proposal was well received in many of the other states, and 5 of them sent delegates to a convention which met at Annapolis in September 1786. This small assembly, being only a partial representation of the states and being deeply sensible of the radical defects of the system of the existing federal government, thought it inexpedient to attempt a partial and probably only a temporary and delusive alleviation of our national calamities. They concurred, therefore, in a strong application to Congress for a general convention to take into consideration the situation of the United States and to devise such further provisions as should be proper to render the federal government not a mere phantom as heretofore, but a real government adequate to the exigencies of the Union. Congress perceived the wisdom and felt the patriotism of the suggestion and recommended a convention of delegates from the several states to revise, amend, and alter the Articles of Confederation. All the states except Rhode Island acceded to the proposal and appointed delegates who assembled in a General Convention at Philadelphia in May 1787. General Convention in 1787. This was a crisis most solemn and eventful in respect to our future fortune and prosperity. All the fruits of the Revolution and perhaps the final destiny of Republican government were staked on the experiment which was then to be made to reform the system of our national compact. Happily for this country, and probably as auspiciously for the general liberties of mankind, the convention combined a very rare union of the best talents, experience, information, patriotism, probity, and character which the country afforded, and it commanded that universal public confidence which such qualifications were calculated to inspire. After several months of tranquil deliberation, the convention agreed, with unprecedented unanimity, on the plan of government which now forms the Constitution of the United States. This plan was directed to be submitted to a convention of delegates to be chosen by the people at large in each state for their assent and ratification. Such a measure was laying the foundations of the fabric of our national polity, where alone they ought to be laid on the broad consent of the people. The Constitution underwent a severe scrutiny and long discussion not only in public prints and private circles, but solemnly and publicly by the many illustrious statesmen who composed these local conventions. Near a year elapsed before it received the ratification of a requisite number of conventions of delegates of the people of the states to give it a political existence. New Hampshire was the 9th state which adopted the Constitution, and thereby, according to one of its articles, it was to become the government of the states so ratifying the same. Her example was immediately followed by the powerful states of Virginia and New York, and on the 4th of March, 1789, the government was duly organized and put in operation. North Carolina and Rhode Island withheld some time longer their assent. Their scruples were, however, gradually overcome, and in June 1790 the Constitution had received the unanimous ratification of the respective conventions of the people in every state. The peaceable adoption of this government, under all the circumstances which attended it, presented the case of an effort of deliberation, combined with a spirit of amity and of mutual concession, which was without example. It must be a source of just pride and of the most grateful recollection to every American who reflects seriously on the difficulty of the experiment, the manner in which it was conducted, the felicity of its issue, and the fate of similar trials in other nations of the earth. End of section 16.
Section 17 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by DisillusionedJimson. Commentaries on American Law, Volume 1, by James Kent. Of Congress, Part 1. The power of making laws is the supreme power in a state, and the department in which it resides will naturally have such a preponderance in the political system, and act with such mighty force upon the public mind, that the line of separation between that and the other branches of the government ought to be marked very distinctly, and with the most careful precision. The Constitution of the United States has effected this purpose with great felicity of execution, and in a way well calculated to preserve the equal balance of the government, and the harmony of its operations. It has not only made a general delegation of the legislative power to one branch of the government, of the executive to another, and of the judicial to the third, but it has specially defined the general powers and duties of each of those departments. This was essential to peace and safety, in a government clothed only with specific powers for national purposes, and erected in the midst of numerous state governments retaining the exclusive control of their local concerns. It will be the object of this lecture to review the legislative department, and I shall consider this great title in our national polity under the following heads. 1. The constituent parts of Congress and the mode of their appointment. 2. Their joint and separate powers and privileges. 3. Their method of enacting laws, with the qualified negative of the President. 1. By the Constitution, all the legislative powers therein granted are vested in a Congress, consisting of a Senate and a House of Representatives. Division of Congress into two houses. The division of the legislature into two separate and independent branches is founded on such obvious principles of good policy, and is so strongly recommended by the unequivocal language of experience, that it has obtained the general approbation of the people of this country. One great object of the separation of the legislature into two houses, acting separately, and with coordinate powers, is to destroy the evil effects of sudden and strong excitement, and of precipitate measures, springing from passion, caprice, prejudice, personal influence, and party intrigue, and which have been found, by sad experience, to exercise a potent and dangerous sway in single assemblies. A hasty decision is not so likely to arrive to the solemnities of a law, when it is to be arrested in its course, and made to undergo the deliberation, and probably the jealous and critical revision, of another and rival body of men, sitting in a different place, and under better advantages to avoid the prepossessions and correct the errors of the other branch. The legislatures of Pennsylvania and Georgia consisted originally of a single house. The instability and passion which marked their proceedings were very visible at the time, and the subject of much public animadversion. And in the subsequent reform of their constitutions, the people were so sensible of this defect, and of the inconvenience they had suffered from it, that in both states a Senate was introduced. No portion of the political history of mankind is more full of instructive lessons on this subject, or contains more striking proof of the faction, instability, and misery of states, under the dominion of a single unchecked assembly, than that of the Italian republics of the Middle Ages, and which arose in great numbers, and with dazzling but transient splendor, in the interval between the fall of the Western and the Eastern Empire of the Romans. They were all alike ill-constituted, with a single unbalanced assembly. They were alike miserable, and all ended in similar disgrace. Many speculative writers and theoretical politicians, about the time of the commencement of the French Revolution, were struck with the simplicity of a legislature with a single assembly, and concluded that more than one house was useless and expensive. This led the elder President Adams to write and publish his great work, entitled A Defense of the Constitution of Government of the United States, in which he vindicates, with much learning and ability, the value and necessity of the division of the legislature into two branches, and of the distribution of the different powers of the government into distinct departments. He reviewed the history and examined the construction of all mixed and free governments which had ever existed from the earliest records of time, in order to deduce with more certainty and force his great practical truth, that single assemblies, without check or balance, or a government with all authority collected into one center, according to the notion of M. Turgot, were visionary, violent, intriguing, corrupt, and tyrannical dominations of majorities over minorities, and uniformly and rapidly terminating their career in a profligate despotism. This visionary notion of a single house of the legislature was carried into the Constitution which the French National Assembly adopted in 1791. The very nature of things, said the intemperate and crude politicians of that assembly, was adverse to every division of the legislative body, and that as a nation which was represented was one, so the representative body ought to be one also. The will of the nation was indivisible, and so ought to be the voice which pronounced it. If there were two chambers, with a veto upon the acts of the other, in some cases they would be reduced to perfect inaction. By such reasoning, the National Assembly of France, consisting of upwards of 1,000 members, after a short and tumultuous debate, almost unanimously voted to reject the proposition of an upper house. The same false and vicious principle continued for some time longer to prevail with the theorists of that country, and a single house was likewise established in the plan of government published by the French Convention in 1793. The instability and violent measures of that convention, which continued for some years to fill all Europe with astonishment and horror, tended to display, in a most forcible and affecting light, the miseries of a single unchecked body of men, clothed with all the legislative powers of the state. It is very possible that the French nation might have been hurried into the excesses of a revolution, even under a better organization of their government. But if the proposition of M. Lally Tollendal to constitute a Senate or Upper House, to be composed of members chosen for life, had prevailed, the Constitution would have had much more stability, and would probably have been much better able to preserve the nation in order and tranquillity. Their own sufferings taught the French people to listen to that oracle of wisdom, the experience of other countries and ages, and which for some years they had utterly disregarded amidst the hurry and the violence of the passions by which they were inflamed. No people, said M. Boissy d'Anglaise in 1795, can testify to the world with more truth and sincerity than Frenchmen can do, the dangers inherent by a single legislative assembly, and the point to which factions may mislead an assembly without reins or counterpoise. We accordingly find that in the next constitution in 1795, there was a division of the legislature, and a council of ancients was introduced, to give stability and moderation to the government, and this idea of two houses was never afterwards abandoned. Senate of the United States. 2. The Senate of the United States is composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator has 1 vote. If vacancies in the Senate happen by resignation, or otherwise, during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. The Senate at present consists of 52 members, representing the 26 states of the Union. In this part of the Constitution we readily perceive the features of the old Confederation. Each state has its equal voice and equal weight in the Senate, without any regard to disparity of population, wealth, or dimensions. This arrangement must have been the result of that spirit of amity and mutual concession, which was rendered indispensable by the peculiarity of our political condition. It is grounded on the idea of sovereignty in the states, and every independent community, as we have already seen, is equal by the law of nations and has a perfect right to dictate its own terms before it enters into a social compact. On the principle of consolidation of the states, this organization would have been inadmissible, for in that case, each state would have been merged in one single and entire government. At the time the Articles of Confederation were preparing, it was attempted to allow the states an influence and power in Congress in a ratio to their numbers and wealth. But the idea of separate and independent states was at that day so strongly cherished that the proposition met with no success. The election of the Senate by the state legislatures is also a recognition of their separate and independent existence, and renders them absolutely essential to the operation of the national government. There were difficulties, some years ago, as to the true construction of the Constitution in the choice of senators. They were to be chosen by the legislatures, and the legislature was to prescribe the times, places, and manner of holding elections for senators, and Congress are authorized to make and alter such regulations, except as to the place. As the legislature may prescribe the manner, it has been considered and settled, in New York, that the legislature may prescribe that they shall be chosen by joint vote or ballot of the 2 houses, in case the 2 houses cannot separately concur in a choice, and then the weight of the Senate is dissipated and lost in the more numerous vote of the Assembly. This construction has become too convenient, and has been too long settled by the recognition of senators so elected, to be now disturbed. Though I should think, if the question was a new one, that when the Constitution directed that the senators should be chosen by the legislature, it meant not the members of the legislature per capita, but the legislature in the true technical sense, being the 2 houses acting in their separate and organized capacities, with the ordinary constitutional right of negative on each other's proceedings. This was a contemporary exposition of the clause in question, and was particularly maintained in the well-known letters of the federal farmer, who surveyed the Constitution with a jealous and scrutinizing eye. The small number and long duration of the Senate were intended to render them a safeguard against the influence of those paroxysms of heat and passion, which prevail occasionally in the most enlightened communities, and enter into the deliberation of popular assemblies. In this point of view, a firm and independent Senate is justly regarded as an anchor of safety amidst the storms of political faction, and for want of such a stable body, the republics of Athens and Florence were overturned by the fury of commotions, which the senates of Sparta, Carthage, and Rome might have been able to withstand. The characteristical qualities of the Senate, in the intendment of the Constitution, are wisdom and stability. The legal presumption is that the Senate will entertain more enlarged views of public policy, will feel a higher and juster sense of national character, and a greater regard for stability in the administration of the government. These qualities, it is true, may, in most cases, be equally found in the other branch of the legislature, but the constitutional structure of the House is not equally calculated to produce them. For, as the House of Representatives comes more immediately from the people, and the members hold their seats for a much shorter time, they are presumed to partake, with a quicker sensibility, of the prevailing temper and irritable disposition of the times, and to be in much more danger of adopting measures with precipitation, and of changing them with levity. A mutable legislation is attended with a formidable train of mischiefs to the community. It weakens the force, and increases the intricacy of the laws, and hurts credit, lessens the value of property, and is an infirmity very incident to republican establishments, and has been a constant source of anxiety and concern to their most enlightened admirers. A disposition to multiply and change laws, upon the spur of the occasion, and to be making constant and restless experiments with the statute code, seems to be the natural disease of popular assemblies. In order, therefore, to counteract such a dangerous propensity, and to maintain a due portion of confidence in the government, and to ensure its safety and character at home and abroad, it is requisite that another body of men, coming likewise from the people, and equally responsible for their conduct, but resting on a more permanent basis, and constituted with stronger inducements to moderation in debate, and to tenacity of purpose, should be placed as a check upon the intemperance of the more popular department. The Senate have been, from the first formation of the government, divided into 3 classes, senators from the same state being placed in different classes, and the rotation of the classes was originally determined by lot, and the seats of one class were vacated at the expiration of the 2nd year, and 1/3 of the Senate are chosen every 2nd year. This provision was borrowed from a similar one in some of the state constitutions, of which Virginia gave the first example, and it is admirably calculated, on the one hand, to infuse into the Senate, biennially, renewed public confidence and rigor, and, on the other, to retain a large portion of experienced members, duly initiated into the general principles of national policy, and the forms and course of business in the House. The Vice President of the United States is President of the Senate, but has no vote, unless they be equally divided. It would seem to be the better opinion that he has authority, as presiding officer, virtute officii, and without any special delegation of power by the Senate, to preserve order. But from some scruples on that subject, the Senate, in 1828, established by rule that every question of the order should be decided by the President of the Senate, without debate, subject to an appeal to the Senate. The superior weight and delicacy of the trust confided to the Senate, and which will be shown more fully hereafter, is a reason why the Constitution requires not only that the senators should be chosen for 6 years, but that each senator should be 30 years of age, and 9 years a citizen of the United States, and at the time of his election an inhabitant of the state for which he is chosen. The same age was also requisite for a Roman senator, though, in their executive offices, no qualification of age was required. Ne oitas quidem distinguapatar qui in prima juventa consulatum acci dictaturas inerent. It has also been deemed fit and proper, in a country which was colonized originally from several parts of Europe, and has been disposed to adopt the most liberal policy towards the rest of mankind, that a period of citizenship sufficient to create an attachment to our government, and a knowledge of its principles, should render an emigrant eligible to office. The English policy is not quite so enlarged. No alien born can become a member of Parliament. This disability was imposed by the Act of Settlement of 12 William III, and no bill of naturalization can be received in either House of Parliament without such disabling clause in it. House of Representatives. 3. The House of Representatives is composed of members chosen every second year by the people of the several states, who are qualified electors of the most numerous branch of the legislature of the state to which they belong. The legislature of each state prescribes the times, places, and manner of holding elections for representatives, but Congress may, at any time, by law, make or alter such regulations. No person can be a representative until he hath attained the age of 25 years, and hath been 7 years a citizen of the United States, and is, at the time of his election, an inhabitant of the state in which he is chosen. The qualifications of electors of the Assembly, or most numerous branch of the legislature, in the several state governments, generally are, that they be of the age of 21 years and upwards, and free resident male citizens of the state in which they vote. And, in some of the states, they are required to possess property, and in most of them to be white as well as free citizens. The description is, almost everywhere, so large as to include all persons who are of competent discretion, and are interested in the welfare of the government, and liable to bear any of its duties or burdens. The House of Representatives may, therefore, very fairly be said to represent the whole body of the American people. Several of the state constitutions have prescribed the same or higher qualifications as to property in the elected than in the electors, and some of them have required a religious test. But the Constitution of the United States requires no evidence of property in the representatives, nor any declaration of religious belief. He is only required to be a citizen of the competent age, and free of any undue bias or dependence, by not holding any office under the United States. The term for which a representative is to serve ought not to be so short as to prevent him from obtaining a comprehensive acquaintance with the business to which he is deputed, nor so long as to make him forget the transitory nature of his seat, and his state of dependence on the approbation of his constituents. It ought also be considered as a fact deeply interesting to the character and utility of representative republics, that very frequent elections have a tendency to render the office less important than it ought to be deemed, and the people inattentive in the exercise of their rights, or else to nourish restlessness, instability, and factions. Whilst, on the other hand, long intervals between the elections are apt to make them produce too much excitement, and consequently to render the periods of their return a time of too much competition and conflict for the public tranquillity. The Constitution has certainly not deviated in this respect to the latter extreme, in the establishment of biennial elections. It has probably selected a medium, which, considering the situation and extent of our country, combines as many advantages and avoids as many inconveniences as any other term which might have been inserted. The representatives are directed to be apportioned among the states, according to numbers, which is determined by adding to the whole number of free persons, including those bound to service for a term of years, and exclusive of Indians not taxed, 3/5 of all other persons. The number of representatives cannot exceed 1 for every 30,000, but each state is entitled to have at least 1 representative. The actual enumeration or census of the inhabitants of the United States is to be made every 10 years, and the representatives newly apportioned upon the same, under a new ratio, according to the relative increase of the population of the states. The number fixed by the Constitution in the first instance, and until a census was taken, was 65 members. The apportionment under the fourth census by the Act of Congress of 7th March, 1822, was to a ratio of 1 representative for every 40,000 persons in each state, and it made the whole number of representatives amount to 213 members. Under the fifth census, completed in 1831, and which made the population of the United States amount to 12,856,000 persons, the ratio of representation was enlarged to 1 representative for every 47,700 persons, making in the whole 248 members. besides delegates from 3 of the territories belonging to the United States, and who have a right to debate but not to vote. The rule of apportionment of the representatives among the several states according to numbers has been attended with great difficulties in the application, because the relative numbers in each state do not, and never will, bear such an exact proportion to the aggregate, that a common divisor for all will leave no fraction in any state. Every decennial apportionment has raised and agitated the embarrassing question. As an absolute, exact relative equality is impossible, the principle which has ultimately prevailed is the principle of approximation, by making the apportionment among the several states according to their numbers as near as may be. This is done by allowing to every state a member for every fraction of its numbers exceeding a moiety of the ratio, and rejecting all representations of fractions less than a moiety. The rule of apportionment established by the Constitution is exposed to the objection that 3/5 of the slaves in the southern states are computed in establishing the apportionment of the representation. But this article was the result of necessity, and grew out of the fact of the existence of domestic slavery in a portion of our country. The evil has been of too long standing, and is too extensive and too deeply rooted to be speedily eradicated, or even to be discussed without great judgment and discretion. But the same rule which apportions the representatives extends to direct taxes, and the slaves in the southern states, while they give those states an increased number of representatives, contribute, on the other hand, when that mode of taxation is resorted to, equally to increase the measure of their contributions. The number of the House of Representatives would seem to be quite large enough, on its present computation, and unless the ratio be hereafter enlarged from time to time, as the exigency may require, the House will be in danger of increasing too rapidly, and it will probably become, in time, much too unwieldy a body for convenience of debate and joint consultation. A due acquaintance with the local interests of every part of the Union ought to be carried into the House, and a sufficient number collected, for all the purposes of information, discussion, and diffusive sympathy with the wants and wishes of the people. When these objects are obtained, any further increase neither promotes deliberation, nor increases public safety. All numerous bodies of men, although selected with the greatest care, are too much swayed by passion, and too impatient of protracted deliberation. The United States, in their improvements upon the exercise of the right of representation, may certainly claim preeminence over all other governments, ancient and modern. Our elections are held at stated seasons, established by law. The people generally vote by ballot in small districts, and public officers preside over the elections, receive the votes, and maintain order and fairness. Though the competition between candidates is active, and the zeal of rival parties sufficiently excited, the elections are everywhere conducted with tranquillity. The legislature of each state prescribes the times, places, and manner of holding elections, subject, however, to the interference and control of Congress, which is permitted them for the sake of their own preservation, and which, it is to be presumed, they will never be disposed to exercise, except when any state shall neglect or refuse to make adequate provision for the purpose. The privilege of voting, as we have already seen, is conferred upon all persons who are of sufficient competency by their age, and of sufficient ability to take care of themselves. The ancient Greeks and Romans had not only very imperfect notions of the value of representation, but the number and power of their popular assemblies were so great, and they were so liable to disorder, as to render it a very provident measure with them, to be guarded in diffusing the privileges of free citizens. Not a 10th part of the people of Athens were admitted to the privilege of voting in the assemblies of the people, and, indeed, 9/10 of the inhabitants throughout all Greece were slaves. In Sparta, the number of votes was fixed at 10,000. In Rome, this privilege was for many ages confined to the pomeria of the city, and it continued to be so confined, and to be tolerable in its operations, until the memorable social war extended it to all the inhabitants of Italy, south of the Rubicon and the Arnis. As no test of property or character was required, and as the people assembled within the walls of Rome in immense masses, and not merely to vote, but to make laws, This great innovation produced the utmost anarchy and corruption, and has justly been regarded as precipitating the fall of that commonwealth. The English nation, in common with the other feudal governments of Europe, anciently enjoyed the blessings of popular representation, and the knights, citizens, and burgesses were intended to represent the farmers, merchants, and manufacturers, being the several orders and classes of people of which the nation was composed. But the mutations of time and commerce, in depopulating ancient boroughs, and in establishing new cities and great manufacturing establishments, without any direct parliamentary representation, insensibly changed the structure of the House of Commons, and rendered it, in theory at least, a very inadequate and imperfect organ of the will of the nation. Archdeacon Paley observed, many years ago, that about one half of the commons were elected by the people, and the other half came in by purchase, or by the nomination of single proprietors of great estates. So extremely unequal was the popular vote at elections in England, that less than 7,000 voters returned nearly one half of the House of Commons. But notwithstanding the great imperfection of the constitution of the English House of Commons, if it were to be tested by the arithmetical accuracy of our own political standards, nevertheless, in all periods of English history, it felt strongly the vigor of the popular principle. While on the continent of Europe the degeneracy of the feudal system, the influence of papal hierarchy, the political maxims of the imperial or civil law, and the force of standing armies, extinguished the bold and irregular freedom of the Gothic governments, and abolished the representation of the people, the English House of Commons continued to be the asylum of European liberty, and it maintained its station against all the violence of the Plantagenet line of princes, the haughty race of the Tudors, and the unceasing spirit of despotism in the House of Stuart. And when we take into consideration the admirable plan of their judicial polity, and those two distinguished guardians of civil liberty, trial by jury, and the freedom of the press, it is no longer a matter of astonishment that the nation, in full possession of those inestimable blessings, should enjoy greater security of person and property than ever was enjoyed in Athens or Sparta, Carthage or Rome, or in any of the commonwealths of Italy during the period of the Middle Ages. I proceed next to consider the privileges and powers of the two houses of Congress, both aggregately and separately. End of section 17.
Section 18 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by ShrimpPhish. Commentaries on American Law, Volume 1, by James Kent. Of Congress, Part 2. Privileges of the two houses of Congress. Each house is made the sole judge of the election return and qualifications of its members. The same power is vested in the British House of Commons and in the legislatures of the several states, and there is no other body known to the Constitution to which such a power might safely be trusted. It is requisite to preserve a pure and genuine representation, and to control the evils of irregular, corrupt, and tumultuous elections. And as each house acts in these cases in a judicial character, its decisions, like the decisions of any other court of justice, ought to be regulated by known principles of law and strictly adhered to, for the sake of uniformity and certainty. A majority of each house constitutes a quorum to do business, but a smaller number may adjourn from day to day, and may be authorized to compel the attendance of absent members in such manner, and under such penalties as each house may provide. Each house likewise determines the rules of its proceedings, and can punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. Each house is likewise bound to keep a journal of its proceedings, and from time to time publish such parts as do not require secrecy, and to enter the yeas and nays on the journal, on any question, when desired by 1/5 of the members present. The members of both houses are likewise privileged from arrest during their attendance on Congress, and in going to and returning from the same, except in cases of treason, felony, and breach of the peace. These privileges of the two houses are obviously necessary for their preservation and character. And what is still more important to the freedom of deliberation, no member can be questioned out of the House for any speech or debate therein. There is no power expressly given to either House of Congress to punish for contempts, except when committed by their own members, but in the case of Anderson, who is committed by order of the House of Representatives for a contempt of the House, and taken into custody by the Sergeant-at-Arms, an action of trespass was wrought against the officer, and the question on the power of the House to commit for a contempt was carried by writ of error to the Supreme Court of the United States. The court decided that the House had that power, and that it was an implied power, and of vital importance to the safety, character, and dignity of the House. The necessity of its existence and exercise was founded on the principle of self-preservation, and the power to punish extends no further than imprisonment, and that will continue no longer than the duration of the power that imprisons. The imprisonment will terminate with the adjournment or dissolution of Congress. The House of Representatives has the exclusive right of originating all bills for raising revenue, and this is the only privilege that House enjoys in its legislative character, which is not shared equally by the other, and even those bills are amendable by the Senate in its discretion. The two Houses are an entire and perfect check upon each other in all business appertaining to legislation, and one of them cannot even adjourn during the session of Congress for more than 3 days without the consent of the other, nor to any other place than that in which the two Houses shall be sitting. Powers of Congress. The powers of Congress extend generally to all subjects of a national nature. Many of those powers will hereafter become the subject of particular observation and criticism. At present, it will be sufficient to observe, generally, that Congress are authorized to provide for the common defense and general welfare, and for that purpose, among other express grants, they are authorized to lay and collect taxes, duties, imposts, and excises, to borrow money on the credit of the United States, to regulate commerce with foreign nations, and among the several states, and with the Indian tribes, to declare war, and define and punish offences against the law of nations, to rise, maintain, and govern armies, and a navy, to organize, arm, and discipline the militia, and to give full efficacy to all the powers contained in the Constitution. Some of these powers, as the levying of taxes, duties, and excises, are concurrent with similar powers in the several states, but in most cases these powers are exclusive, because the concurrent exercise of them by the states separately would disturb the general harmony and peace, and because they would be apt to be repugnant to each other in practice, and lead to dangerous collisions. The powers which are conferred upon Congress, and the prohibitions which are imposed upon the states, would seem, upon a fair and just construction of them, to be indispensable to secure to this country the inestimable blessings of union. The Articles of Confederation, digested during the American War, intended to confer upon Congress powers nearly equal to those with which they are now invested, but that compact gave them none of the means requisite to carry those powers into effect. And if the sentiment, which has uniformly pervaded the minds of the people of this country, be a just one, that the consolidated union of these states is indispensable to our national prosperity and happiness, and if we do not wish to be once more guilty of the great absurdity of proposing an end, and denying the means to attain it, then we must conclude that the powers conferred upon Congress are not disproportionate to the magnitude of the trust confided to the Union, and which the Union alone is competent to fulfill. Rules of Proceeding. The rules of proceeding in each house are substantially the same, and though they are essential to the transaction of business with order and safety, they are too minute to be treated at length in an elementary survey of the constitutional polity and general jurisprudence of the United States. The House of Representatives choose their own speaker, but the Vice President of the United States is ex officio President of the Senate, and gives the casting vote when they are equally divided. The proceedings and discussions in the two houses are public. This affords the community early and authentic information of the progress, reason, and policy of measures pending before Congress, and is likewise a powerful stimulus to industry, to research, and to the cultivation of talent and eloquence and debate. Though these advantages may be acquired at the expense of much useless and protracted discussion, yet the balance of utility is greatly in favor of open deliberation, and it is certain, from the general opposition to the experiment that was made and continued for some years by the Senate of the United States, of sitting with closed doors, that such a practice, by any legislative body in this country, would not be endured. The ordinary mode of passing laws is briefly as follows. 1 day's notice of a motion for leave to bring in a bill, in cases of a general nature, is required. Every bill must have 3 readings previous to its being passed, and these readings must be on different days, and no bill can be committed or amended until it has been twice read. Such little checks in the forms of doing business are prudently intended to guard against surprise or imposition. In the House of Representatives, bills, after being twice read, are committed to a committee of the whole House, when the Speaker leaves the chair and takes a part in the debate as an ordinary member, and a chairman is appointed to preside in his stead. When a bill has passed one House, it is transmitted to the other, and goes through a similar form, though, in the Senate, there is less formality, and bills are often committed to a select committee, chosen by ballot. If a bill be altered or amended in the House to which it was transmitted, it is then returned to the House in which it originated, and if the two Houses cannot agree, they appoint committees to confer together on the subject. When a bill is engrossed and has passed the sanction of both Houses, it is transmitted to the President of the United States for his approbation. If he approves of the bill, he signs it. President's negative. If he does not, it is returned with his objections to the House in which it originated, and that House enters the objections at large on their journals, and proceeds to reconsider the bill. If, after such reconsideration, 2/3 of that House should agree to pass the bill, it is sent, together with the objections, to the other House, by which it is likewise reconsidered, and, if approved by 2/3 of that House, it becomes a law. But in all such cases, the votes of both Houses are determined by yeas and nays, and the names of the persons voting for and against the bill are entered on the journals. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same becomes a law, equally as if he had signed it, unless Congress, by adjournment, in the meantime, prevents its return, and then it does not become a law. The practice in Congress, and especially in the second or last session of each Congress, of retaining most of their bills until within the last 10 days, is attended with the disadvantage of shortening the time allowed to the President for perusal and reflection upon them, and of placing within the power of the President the absolute negative of every bill presented within the last 10 days preceding the 4th of March, and this he can effect merely by retaining them without being obliged to assign any reason whatever, for he is entitled to 10 days to deliberate. Most of the bills that are presented to the President in the second session of every Congress were, a few years ago, presented to him within the last 10 days, and generally within the last 2 days. But the rules of Congress have latterly checked the evils and danger of such an accumulation of business on the last days of the session. This qualified negative of the President upon the formation of laws is, theoretically at least, some additional security against the passage of improper laws, though prejudice or want of due reflection. But it was principally intended to give to the President a constitutional weapon to defend the executive department, as well as the just balance of the Constitution, against the usurpations of the legislative power. To enact laws is a transcendent power, and if the body that possesses it be a full and equal representation of the people, there is danger of its pressing with destructive weight upon all the other parts of the machinery of the government. It has, therefore, been thought necessary by the most skilful and most experienced artists in the science of civil polity that strong barriers should be erected for the protection and security of the other necessary powers of the government. Nothing has been deemed more fit and expedient for the purpose than the provision that the head of the executive department should be so constituted as to secure a requisite share of independence, and that he should have a negative upon the passing of laws, and that the judiciary power, resting on a still more permanent basis, should have the right of determining upon the validity of laws by the standard of the Constitution. A qualified negative answers all the salutary purposes of an absolute one, for it is not to be presumed that 2/3 of both houses of Congress, on reconsideration, with the reasoning of the President in opposition to the bill spread at large upon their journals, will ever concur in any unconstitutional measure. In the English Constitution the King has an absolute negative, but it has not been necessary to exercise it since the time of William III. The influence of the Crown has been exerted in a more gentle manner, to destroy any obnoxious measure in its progress through the 2 houses of Parliament. Charles I stood for a long time upon the strict and forbidding rights of his prerogative, but he was compelled, by the spirit and clamour of the nation, to give his assent to bills which cut down that prerogative, and placed the power of government in the hands of the Parliament. The peremptory veto of the Roman tribunes, who were placed at the door of the Senate, would not be reconcilable with the spirit of deliberation and independence which distinguishes the councils of modern times. The French Constitution of 1791, a laboured and costly fabric, on which the philosophers and statesmen of France exhausted all their ingenuity, and which was prostrated in the dust in the course of 1 year from its existence, gave to the King a negative upon the acts of the legislature, with some very feeble limitations. Every bill was to be presented to the King, who might refuse his assent, but if the 2 following legislatures should successively present the same bill in the same terms, it was then to become a law. The constitutional negative given to the President of the United States appears to be more widely digested than any of the examples which have been mentioned. End of section 18.